Good morning, everyone. We are now on the record and video streaming. I'm calling this evidentiary hearing to order. My name is Andrew French. I'm chair of the Kansas Corporation Commission. I'm serving as presiding officer for this hearing, and I'm joined by my fellow commissioners, Dwight Keene and Annie Keither. This is the hearing for dockets 23 CONS 3017 CPEN, 23 CONS 3029 CPEN, 23 CONS 3087 CPEN, and 23 CONS 3135, captioned in the matter of resolving various regulatory violations associated with Ace Energy LLC, as well as docket number 23 CONS 3143 CMSC, captioned in the matter of the application of Ace Energy LLC for an operator's license renewal. We will begin today's hearing with the entries of appearance, and I will start with commission staff.
Thank you. Tristan Kimbrell on behalf of commission staff and the public generally.
Thank you. Good morning, Tristan. And for operator.
John Slatter and Jackson Ely on behalf of Ace Energy, the operator in this matter. Mr. Frieden is also present, the sole owner and member of Ace Energy. Also, just an FYI, I just heard the fire alarm going off, which means they might be testing them. That usually ends after about 15 minutes, but it gets really, really loud. I hope that's not the case, but we'll see.
Well, why don't you just keep us posted? And good morning, Mr. Slatter. Good to see you again. If you have an issue and you want to go off the record or take a recess for 10 minutes, that's understandable, and we can work with you.
Not too loud yet, so we'll see how it goes. I don't know if you heard that just a second ago.
Or at least I cannot hear it. So
Okay,
if it's something you can work through, then go ahead. And if it becomes a distraction, we'll let you know. And if it's too much of a distraction for you, like I said, I think we'd be very happy to give you a recess.
I've got little kids. It's not going to be a distraction.
I get that. All right. Sounds good. Well, we have our entries of appearance. Let's now move to notice of this hearing. Does staff have any recommendation regarding notice of the hearing?
Yes, notice of this hearing was contained in the presiding officer order setting evidentiary hearing filed on October 9th, 2023. The order was properly served on all parties. Staff further notes that all parties are in attendance today. Based on these facts, staff recommends the commission find that notice is proper and that the commission has jurisdiction to hear this matter at this place and time.
To notice of today's hearing. Hearing none, and based on staff's recommendation, I will find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. I'm going to now move to a few preliminary matters, and then I'll discuss the procedure of the hearing. Before I move and ask if the parties have any preliminary matters, I'm just going to run through some of our perfunctory items that we always go through. Because we are conducting this over Zoom, we understand that things can go wrong, and sometimes people have fire alarms going off or other items. But if any party does encounter a technical issue, please just ask us to go off the record. We can recess, and then we can resolve the technical issue before going back on the record. Second, witnesses are asked to keep their microphones off or muted when they're not scheduled to talk. And if everyone would also please mute their cell phones, phones in their offices, other electronic devices, that would be appreciated. Third, so the parties are aware, if the commission does need to consult among ourselves for something like an evidentiary ruling, we'll go off the record. Commission will enter what we call a Zoom breakout room to discuss that, and then we'll return and go back on the record. Fourth, since we're doing this by Zoom, please be very careful to identify exactly what documents you're referring to when you're discussing pre-filed testimony or exhibits. I believe we all have either paper copies or PDF versions of the documents that have been circulated. But if everybody can be very specific in what they're identifying, it will help us either bring it up on the screen or identify it on our own screens. So with those sort of procedural items noted, do the parties have other preliminary matters that they would like the commission to take up at this time?
Chair French, will you be ruling on the operator's motion to strike in the motion limit? Okay, then that's all that staff was concerned about.
Is with staff like a ruling on their motion for summary judgment?
Yes, that would be great.
Okay. Do you want Well, let's start with that. That's a little bit foundational. I probably am going to deny that. I did look it over pretty carefully. I read the response. I would agree that there is certain evidence that, at least in the pre-filed testimony, the operator may not offer much contrary evidence, but I think staff's motion is dependent to some degree on evidentiary rulings and the ultimate weight and credibility that the commission would assign to its testimony, which I believe is the purpose of this hearing. And so for that reason, the commission is going to deny the motion for summary judgment. We can now move to the motions to strike and the motions in limine. Mr. Schlatter, if you want, you can present those one at a time, or you can present them together, however you'd like.
Sure. The motion in limine is pretty straightforward, and I'm going to call that out. I'm not going to read you the motion that we filed. We filed it in advance of the hearing to avoid that. But effectively, we have two categories of evidence that are being offered. I'm not even sure if it would qualify as circumstantial evidence, but there's evidence that Mr. Frieden is somehow a member or owner of SX54. At least that's being alleged. There has been no evidence produced that could possibly lead to that finding. We have essentially the fact that he serves as a resident agent for an entity with out-of-state members is not evidence of ownership. It's just evidence of that company complying with the law and maintaining a resident agent in this state. All of their members are out of state, and so they found someone in state. Likewise, him filling out forms in COLAR is not evidence of ownership or being a member of that entity. It's just evidence that they hired him to do COLAR. Lots of companies do that. And finally, there was an allegation that his wife is, and maybe she was the resident agent, I might be conflating the two, and that it was, Mr. Frieden was accused of being or is the emergency contact for the operator in Kansas, which, just like the resident agent, I would hope that somebody that lives in Houston would want their emergency contact to be in the proximity of its leases. And so Mr. Frieden took that on just like he took on their COLAR. None of those are any evidence of ownership or membership. No evidence has been forthcoming. I think we can substantially improve the speed of this hearing by disregarding that evidence. And then there's a prior civil litigation matter that's been put into the record in the pleadings that has the probative value is so outweighed by the prejudice. Let me say, I said that backwards. The prejudice is so outweighed by the probative value of that, and it's just abject, improper character witness and should be left out of these proceedings. It does nothing other than prejudice client. It doesn't go in any way, shape, or form to whether or not he should have a license in Kansas. It doesn't meet any of the statutory criteria, and it certainly doesn't go to any of the penalty orders that are the subject of this docket. So I'd ask that that be kept out as well.
So that's the motion in limine. Does staff have any response before I rule on it?
Yes. As far as SX54 goes, Mr. Frieden listed himself as a member of XX54 and filed transfer forms on behalf of XX54 to Ace Energy. The commission should be able to see that evidence and weigh it. I believe that evidence should be admitted. As for the previous proceeding, Mr. Frieden was found to have committed fraud. That's admissible as it goes to the credibility of Mr. Frieden.
We are going to deny the motion in limine. There's probably a little too much weight given to the rules of civil procedure. In this case, the commission does have the ability to flex those a bit. I would note there is a guardrail, though, and that's the Kansas Judicial Review Act. Any order we issue must be based on substantial competent evidence, must be consistent with Kansas law. Operator will have an opportunity to see what evidence we have relied on in making our decision. I think it's fair for this evidence to be presented. The commission has counsel. We will consult with counsel to understand what weight and evidence we can rely on and weight we should give that evidence. So, I don't think it's quite the same as a jury trial by any means, where you're going to get a simple up or down. you're going to see what the commission relied on. And we aren't necessarily lay people. We have the ability to judge the credibility and the admissibility of evidence. So for those reasons, we'll deny the motion in limine. If you want to move to the motion to strike.
Yes, sir. On the motion to strike, again, these are evidentiary issues. Now, maybe the commission does have freedom to relax the rules of civil procedure. It does not have freedom to relax the rules of evidence by its own regulations. The motion to strike lays out each and every applicable rule of evidence at issue and applies it to testimony in the record. We can take this up at the time that testimony is proffered. That may be more efficient, or we can, I could rest on the brief itself.
Does staff have any response?
I would just point out that under KSA 77524A, the presiding officer need not be bound by the technical rules of evidence, and under the commission's own regulations, those rules can be relaxed. Staff would ask that the motion to strike be denied.
Yeah, I'm prepared to rule. So we're gonna deny the motion to strike in full. I was actually going to make the same point, which is that statutes and regulations do allow the commission to relax the rules of evidence. This isn't a CAPA proceeding, but the Administrative Procedures Act even expressly allows hearsay to be considered. But again, I would reiterate all the same points I made for the motion in limine. The commission is bound by the Kansas Judicial Review Act. We must only base our decisions on substantial competent evidence. So we have full ability to take all of the evidence, weigh the credibility, and explain, in non-arbitrary facts why the evidence we're relying on is substantial. An operator will have the opportunity, and staff will have the opportunity to view that decision. So for those reasons, we will deny the motion to strike as well. Are there any other preliminary matters to come before us this morning? All right. I haven't had the presiding officer or the pre-hearing officer had not listed any more for me. So if I don't hear anything else, we will go ahead and move to the procedure for the hearing. In regard to the procedure for the hearing, parties are typically allowed to make opening statements. After opening statements, we will have examination of the witnesses. And after direct examination of each witness, there will be an opportunity for cross-examination. And then there will be an opportunity for commissioner questions. We will allow redirect. Any further cross or redirect, we will just make a decision at the time as to whether that's expeditious and productive. Following witness examinations, we will allow the parties to make closing statements if they so choose, and we'll arrange for the filing of post-hearing briefs if the parties choose, and then we will conclude the hearing. So, as I mentioned, we will start with opening statements, and we will begin with staff, Mr. Kimbrell.
Thank you. Commissioners, at first glance, this docket appears to be a massive hodgepodge of orders and motions. And as I was trying to wrap my brain around this docket, a quote kept popping into my head: "Take away the cause and the effect ceases." And I think that is actually the perfect way to understand this docket. There are 4 penalty orders in this docket, and the penalties are for some fairly egregious violations of commission regulations, but they're only the effects. The cause is Ace Energy. And that's why their license review is such an important part of this docket. Sometimes effects have a way of boomeranging and impacting their cause, and that's what's happened here. The effects have finally caught up to Ace Energy, and staff will show in this hearing that by law, Ace Energy's license cannot be renewed. So let me briefly discuss the 4 penalty orders in this docket. The first is 23-30-17. Staff intends to show that Ace Energy's license was suspended from June 21st, 2022 to July 20th, 2022. Staff took pictures on July 8th, 2022, showing 2 of Ace Energy's wells in operation. Ace Energy was operating its wells under suspended license, and staff has the photos. Now, Ace Energy may try to argue that it was its best to get its license unsuspended, or that staff was slow in dealing with paperwork, which staff will show wasn't the case. But Ace Energy's arguments are irrelevant. Ace Energy's license was suspended, and yet it continued to operate its wells under that suspended license. The second penalty order is 23-30-29. Staff will show that 2 of Ace Energy's wells had failed mechanical integrity tests, and by commission regulation, Ace had 90 days to perform successful MITs on the wells or plug the wells. Instead of meeting that deadline, Ace Energy waited until after the deadline had passed to plug the wells. Ace Energy may try to argue that it plugged the wells only a couple of days after the deadline, but again, that's irrelevant. Commission regulation set a deadline for Ace Energy to bring those wells into compliance, and Ace Energy missed the deadline. The third penalty order is 23-3087. Staff will show that Ace Energy began injection operations at 5 wells. Staff took pictures of all 5 wells hooked up to injection lines with the valves to each of those lines in the open position. 2 of the lines were even cool to the touch, indicating water was actively flowing through them. Now, Ace Energy may argue that it never put any water down those wells. Staff will show, however, that Ace Energy went to the trouble of hooking up 5 wells for injection, opened all the valves, and then didn't bother to apply for injection permits for any of the wells. So the commission can draw its own conclusions. The fourth penalty order is 23-3135. Staff will show that Ace Energy either filed an inaccurate form with the commission or injected fluid into a well under pressure greater than allowed by permits. Ace Energy will likely argue that staff can't show which one is true, that the form was inaccurate or the injection was unauthorized. Therefore, neither violation should be upheld as valid. Jonathan Frieden, in his pre-filed testimony, though, admitted that he filed an inaccurate version of the form. He also admitted in his testimony that when he received a letter from staff asking him to correct the form, he didn't do it. Staff will show that Ace Energy admitted to violating a commission regulation, and therefore the commission should uphold the penalty order. So finally, we come to the cause of all these effects. We come to the question of whether the commission should allow Ace Energy to renew its license. Staff would ask that the commission keep Kansas law in mind when considering this question. KSA 55-155C4 says that, quote, no application or renewal application shall be approved until the applicant has demonstrated to the commission's satisfaction that the applicant complies with all requirements of Chapter 55, the Kansas Statutes Annotated, and all rules and regulations of the commission. It's the applicant's duty to demonstrate to the commission's satisfaction that is in compliance with all commission regulations. By law, Ace Energy must be the one to demonstrate that it is in compliance with all regulations. Simply put, commissioners, Ace Energy can't do that. Ace Energy's license is currently suspended in docket 22-3124 and docket 23-3326. Additionally, staff conducted inspections of all of Ace Energy's leases to provide the commission with information on every single well operated by Ace Energy. Of Ace Energy's roughly 400 wells, staff found approximately 300 out of compliance with commission regulations. Now, Ace Energy will likely argue that when it submitted its license renewal application on November 28th, 2022, its license wasn't suspended and staff hadn't informed it yet that 300 of its wells were out of compliance. Consequently, the commission must consider Ace Energy's license application only as it stood on November 28th, 2022, and not consider anything that occurred after that date. But that's not what the law says. Ace Energy has to demonstrate it is in compliance with all commission regulations. Ace Energy can't demonstrate that it's in compliance with all commission regulations because its license is currently suspended. Ace Energy can't demonstrate that it is in compliance with all commission regulations because staff found 300 of its wells out of compliance with commission regulations. Commissioners, if you take away the cause, the effect ceases. Staff asks that you uphold the 4 penalty orders in this docket. Staff also asks that you find that Ace Energy has not demonstrated that it is in compliance with all commission regulations. And ultimately, staff asks that you deny Ace Energy's license renewal application. Thank you.
Thank you, Mr. Kimball. Mr. Schlatter.
Thank you, French. Commissioners. I think Mr. Kimball's done a fine job of demonstrating the pitfalls in staff's particular case, notably each and every weakness in the penalty orders it cited. And we'll get into those during the evidentiary hearing, but every single one of those penalty orders, there's something wrong with. There seemed to be a tone there that maybe the burden of proof was on Ace Energy, that it has to prove compliance in order to prevail in this docket. That's backwards. Staff has the burden of proof here to prove that these violations existed. these violations are the alleged source of Ace Energy's non-compliance. If they can't prove Ace Energy is non-compliant, what else is there to prove? And so, to be clear, Ace Energy does not have the burden of proof in this docket. That is squarely on staff's shoulders, and I don't think that should be in dispute, and I want to make clear it's not in dispute. As far as this issue of violations occurring well after the license renewal application occurred, I think there's a reason why licenses are renewed annually, and the demonstration of compliance is done on an annual basis. And that's not because this application is a living, breathing creature. It's filed by a deadline date and should be approved by a deadline date. There should be no post facto investigations to retroactively suspend a license. That's improper. That defeats the obvious purpose of the statute. But at issue today is operator's application to renew its license that was filed on November 28th of 2022. Now, my motion dated November 30, 2022, staff opposed operator's license renewal application. KSA 55155 is the statute that governs the renewal of operator's license. That is the only statute that is issued today with respect to operator's license. There are other subparts, but particularly in subpart 4 that's at issue today. Staff offers two bases for why operator's license should not be renewed under that statute: that it cannot demonstrate to the commission's satisfaction that it complies with commission rules and regulations, and that operator is somehow related to SX54 LLC, which is a defunct operating entity with wells on the plugging list, that operator somehow related this entity through the combination rules set forth in 55-155C4D. Now, those combination rules can only impute SX54's non-compliance with commission regulations upon Ace Energy if any spouse, parent, brother, child, sister, parent-in-law, brother-in-law, or sister-in-law of any member or owner of Ace happen to be an officer or director or partner of SX54. The evidence will not only show that staff's allegations are unsupported and unfounded, but that staff had no colorable basis to make these allegations when it filed its motion to deny operators license on November 30, 2022. Staff's own testimony demonstrates that operator was indeed in compliance with commission regulations at the time it filed its application. This includes all the wells subject to each and every penalty order that is the subject of this consolidated docket. Staff has produced absolutely no evidence, because none has ever existed, that Jonathan Frieden or his wife Rebecca Dragon Frieden are or ever fell within the combination rules of KSA 155C4D as to SX54. It cannot be ignored and should not be ignored that staff never possessed anything resembling credible evidence on this issue, and that has never been a legitimate basis to oppose Ace Energy's license renewal application. As aptly demonstrated by the 800+ pages of pre-filed testimony exhibits submitted by staff in this docket, the motion to deny operator's license renewal application was a pretext to engage in a fishing expedition in search of a basis to support its motion to deny Ace Energy's license renewal application. This fishing expedition came at an extraordinary cost to operator. It had no colorable basis to file its motion in the first place, and it was forced to search out violations after the fact. This type of conduct should not be tolerated by the commission. Now, docket 233143 is the license renewal docket, and that was the last of the dockets opened among those before the commission today. It is noteworthy that the pre-hearing conference in that docket was noticed up on December 20th, 2022. Under CAPA, specifically 77-511, the present hearing commenced at that time. The commission has consistently found and ordered that to be the case in numerous other dockets, specifically the dockets on orders granting summary proceedings and the compulsory unitization dockets. On that date, the record should have been closed as to the nature and scope of staff's allegations against operator in all dockets, both under CAPA and as a matter of due process. Accordingly, the commission should not, in a matter of law, and as a matter of law, cannot consider matters after that date. The overwhelming majority of evidence offered by staff cites inspections conducted after its November 30 motion, after the hearing commenced on December 20th, 2022, and even after the pre-hearing conference was conducted on January 5th. This demonstrates that staff had no basis to file its motion to deny application in the first place and sought to engage in a belated attempt to support its improper motion. Again, this conduct has come at great expense and time to operator. It cannot be ignored or denied that operator did not learn of the wild scope and breadth of compliance issues it would be accused of until July 7th, 2023, when staff pre-filed 600 pages of testimony exhibit, largely unrelated to matters set forth in the docket before the commission today. As a matter of law, those matters were not properly noticed, are not properly before the commission, cannot be offered into evidence at this hearing, nor can they form a factual basis for any ruling that might be made adverse to operator. To be clear, there are 4 penalty orders properly before the commission today. These penalty orders involved compliance issues at 9 wells. 9 wells, not 409. To be even more clear, staff's own testimony establishes that all 9 of these wells have been brought into compliance prior to the filing of operator's license renewal application and prior to the filing of staff's motion to deny application. The evidence will also show that staff has fallen short of its burden of proof on the violations contained in those penalty orders. The evidence will even show that staff caused the violation at issue in docket 23-3017 to occur by refusing to take action on a T application for weeks until after the deadline had passed for the sole purpose of prejudicing operator and punishing it with a $10,000 fine. This is not the first time staff has engaged in this type of conduct as it pertains to operator. This not only undermines staff case on this docket, it demonstrates the hostile animus and bias operator rightly complains of. As to the hundreds of matters not before the commission, staff has not come close to satisfying its burden of proof of these matters and merely offers inadmissible hearsay in support. This evidence demonstrates nothing more than staff's crusade against operator and its livelihood, one which I hope no other operator should ever have to endure. The animus and prejudice operator complains of is real, as can be garnered by the sheer resources staff put into its case to ruin operator, which undoubtedly amounts to thousands of hours of staff time and thousands upon $1,000 of commission resources. The reason the proceedings in this docket are so out of control is that staff has conducted this matter in reverse order. Rather than investigate a compliance issue and seek a penalty order, staff sought to obstruct operator's license renewal application, then conduct an investigation to find out why. As previously explained, CAPA forbids this approach, and courts have found it to be a violation of fundamental due process rights. Staff's newfound trial by surprise approach to these hearings results in completely backwards proceedings where discovery is conducted after pre-filed testimony is submitted. Essentially, operator cannot learn of what is being accused of until after staff puts on its case in chief. The purpose of pre-filing testimony is to streamline the scope of testimony and evidence presented at the hearing, so the live portion can be truncated and efficient. Staff's approach results in the opposite outcome where the scope is limited to staff's imagination only and operator is left scrambling to defend itself. This necessarily causes the pre-hearing and hearing process to spiral out of control at enormous time and expense to operator, which constitutes economic waste. I would implore the commission to take the reins going forward and require the staff have its case prepared before it pursues a penalty order. This would result in more orderly and truncated hearings that don't violate CAPA and do not violate due process rights, and likewise would prevent any future operator from having to endure the unnecessary hardship ACE Energy has endured over the last 12 months. It would also force a return of staff working with operators to resolve compliance issues rather than litigating every technical violation before the commission. That type of relationship breeds a hostile relationship devoid of trust, which is counterproductive to the administration of the commission's regulations. For these reasons, I think the commission should reject staff's motion to deny application, rescind the penalty orders, and order such further relief to operator as it deems proper.
All right, thank you, Mr. Schlatter. I think we are ready to proceed with the examination of witnesses. We're going to have staff's witnesses first. Mr. Kimbrell, you may call your first witness.
Thank you. Staff calls Ryan Dueling.
Good morning, Mr. Dueling.
Good morning, Chair French.
All right, we do not have a court reporter present. We're recording this proceeding, but that means I am going to need to swear you in. So if you will, please raise your right hand. Do you swear or affirm that the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. The witness is yours, Mr. Kimbrell.
Thank you. Mr. Dueling, please state your full name for the record.
Ryan Dueling.
By whom are you employed?
I am employed by the Conservation Division of the Kansas Corporation Commission at the District 3 Field Office.
And what is your work address?
137 East 21st Street in Chanute, Kansas, 66720.
What is your work title?
I am an environmental compliance regulatory specialist and also the District 3 compliance officer.
Are you a member of the technical staff?
Yes.
Are you the same Ryan Dueling who caused to be filed in this docket direct testimony consisting of 14 pages and 8 exhibits, as well as rebuttal testimony consisting of 8 pages?
Yes.
Was this testimony created by you or at your direction?
Yes.
As compliance officer, what role did you play in the creation of the field reports included in your direct testimony as Exhibit RD1?
The field staff investigated leases and compiled the data composed to the field reports. I worked with staff while they were composing the field reports and reviewed the field reports before they were submitted to our supervisor for a field report number. Once the field report number was attached to the field report, then I reviewed the field reports again and documented any violations that staff had found during lease inspections.
Thank you. Were the field reports in Exhibit RD1 created in the regular course of KCC business?
I'm going to offer an objection at this point. This is just a belated attempt to create the foundation that should have been created in the pre-filed testimony. It's too late for this.
I'm trying to get this admitted into the record now. Therefore, I should be allowed to do my foundation at this point.
So here's how I'm going to rule. I do agree. Typically, I'm very disinclined to allow additional direct testimony. However, in this case, I'm going to overrule the objection because operator has raised the issue of foundation for some of this evidence to be part of Mr. Dueling's testimony and why it was included with his testimony. And I think it would be very helpful for the commission to understand why Mr. Dueling has the foundation to be including some of this testimony within his, or some of this the exhibits within his testimony. And so I'm going to allow it on that basis that the issue was raised, and I think it would be helpful for the commission to understand the business process. So go ahead, Mr. Kimbrell.
Thank you. Were the field reports in Exhibit RD1 created at about the same time that the field inspections were conducted?
Yes.
Were the field reports in Exhibit RD1 created in a manner different than how other District Number 3 field reports are created?
No.
Are the field reports in Exhibit RD1 commission records?
Yes.
Are you the individual in District Number 3 responsible for maintaining control of District Number 3 field reports in the ordinary course of business?
These are leading questions.
I'm trying to lay a foundation, and I don't think that this is a leading question.
It's a yes or no question. It's a leading question. It's a series of leading questions. They're all improper.
I don't believe I've heard a leading question yet, so I'm going to overrule.
Thank you. Mr. Dueling, do you remember the question that I asked?
Would you please repeat it?
Sure. Are you the individual in District 3 responsible for maintaining control of District Number 3 field reports in the ordinary course of KCC business?
Yes.
What role did you play in the creation of exhibits RD2 through RD8 attached to your direct testimony?
Majority of the role. I located the violations that staff had found in the field reports and documented them into a database that my supervisor, Troy Russell, helped construct. I also documented the violations in the field reports to the KCC rules and regulations. Troy helped me build some reports that are the exhibits that we could query out the violations per commission regulations, and that's what the exhibits are.
Thank you. As compliance officer, are you familiar with the commission's regulations?
Yes.
As compliance officer, do you regularly apply commission regulations to oil and gas operators in district number 3?
Yes.
Now that you're under oath, do you have any corrections to make to your testimony?
No.
If I asked you today the same questions contained in your testimony, would your answers be the same?
Yes.
Do you swear the answers contained in your pre-filed direct and rebuttal testimonies were and are true to the best of your knowledge?
Yes.
Thank you. Chair French, at this time, I move for the admission of Ryan Dueling's pre-filed direct and rebuttal testimonies and attached exhibits to the formal record.
Are there any objections?
Subject to the prior objections, no objection.
Prior objections and all the written objections are noted. But at this time, I will admit the testimony of Mr. Ryan Dueling as described. With that, Mr. Schlatter, you are free to cross.
Thank you, Chair French. Mr. Dueling, good morning.
Good morning, sir.
Thank you. We've got a lot of work to do today, so I'm going to dive right in if that's all right with you.
Yes, sir.
On page 14, lines 2 and 3 of your direct pre-filed testimony, you testified that operator has several hundred wells out of compliance. How many wells were out of compliance identified before November 28th, 2022?
At the time I done this testimony, the answer that I give here is correct. There's several hundred wells out of compliance. I'd have to go back and track from a year and a half ago to try to figure out the exact amount of violations at that date that you're requesting.
Well, you conducted this inspection in January 13th to the 25th, did you not?
I believe that is correct.
So the answer is probably none, isn't it?
That's an answer you're given. I would like to say I would have to go back and confirm to get that answer.
Mr. Dueling, how could you have found a violation before November 28th, 2022 in January of 2023?
Well, I'm not going to say that all these violations were found after the date that you were given.
You found them before you conducted your investigation?
Like it's the part of the violations would have been, yes, because of there was already dockets open.
As to the hundreds of wells listed in RD2 to RD8 that you conducted inspections on in January, were you aware of those violations in November 28th of 2022, or do you have any evidence that those wells were in violation as of November 28th, 2022?
No.
Is your preference that these hundreds of wells be brought into compliance or that Ace Energy be put out of business?
I would always prefer that the wells be brought into compliance.
Good. Are you aware that on May 18th of 2023, I transmitted the terms of a proposed settlement agreement that would allow operator to bring all of these wells into compliance? Did you receive and review that proposal?
I'm going to object to that. I'm going to object. Number one, that's a settlement agreement that should not be brought up at the hearing. And number two, any discussion of that settlement agreement occurred as attorney-client privilege.
It's a settlement offer is only inadmissible for purposes of establishing liability. That's not what it's being offered for. Mr. Dueling's testified that he wants him to be in compliance. Ace Energy offered to become in compliance, and I never heard a word about it, and I want to know why. I think the commission should be aware of that.
And again, I would object that that is attorney-client privilege, any discussion between staff and counsel.
Can
The
you
existence of my settlement offer is not attorney-client privilege.
Mr. Schlatter, can you restate your question real quick? I'm sorry, I missed the very beginning of the question. I caught all the responses.
The question about the settlement offer.
Yeah.
Well, it was a proposal, Chair French. So on May 18th, 2023, I transmitted the terms of a proposed settlement agreement that would allow operator to bring all of its wells into compliance, in fact, over an 18-month time period. So, and that included all of the hundreds of wells that Mr. Dueling had identified, even though we didn't know one way or the other about them. And I asked if he received and reviewed that offer or that proposal.
All right, I'm going to overrule the objection. I'll let you go down this line. I think you can ask about anything you've transmitted. I don't see how that's privileged. I will caution that, you know, my personal view is this could quickly get outside the bounds of relevance. So just be mindful of that. You know, we're obviously here today to decide, you know, compliance on specific issues, and don't want to get into negotiating a settlement agreement in a hearing. So, but as long as we're clear on what those guardrails are, I will overrule the objection.
Yes, thank you. And I will be as careful as I can, but I would ask the commission to be mindful of the fact that operator has testified that he feels that he's been mistreated, and there is an arbitrary and capricious standard in the enforcement of commission regulations. And so I will walk the line, and I'm sure you'll let me know when I've crossed it. But I would like to ask a few questions about this because I think it's important. And I'm going to publish the email that I sent. So I don't want to go through it, but I would like to offer it into evidence. I think actually I need Mr. Dueling to answer my question first, and then we can get there. So, Mr. Dueling, do you need me to rephrase that question?
I'm sure it's probably in Freedom's testimony. I don't remember seeing that, but do you have a copy of what you're talking about?
Mr. Dueling, I lost you there for a second on the audio. I think when you rocked back, you maybe got out of range of the microphone. Can you restate your response?
Yeah, I asked you. I said you have a copy of that.
Just a second. I'm sorry, Rylan. I think what's happening is you're getting picked up on Tristan's microphone. So Tristan, if you could go on mute and feel free to go off if you need to object to something, but I think that's what's going on. Go ahead, Ryan.
Okay. I believe you asked about a settlement agreement that you submitted back in May. I was wondering if you had that settlement agreement. Was that Mr. Freedom's testimony, or that I could make sure? I don't want to answer to something that I've never looked at.
No, sir, that was not an agreement. Man, this share screen thing. Okay. This was not a settlement agreement. It was a settlement proposal that I had made that I never heard back on. And I was wondering if, and I hope you can see that this is what was marked, at least in digital correspondence, as Exhibit AX2. So the A's cross number 2. This is.
Do you have the ability to zoom in at least at the top on the timestamp? And
yeah, is that better?
That's good. At least I can see it at this point.
Well, this Zoom bar keeps jumping in front of my control panel. I don't know why it's over there. But yes, so Mr. Dueling, this was an email I transmitted to your council with a proposal to bring all of the wells into compliance. I'd asked you if you preferred the wells be brought in compliance or Ace Energy be put out of business, and you said the wells in compliance, and I think that's appropriate. And so I had transmitted this, and I was wondering if you ever received or reviewed this.
It looks like this is a email between you and Tristan, you know, like you say, a settlement agreement proposal. As a compliance officer at District 3, I have a great deal of contact with operators when we are trying to propose a compliance agreement. Settlement agreements are usually done between legal staff and opposing operators, legal staff. I'm not sure the correct term of that. So as a compliance officer, I usually do not get involved too much with actual settlement agreements. I have a lot of, I work with operators every day that are requesting compliance agreements. So the answer to this I'm going to say is no. It might be a question that maybe my supervisor, Troy Russell, will testify later, can talk more in depth on that. But as far as compliance agreements, yes, I have a tremendous amount of work that goes in with the operators that come forward and want a compliance agreement. As far as the settlement agreements, no, sir.
Okay, so you did not, and let me step back. My understanding is the difference between a compliance agreement and a settlement agreement, at least in the eyes of commission staff, is a compliance agreement is entered into before there is a penalty order, meaning that staff has identified a laundry list of violations, sort of like the list that's attached as RD2 through 8 of your testimony, and works with operator pre-penalty order process to enter into a compliance agreement. Whereas a settlement agreement is aimed at resolving already identified violations and penalty orders. Is that correct? Is my understanding correct?
Yes, for the most part. Most of the time, operators, it might not be just compliance issues that we have located. It's operators that know that they have some violations that are coming up or have just recently happened and want to stay within the rules of regulation. So they contact us and we try to work a compliance agreement so they do stay in compliance with the rules and regulations. But for the most part, your answer was correct there, or statement.
Okay. And so I transmitted this settlement proposal in May 18 of 2023, and you were never made privy to the existence of this settlement proposal.
I do not recall that I had direct contact reading this proposal. I read a lot of stuff every day, but I do not recall this settlement agreement.
And you were never made aware that terms had been offered by Ace Energy, orally or otherwise?
No.
Okay, and you weren't involved in any discussion about a potential settlement agreement with Ace Energy and staff in May of 2023?
Not that I recall. Like I say, the most of that conversation would probably been from possibly my supervisor, Troy.
Okay, so I need to ask him about it.
That would probably be the best. Yes.
That's fine. Appreciate that. Do you believe you have a duty to administer and enforce commission regulations the same against Ace Energy as against every other operator in your district?
Yes, that's correct.
And do you have a duty to administer and enforce the regulations in a fair and judicious manner?
Yes.
And do you believe you have a duty not to engage in behavior designed to cause operator to commit violations of commission regulations?
I apologize. There was a little bit of feedback there. Could you repeat that, please?
Before you answer the question, Mr. Schlatter, are you done with the screen share?
Yes, thank you.
If you could take that down, thank you.
And I'm not going to offer that into evidence at this time because there's no foundation for it. We'll address that with Mr. Russell, hopefully. Okay, Mr. Dueling, the last question I'd asked, which you'd asked me to repeat, was, do you believe you have a duty to not engage in behavior designed to cause the operator to commit violations of commission regulations?
Yes.
But in the past, there have been instances where District 3 staff have delayed taking action on compliance matters submitted by Ace Energy until after deadlines have passed, which contributed to Ace Energy being found to have committed violations, correct?
Objection. That's argumentative, and it's unclear what is even being referenced.
Please rephrase the question.
I'm sorry, I didn't hear you.
I'm sorry, it must be my audio. I will sustain the objection if you'd like to rephrase it.
Sure. Mr. Dueling, in the past, hasn't operator been found to commit violations that were contributed to by staff not promptly taking action on certain matters?
I'm gonna renew my objection. That is unintelligible, that question, and argumentative.
Yeah, I'm going to sustain the objection.
Okay, I'll just dive right in then. I'm going to publish Exhibit AX3 for you, Mr. Dueling, to see if this is a letter from you to Ace Energy. Get this thing. There we go. All right. You zoom in here. You may recall this letter. This is dated July 29th, 2022. It involves a settlement agreement in docket 223124. Do you recall sending this letter to Ace Energy?
I'm going to object. This letter is reference to 22-3124, which is a docket that the commission has already had a hearing on, is already looked at a petition for consideration filed by the operator. This is completely irrelevant to the current docket.
Well, in response to that, I would note that Mr. Dueling expressly testifies to this docket in both his pre-filed and rebuttal testimony, as does Ms. Borst, as does Mr. Russell, and that staff provided hundreds of documents on this docket in response to discovery. I can't imagine it would be submitting irrelevant documents in response to discovery.
The reason that was testified on is because ACE is still suspended in 22-3124. None of the actual issues in 22-3124 are brought up in testimony. Therefore, anything regarding the actual issues in 22-3124 are irrelevant to the present docket.
So not only is it within the direct scope of his testimony, but it's also relevant, at least according to staff.
So I don't know that I have enough information yet to determine how relevant this this document is. So I think we will overrule the objection at this point. And Mr. Schlatter, I think you can go on and establish the foundation for why you believe it's relevant.
Thank you. Mr. Dueling, do you recall this sending this letter to Ace Energy?
Yes.
Do you recall the circumstances of the settlement agreement referenced in the reference line, or at least the general terms?
Yes.
And correct me if I'm wrong, but as I recall, there were 45 wells at issue in that particular settlement agreement, correct?
I would have to pull that settlement agreement up. I mean, I'm under oath, so I'm not going to say yes or no to that without looking that up, because I was not prepared today to talk about this docket.
Do you recall that Ace Energy had a deadline of July 31, 2022 to obtain TA status for as many of those 45 wells as possible under that settlement agreement? And if not, it would have been required to conduct enhanced compliance measures such as casing integrity tests on wells.
I do know there was a deadline I believe at the end of July that requested that they had so many wells that if they could TA, and you're correct on that. What you have failed to mention on that, I will go ahead and
Well, Mr.
mention.
Dueling, I'm not done talking about it. We can
Well,
get,
I'd like to answer your question if I could. You asked me
Oh, go
if I
ahead.
knew about this. No, I'll be quiet. Go ahead. Sorry.
it's up to you. I'm not going to cut you off.
Could you ask the question?
My next question was, okay, so just to get back to where we were at there. So if Ace Energy was able to obtain TA status for any number of these 45 wells, those wells effectively dropped out of the settlement agreement going forward, correct?
That is correct. All the wells that could be approved for temporary abandonment status would not be added to the settlement agreement. That settlement agreement was wrote that they had a deadline to get any well into compliance by an approved TA that was possible. And then it stated whatever was not able to be approved would be added to their settlement agreement.
And the consequence of the well being added to the settlement agreement was that in order to get into compliance, it would have to pass a casing integrity test or any other number of remedial measures, more expensive than filing the TA application.
Again, I would have to read that settlement agreement to know for sure if that language is correct.
Mr. Schlatter.
I'm about done.
Okay, well, I was going to say, I think I'd probably be interested in a proffer of, what we're trying to get at in this. And I thought maybe a way to wrap it up would be to simply take notice of this docket, and you all could reference it in briefing, since it is a closed proceeding. But if you've got maybe one or two questions, I'll let you go on.
Real pointed questions, Chair French. If I maybe extended such a leash at least a little bit on this issue, because it goes to the question that I'd asked twice before. So according to this letter, first line, it said the District 3 office had approved several TA applications on July 11th. And those, I believe those are itemized below. There are 20 of them here. Do you see where I'm seeing that?
Yes, sir.
Then it says that, and so that would have allowed those 20 wells to drop out of the settlement agreement or not become added to a settlement agreement, correct?
Correct.
And then it says that District 3 staff reviewed further and found that they should have been denied and effectively unapproved these 20 wells, causing them to be added to the settlement agreement.
Correct.
And you sent this letter on July 29th of 2022. That, I believe that is the Friday of that week, being the last business day that Ace Energy could have been brought these wells into compliance and kept them out of the settlement agreement, correct?
30. Yeah, I mean, I agree that must probably, I think there's 31 days in July. So yeah, that'd be the last business day.
And did you mail this to Ace Energy?
I believe so. I always mail it, but he was also notified. I mean, I had talked to Mr. Frieden about this settlement agreement and all the wells a long time prior to this, before July 29th, because I was able to locate, I believe, at least one, if not two wells that he had never even filed a temporary abandonment form that was part of this. And if I wouldn't have contacted him, the way the settlement agreement, if he wouldn't have filed the TA on that well or two, it would have been null and void. So he would not have even had an attempt at the settlement agreement. So there was conversation between me and Jonathan prior to July 29th about several wells in this settlement agreement.
You didn't tell him during that conversation that you were going to unapprove 20 TA applications, did you?
Do I?
You didn't tell him.
Could you repeat that?
Yeah, you didn't tell him that you were going to unapprove 20 TA violations, did you?
I'm going to object.
There was conversation.
Mr. Dwayne, I'm objecting again. We're still talking about issues in 22, 31, 24 that have already been covered. It's a closed docket.
I got like two more questions on this.
I think at this point, I am going to sustain the objection only for the purpose that I think, Mr. Schlatter, we see what you're establishing here, and I think the record probably speaks for itself of what you've established. I think, you know, it's probably going to strain relevance to to go much further into the record in that docket. The docket's facts speak for themselves, and certainly would have the opportunity. If you'd like to take notice of that proceeding, I think we could do that, and you could address it in briefing.
Sure, I mean, the point being that this letter couldn't have been received until after July 31st. And I'm not, are you instructing me to offer that the commission take notice of this proceeding?
If you would either like to take notice of I assume this letter is part of the docket file in that docket.
It is. It is listed as Exhibit RD1 in that docket.
Would you like to take notice of this this exhibit then, or this document?
I would like the commission to take notice of this.
Any objection?
No objection.
The commission will take notice of this document. And we don't need to identify it as an exhibit because it is in the other record.
Okay, thank you. I appreciate that.
Yeah.
Okay, moving on to a docket that is at issue in this particular, or at least before the commission, formally speaking. And unfortunately, it does get involved to a docket that is not, but that's unavoidable given the circumstances. And that is docket 203017. Mr. Dueling, you testify about this particular docket at page 5, lines 2 through 18 of your pre-filed direct testimony. This is a docket for operating on a suspended license, and that license was suspended as a result of non-compliance in docket 223410, which fortunately is not before the commission day, but is directly related to 233017. I mean, that's just correct. I'm just establishing where we're going here.
I would just say that, sorry, I would just object that 223410 is a docket that is closed, that it doesn't matter what any of the issues in that docket were, only matters whether the Base Energy's license was suspended under that docket or not.
Well, it was suspended for non-compliance with that docket. This kind of just can't slap a new docket number and say it's not relevant anymore.
I believe that that's exactly what the commission does, is the commission has different docket numbers for different violations, and the docket 223410 is closed, and therefore it doesn't matter what those issues in that docket are.
Well, it's within the scope of Mr. Dueling's testimony. He specifically cites it in the lines and pages I referenced.
So similar to the last line of questioning, I am going to overrule the objection, but Mr. Schlatter, your question was very compound.
Yes,
if you could rephrase and again, I guess help us get to the point of relevance quickly.
Thank you. Yes, I will. I was probably speaking too much there, not doing direct or cross-examination. Yes, so Mr. Dueling at lines or page 5, lines 2 through 18, you testify that operator was suspended for non-compliance in docket 223410, correct?
Yes.
And that penalty order involved TA violations at the DR Nelson 3, P2, and V2 wells, correct?
Yes.
And the penalty was for operator to pay the $300 fine and to obtain TA status on those 3 particular wells, or to plug them or produce them, correct?
Correct.
Okay, and Mr. Frieden has testified that he submitted TA applications for all 3 wells on May 10, 2023, which would have been the date the penalty order was issued. Is that your understanding as well?
What was the question again?
Mr. Frieden testified that the TA applications for these 3 wells were submitted on May 10, 2023, which is the same date of the penalty order. Is that your understanding as well?
That's what he testified. I believe I would like to look at my rebuttal because I'm not sure on that exact date if that's when it was when he no, I'm not going to agree with that at all.
What day do you believe they were submitted?
I believe it was June the 11th.
All 3? All 3 wells were submitted on the day?
I know the V2 was not submitted till June the 11th.
Okay. I would like to show you what's marked as Exhibit AX5, which are the various reports related to these 3 wells. And as soon as I share screen and it throws off my old computer, I will do that. Okay, how does that look?
Okay.
Okay, so this is the DR Nelson DR number 3 TA application. It's shown as approved on May 26, 2022. So, correct?
That's what it shows, yes.
So that TA application was obviously filed before June 11th, right?
Appears to be yes.
Okay. Same thing, the DR Nelson P2 TA application, showing as approved on May 26, 2022. So that one likewise was approved and the TA application filed before that particular date.
Correct.
Okay, and then lastly here, so at this point, docket 223410 is 2/3 of the way home as far as compliance goes. 2 out of the 3 wells have been brought into compliance. The only one left is the V2, correct?
Talking about the wells, yeah, I don't know about the date when I'd have to go back and read that order to see when the date they had to be completed by. Because I don't have that information from me because that wasn't in none of my pre-files.
Okay. I can pull up that order if you'd like. Would that be helpful?
You're talking about 3017 or the other one? 33.
3410, 223410.
Yeah, I know that order, there was 3 wells that he was out of compliance with and did not meet the deadline. So yes, it was, they had to be brought into compliance after that deadline on that order.
Okay, I don't know let me look at that real quick. I'm gonna call that up and see if we can figure out when that would have been. What is the normal time period for compliance on a penalty order? It's obviously not the day it's issued if there's directives to do some curative measures.
Yeah, usually it's 30 days.
Okay. That's kind of what I thought too, but I think looking at this, I couldn't find it. So here's the penalty order on, this is marked as Exhibit AX4. This is the penalty order entered in 223410. This is the background here. I'm scrolling down to page 2. Here are the 3 wells we previously identified as being out of compliance. I don't see a deadline date there. Where would this 30-day deadline ordinarily be located?
And you say this is an exhibit so I can look at it, so I don't have to have you keep scrolling up and down?
It is an exhibit.
Which one is it, sir?
It's AX4, cross exhibit 4. Here it is. No, that's the request for hearing date.
I'm sorry for taking time. I want to read this whole thing, so I'm not answering your question wrongly here.
Okay.
Well, it appears the reason that there was this order is the operator had to bring 3 wells into compliance by either plugging them, returning the wells to service, or attaining TA status. He had failed to do that. And I'd like to bring up, I don't have the whole part of the penalty order usually has attachments that tells you all the violations. This might be it here. Yeah, the operator was actually supposed to have taken these wells into compliance by March 5th of 2022, which the operator failed to do. That's why the penalty order was the penalty recommendation was sent on to legal and put in front of the commission is because he failed to bring these 3 wells into compliance by March 5th, which was on an NOV letter that I had sent back in February 3rd of 2022. So am I getting towards your question? Is
You
that
mentioned a deadline date to bring these 3 wells into compliance under the penalty order. I don't see one on here. I would just
what I was trying to explain, and I apologize, is when an I was talking the 30 days was the NOV letter that we send out. We give a 30-day deadline for the operator to bring the 3 wells into compliance. So my 30-day answer, I apologize. I was confused with where we is at. My 30-day answer was for the NOV letter that was attached to this penalty order.
Okay. But this particular penalty order does not have a deadline to bring the wells into compliance. It's just an instruction to bring them to compliance.
Yeah, the operator had done missed the deadline. I mean, the operator had failed to meet the deadline of March the 5th. So, yeah, I guess.
Okay. But under this penalty order, there's no deadline. It's just to bring them into compliance.
Objection. Mr. Dueling isn't the individual who drafted this. This is something that was approved by the commission. Mr. Dueling shouldn't be forced to testify on deadlines in a penalty order.
I do think, I mean, it's an order. The document speaks for itself. If you want to ask Mr. Dueling further questions on it, that's fine, but maybe not his understanding of what the deadlines are associated with it.
Right. We're out here because he said there was a deadline and I didn't know of one, and I think we've established there isn't one, so we can move on. Okay, so getting back to this particular temporary abandonment, this is the application for the V2. This is the well that needed to get into compliance for that penalty order to be closed out, correct?
Correct.
Okay. And this one you testified was submitted on June 11th.
Yes.
Okay. And so on June 11th, it's submitted. And then on July 6th of 2022, it is denied. The basis is shut-in dates changed based on UC3s.
Okay.
So it was, from the time it was filed, it was about 25 days until staff took action on this particular temporary abandonment application. You testified in that same spot in your testimony, page 5, lines 2 through 18, that you suspended operator's license for non-compliance with this docket on June 21st, 2022. And gave him a 10-day deadline to shut in all of his wells, correct?
That's in my testimony we're at, sir. Page 5.
5. Lines 10 through 13.
Yes, that's what it says. Staff suspended operator's license on June 21st.
So on June 21st, did you know that you were going to deny the TA application for the V2 on July 6th? 15 days later and 5 days after the date to shut in all wells?
Okay, could you repeat that?
Well, you
Repeat
suspended
your-
operator's license on June 21st, 2022 for not being in compliance with the TA regulations. Did you know at that time that you were going to deny the TA application for the V2 15 days later?
No, because I probably had not even obviously I had not even been able to process this TA before June 21st.
But operator had submitted the requisite form on June 11th. It sat there for 10 days. It was the only thing he had left to do to bring that docket into compliance was to get approval of that TA. And it sat there for 10 days. And then on June 21st, you suspended him for not bringing that penalty order into compliance.
The commission suspended him. I mean, you're talking like I have the authority to suspend any operator. It's the order that the commission put out stated it would be suspended on June 21st. So yes, the license was suspended on June 21st.
Is that fair to Ace Energy to not process the application that's the only thing between him and compliance in that docket, and then suspend his for more than 25 days?
Objection. Argumentative
then-
and compound.
And I haven't finished my question. Let me rephrase. Do you think that it's fair to punish Ace Energy through a license suspension and subsequent penalty order for non-compliance when it had submitted the form it needed to do to achieve compliance 10 days prior to that date, or actually 20 with the 10-day tail time?
No, I'll object, argumentative and compound.
Yeah, I mean, Mr. Schlatter, we're walking a fine line here. I mean, if you want to take notice of the dates, that's certainly fine. If there's documents you need us to take notice of, you know, I might allow a question to Mr. Dueling along the lines of, you know, what's a reasonable time for staff to act on things, but even that's straining relevance. So yeah, I would probably encourage you to move along. But if you've got more questions, maybe one or two, but I'm probably more inclined to have you identify the documents with the dates and then let the commission draw its conclusions on those.
I can do that. I've just never had a evidentiary hearing where I was just offering documents and pointing out dates and not putting documents in through witnesses. That feels more like argument to me. If that's what the commission prefers, I'll gladly do that. I've never done it that way before. So I want to make sure I'm making this
trying to
record
establish
properly.
here.
Excuse me?
What I guess it would be helpful to me to know what fact you're trying to establish here.
Well, Ace Energy testifies it submitted its TA application on May 10th. Mr. Dueling says it was June 11th. Either way, it was submitted, and that was the only application that needed to be processed to bring itself in compliance. That application sat in queue for quite a long time. In the meantime, his license was suspended for non-compliance with that docket. The only reason it was suspended is because that application had not been processed. And then he had 10 days to shut in all his wells. Mr. Frieden testified that he was trying to get a hold of District 3 staff and everyone was ignoring him about the status of this particular application. Then on June 6th, his application is unilaterally altered to reflect a new shut-in date, subsequently denied on that basis. And then he's hit with a $10,000 penalty order for operating on a suspended license. To me, those don't demonstrate a set of facts that is fair towards operator. 25 days to take action on a TA application when at the same time he's expected to shut in all 400 plus of his wells within 10 days.
So your points are well taken as far as the timeline and your opinion on that. I guess I'm struggling with what information you're trying to elicit from Mr. Dueling.
But just those facts. I mean, why did it take so long? If I can just proffer all of that evidence, then I don't need to talk to Mr. Dueling. But I've never done that before.
I think that's what I was suggesting is that I'm having a hard time seeing what Mr. Dueling can add to sort of the facts that are already in the record. And I will allow you if you want to ask one or two more questions of Mr. Dueling. But you know, we obviously have limited time for this. So if you can make all those arguments with the facts that are already in the record, I would suggest if there's anything we need to take notice of that is not in this record already, please let us know.
Well, yes, and this will be offered into the record, and I think the commission can take notice of it either way.
Yes.
The inferences to be drawn, I was just anticipating eliciting through testimony. If I can proffer that, then that will make things go very quickly.
Absolutely.
Okay, thank you. And I agree that will speed things up dramatically. Okay, Mr. Dueling, scrolling down to Exhibit AX5. This was a document furnished in discovery. I think maybe this is where you obtained the June 11th, 2022 date. This document establishes that staff at least put its fingers on the TA application for the V2 well on June 13th at 2022, correct?
That's what it says, yes.
And it says that the KCC edited it. Do you know what that means?
Yeah, I mean, she received it in from the operator's queue.
Nothing more. So it wasn't actually edited.
No, not that I'm aware of. No, because that I'll be honest with you, I don't know what that means, but I can tell you the process of when operator submits the CP 111 through Kohler or administrative specialist accepts them in, is the way I understand it, and that is her entry there. Okay, on the June 13th.
I guess to just paraphrase, it was in District 3's hands on June 13th, 2022.
Yes.
Okay, and it being the TA application for the V2. And then the next entry is Ms. Brooke Dyke changing the shut-in date from January 1, 2019 to January 1, 2012 on July 6, 2022. That's what this means?
Yes.
What basis was there to change the date? And what evidence was there that was the correct shut-in date? That you believe that January 1st, 2012 was the correct shut-in date?
The DR Nelson V2 is an enhanced recovery well. Operator filed U3Cs showing that no fluids had been injected into the well. Traced U3Cs back to 2012. No reports of any fluid being injected in the well means it was inactive. It was not being used.
Was it equipped for injection?
So that's for the date.
Oh, sorry. I didn't mean to cut you off.
Could you repeat it? I'm sorry, we crossed lines there.
I just wanted to make sure that you'd concluded your answer. I think I accidentally cut you off, and that's my fault. You had stated that the reason you picked that day was based on U3C forms, I believe. Is that all the conclusion of your testimony?
Yeah, that's correct. That the U3Cs that were submitted by the operator. Yes.
Is this particular well equipped for injection?
I do not know. I'd have to go back and look at a field report from the last time staff was on this lease.
If it were equipped for ejection, would it not fall under the exclusion to the TA requirement, meaning that the exclusion that if the well can immediately be reactivated, it doesn't need to file TA applications?
Not since it's been shut in over 10 years, no.
The exemption to the TA requirements concludes after 10 years under K 83-2-111.
it says 82.3.111, they'd have to file an exemption to the 10-year rule.
But the requirement to obtain TA status, there's an exemption from that for wells that are equipped to produce, correct?
Well, there is an exemption for a declaratory well, but you can't have a declaratory well that's been shut in over 10 years either. Because even though it's a declaratory well, sir, that well still has to be operated at least one time throughout each year. And when you don't put any fluids at all down it through a whole year, then there is obviously, even if it was connected, obviously the operator did not put any fluids down that well because he reported 0 barrels of fluid being put into that well. So yes, the answer to your question, there is a somewhere, I don't have 2311 pulled up, but to be a declaratory well, you still have to produce or inject in that well at least once a year, even though it's declaratory. And that was not done per U3Cs filed by the operator.
Okay. Are those U3Cs in the record today? All 11 of them, or how many there are? I've not seen those.
Objection. No, Ryan Dueling wouldn't know what was in the record.
Sustained.
Let's move on to the MITs at the EC Larson and docket 233029. Okay, at lines 6 or at page 6 through 16, page 6, line 16, page 8, line 4, docket 23, you testify about docket 233029 regarding the passing of MIT violation or passing of an MIT at the EC Larson number 2 and number 6. In your testimony, specifically at lines or at page 7, line 7, you indicate the wells failed MIT on April 5th, 2022. Correct?
Correct.
I'm going to show you what I've marked as Exhibit AX6. And I will try and zoom in as soon as this thing goes away. There we go. All right. So let me zoom out just a little bit. Here's the what I've shown to you, which is marked as AX6. This is the MIT test for the EC Larson number 2. It shows test date of April 5th, 2022. And it shows that the wells failed mechanical integrity. Scrolling down, this is the mechanical integrity test for the EC Larson number 6. Same date, April 5th, 2022. Same reason, failed mechanical integrity. What I'd like to offer into evidence is the subsequent mechanical integrity tests conducted on the EC Larson wells. In particular, this exhibit here, I'm on page 5 of this exhibit, EC Larson number 2. This wasn't part of your testimony, but mechanical integrity testing was attempted again on June 21st, 2022, correct?
Yes.
And scrolling down to page 7, EC Larson number 6. Casing mechanical integrity test again, June 21st, 2022. And again, it failed mechanical integrity. And so in the subsequent 2.5 months here, Ace Energy was working to repair this well to save the well. Is that a fair statement based on this evidence?
Objection. Speculation. He doesn't know what Ace Energy was doing.
He's already testified that he's aware of everything staff is doing. Staff states that it's in the field.
U.S.
I will sustain the objection as to Ace Energy's intentions.
So as of June 21st, 2022, Ace Energy had been in the field working on this well to attempt to get it to pass MIT. Correct?
I do not know if that's correct or not. I can tell you that we retested the well on June 21st and it failed. Well, if Ace Energy did anything to the well or not, I do not know.
Okay. Scrolling down. So after the EC Larson number 2, let me step back. Doesn't staff witness all MITs?
Not 100% MITs. No, we witness as many MITs as possible.
Based on this report for the EC Larson number 2 on June 21st, 2022, can you tell me whether staff witnessed this MIT?
On June 21st,
Yeah.
this test was witnessed.
Okay. And scrolling back up to page 5. The EC Larson number 2, can you tell me from this report whether or not staff witnessed this MIT on June 21st, 2022?
Yes, it appears so. It's collected. Yes, it was witnessed.
Okay. And based on your experience in District 3, do operators often retest wells without first attempting to repair them?
It don't make no sense to, but we have had some because the deadlines come up and they numerically think it's going to pass. But most operators try to repair wells before they before they request another test.
Okay. And then scrolling back down here. So after the EC Larson number 6 failed MIT, on June 21st, it was plugged and abandoned on July 6th. Is that correct?
That is correct.
Okay. And that's just 15 days after it failed MIT. Is that a reasonable period of time to get a plugging contractor out there?
Well, I think what you failed to mention in that last statement is it originally failed on April 5th, either repairing and having a successful MIT or plug the well. It wasn't just the 15 days or whatever you stated in your statement there.
Is 15 days a reasonable or even maybe exemplary example of a reasonable period of time to obtain a plugging contractor after a well fails MIT? In your experience?
It might be tough to get a plugging contractor in 2 weeks, but there's several plugging contractors out there. So, obviously I don't have any production, so I I can't say that if I could get somebody to plug it in 2 weeks or not.
Okay. I mean, to me, that seems like an awfully quick period of time to get a plugging contractor out there. Is that your experiences, particularly the summer of 2020?
I'm gonna answer that as yes. It is 2 weeks is a time frame that would, it would be tough probably to get a plugging contractor to drop everything and come do it. However, I'd like to point out they had more than just 2 weeks. They had 90 days from the day that first failed to get that done.
What would have been 90 days from April 5th?
I'm assuming July. I mean, you'd have to go. I'm assuming it'd be July the 4th.
July the 4th, which is a federal holiday. Okay, so 2 days after the 90-day deadline to bring this well into compliance.
Just this one, yes. The other one wasn't brought into compliance, I believe, until the 19th.
Okay. The EC Larson number 2, I'm on page 10 of exhibit AX6 now. This well was tested again for mechanical integrity on July 8th, 2022. And unfortunately, it looks like it also failed again. Can you tell from looking at this if staff witnessed this MIT?
It's marked that it was witnessed.
Okay. Oh, yeah. This is all I needed all along. Didn't notice that until just now. Okay, so so now this is after the 90 days and Ace Energy is still attempting to achieve mechanical integrity compliance. And this test is like 3 weeks after the last one. Is that at least a good faith effort to save the well in your experience?
Again, I do not know if they did anything in those 3 weeks other than just retest the well. So, matter of fact, the matter to state is they had 90 days to try to save the well and retest or plugged, and I'm not sure, why you keep going back to 3 weeks, because they had the 90 days. So if they was strongly wanting to save this well, if I was the operator, I would have been starting, probably on April the 6th, trying to repair the well so I could get a good test on it.
I would move to strike that last portion of the testimony about operator's intention, particularly in light of the previous ruling.
Mr. Schlatter asked that question. Mr. Dueling was just answering the question that was asked.
I did not ask that question.
So, Mr. Schlatter, you did ask his opinion about what the operator should or should not be doing, acting in good faith. So I think it's within the line of the question, but I will note, so I'm not going to strike it, but I will note that, the commission has the ability to decide what weight they give to different statements. So we'll allow it in. We're not going to strike it. I did want to ask you, Mr. Schlatter, I don't want to cut you off at all, but I did want to give everybody a mid-morning break here. We've been going a little over an hour and a half. I'm assuming you still got some questioning from Mr. Dueling, but would there be a good time to take a break in the next 10 or 15 minutes?
Yeah, I'm about done with this line of questioning. So I think after that would be a good time for a hard break.
I will just rely on you to tell me when you've reached the end of this line, and then we'll give everybody a short mid-morning break. I imagine some people would like it.
I would appreciate that.
Okay. Still on Exhibit X6 here. Scrolling down to the very last page, page 12. This is the plugging record for the E.C. Larson number 2. This document evidences that well was plugged and abandoned on July 19th, 2022, correct?
That is correct.
And that was less than 2 weeks after it failed its last MIT, correct?
The very last one, the last time it failed, I believe you said they tried it. I think it said July the 8th. So yeah, that's a couple of weeks.
Okay. And
after the third attempt, yes.
Okay. And at this point, operator had finally brought this particular penalty order into compliance July 19th.
No, they brought the well into compliance on July 19th. That is correct. Yes.
Okay. And that would have been, so you said it was 90 days from April 5th, which was July 4th. So this one is 15 days after the conclusion of the 90-day deadline, correct?
That would be correct. Yes.
Does district staff ever extend the 90-day deadline when an operator is working to save a well?
No, not on UIC penalties.
90 days is a hard deadline.
Yes.
Okay, that's all the questions I have for Mr. Dueling on this topic. So that would be a good time for a hard break.
All right, thank you. I very much appreciate that. Let's take a 10-minute break. So we'll come back at 10:50 and resume at that time. So we are now in recess and off the record. 10:50. All right, it looks like we've got 10:50, or I do. A couple items before we go back on the record. I have switched my audio source. John, can you hear me okay?
Yes, this is actually much better. You weren't cutting off at the very beginning again.
Yeah, my microphone, for whatever reason, there was a delay of 2 or 3 seconds after I started speaking, that folks could hear me, I think. So I'm hoping my new earbuds will will be a little better, but bear with me if my issue continues. The other item I wanted to raise is just the matter of a lunch break. My intention is we're not necessarily going to take that break at noon, but if we can get through this witness or get to a logical stopping point, we'll take a break. I'm intending for just a 30-minute lunch. Is that going to be an issue for anybody? Does anybody need longer than 30 minutes? We've got a full day, and I also want to do a hard stop at 5 o'clock to make sure everybody can go vote if they haven't been able to yet. All right, I'm not seeing any objections. So, Mr. Schlatter, you can continue with your examination of Mr. Dueling.
Thank you, Chair French. Mr. Dwayne, I'd like to refer you to page 8, lines 7 through 23 of your pre-filed direct testimony. That's where you refer to the penalty order for unauthorized injection at the Gale Mullen C43, E43, I43, Mullen I22A, and Underwood 6R90.
Yes, sir.
Now, the allegation has been made that these wells were merely equipped for injection and that violates commission regulations. Is that your position?
Being equipped does, yes.
So, well, that's equipped for injection but not actually injecting violates commission regulations.
Yes, it well should be permitted before it's even hooked up for injection purposes. Our intent is to make sure that we protect fresh and usable water, and even a well that has failed, it needs to be unhooked immediately because we know for sure that it's not protecting that. Same way with the well that's even hooked up with valves open, capable of producing fluids down into that well. I believe it's somewhere, I got a copy of the regulation 400 or 4. It states in there that a well should be permitted. None of these wells were permitted.
Which regulation says it's a violation to hook a well up for injection even if it's not being injected into?
Um, 82.3.400B, second sentence says the failure to obtain a written permit from the Conservation Division before beginning injection operations. Injecting operations would be prepping that well ready for injection purposes. That's why no injection, any well that does not have a permit or authorized to be an injection well should not be hooked up or used for injection purposes.
Okay, so I've got 82.3.400 before you today. It says authority to inject. Injection shall be permitted only after both of the following conditions are met. Operators filed an application and the Conservation Division has issued a permit. So that doesn't say anything about being hooked up for injection, does it?
No, but under B, second sentence says beginning injection operations. To begin any injection operations, you have to lay the groundwork and structure to get the water there. These wells were, the field report showed not only that they were hooked up, but there was other stuff that in Brad's field reports that showed that they were more than likely using these wells for injection.
So you're saying that injection operations can include not injecting water?
What I'm saying is injection operations. I do not know of any operator that would have injection lines running to the well and hooked up with valves open, check valves installed to make sure the water's going down the well and not be using them for authorized or for injection purposes.
I mean, I'm going to ask the question again. Is it your opinion that 82.3.400B, the term injection operations includes operations that do not involve injection of water?
What I believe the way the reg reads and what I've been told that with discussions with legal staff that it says before beginning injection operations. You have to obtain a written permit for an authorized well before you begin any injection operations.
Mr. Dueling, I'm just trying to understand what you think that term means, injection operations. To you, does it mean an operation that doesn't involve injecting water?
Don't know how to answer that, to be honest with you. You keep asking that, and what I'm going to say is I believe that a well that is hooked up for injection purposes has broke 82.3B because you begin injection operations by connecting that well for injection purposes.
Even if no water has been injected?
I'm going off of what's written in the reg.
Chair French, can I please get an answer to the question? It's a yes or no.
I'm hesitant to direct the witness to say more than what he's comfortable saying. I think we're giving some leeway to staff here to give their opinion on what a regulation means, and I'm happy to do that because they've got some experience. But at the end of the day, the facts are going to be laid out, and the commission's going to have to interpret the reg and decide what that means. So I don't think I'm going to ask Mr. Dueling to speculate further on what he thinks the reg means or his interpretation.
I'm not asking him to. I'm asking him to answer a question as to whether injection operations does not require the injection of fluid into the ground. I think that's his testimony, but I've not been afforded an answer to that question.
Go ahead.
Chair French, apologize.
Go ahead.
I was just going to say, you've already ruled on this, Mr. Schlatter. You should not be arguing with you.
Yeah, to be honest, I think I've heard Mr. Dueling give a couple different interpretations here. I would also say this, from my recollection of the pre-filed testimony, staff's position on injection is pretty clear. So I don't think there's any further examination or any further answer that Mr. Dueling needs to give to that item.
I'd like to scroll up to the definition of injection in the commission's regulations, just to put this in the record. So this is 82.3-100 series. 101, 82.3.101. The commission has taken upon itself to define the term injection at 40. And that means injection of fluids or natural gas for enhanced recovery or disposal of fluids or brines. Mr. Dueling, is the word equipped for injection located anywhere in the definition of injection?
Not in that sentence, no.
Have you ever personally observed water being injected into these particular wells?
Me personally, no.
In your rebuttal testimony at page 5, lines 8 through 12, you say it's probable water was injected because nobody you know has hooked up a well without injection authority. Is that evidence of actual injection?
Would you point me to that again in my rebuttal? What page and line?
Page
Please?
5, lines 8 through 12.
And what was your question again?
You say it's probable water was injected because you don't know anybody who would hook up a well without injection authority. That's not an evidence of actual injection, is it?
Objection. That's misstating what Mr. Dueling testified to.
Do you want to read your testimony into
Objection.
the record so I can ask the same question? Because I don't think it's mischaracterizing anything.
Mr. Schlatter, I think you're arguing with the interpretation of Mr. Dueling's answer in his testimony. I think his testimony speaks for itself.
I'm at 5, 8. The question at issue is, beginning on line 3 of page 5 of Mr. Dueling's rebuttal testimony. On page 8, lines 25 through 26 of Mr. Frieden's testimony, he alleges he was not injecting into the wells at issue in docket 23-3087 that the wells were only hooked up for injection because operator planned to eventually apply for permits to inject into the well. Are you aware of any operators who have hooked up for injection before even applying for injection authority? Answer, I am unaware of any operator in District 3 having gone to the expense and effort of hooking up a well for injection before applying for injection authority at the well. This is the phrase I'm talking about. Given the number of wells operator has hooked up for injection, it is much more probable that operator was injecting into those wells without injection authority. Then it goes on, this is even more likely given that the valves on all these wells were open and ready to receive fluids. My question was, is other operators' conduct, how does another operator's conduct make it probable that water was being injected into these wells?
Is there, I'm sorry, I did not catch all. Is there a question, Mr. Slatter?
Yes, you state that it's probable water was injecting based on other people, other operators. Correct?
What I'm saying is the operator went through a great deal of expense to run the lines from the pump house to the injection well, hook them up with all the valves going to that. And it asks if the other operators do that. And the answer is no. Most operators get authority, permitted the well before they ever run all that stuff. That way they know it's permitted, it's capable of injecting. Does that answer your question?
My question is, how is that evidence that water was actually being injected into these 5 wells?
Well, there's a lot of evidence that shows that the wells were hooked up for injection.
Some operator may or may not have done is not relevant to whether or not there was actual injection into these wells.
Objection. Mr. Slatter's testifying.
Well, now I'm asking the commission to take notice of that.
Yeah, I'm going to sustain the objection. I think, Mr. Schlatter, you've already asked that question, and I sustained an early objection on it.
Moving on to that particular testimony, you state that the valves on all the wells were open. Did you actually observe those valves open?
Just from photos.
And are you referring to the check valves?
I am referring to the ball valves. if you want to bring up those pictures, we can discuss those.
I can't because I have no idea what photos you're referring to based on your testimony. Well, let's just skip that for now. Let's say if you're talking about the check valves, can you tell if a check valve is open from looking at it?
You can tell which direction a check valve is placed on the line to show which way the water will flow into the well.
That's not what I asked. I asked, can you tell from looking at it if it's open or closed?
Not no one physically can know.
Thank you. All righty, let's move on to the field inspection, I believe is what it's referred to. Yes, recent field inspection starting at page 9, line 5 of your pre-filed direct testimony. So you testified that staff allegedly found violations at hundreds of wells on operators' leases based on inspections that took place between January 12th of 2023 and January 25th of 2023. That's a 13-day time period, correct?
That's correct.
Who asked staff to conduct these inspections?
Objection. This is attorney-client privilege.
Does that mean that the attorneys requested it?
The extent that the answer requires the witness to discuss, the consultations they had with counsel, I would sustain the objection. If the witness can answer without any reference to attorney-client privilege conversations, then I'll allow an answer.
I mean, I think it's the who asked for the inspection to be conducted. I'm not sure how that would fall under advice or legal advice. So I think he can identify the who without disclosing attorney-client privileged information.
Chair French, I'm not a lawyer. I do not know if I'm supposed to go ahead and try to answer this, or if I should request a time real quick to talk with Tristan.
Because this may have some relation on attorney-client conversations, we can go in recess for 60 seconds. So that you can get an answer. But I do tend to agree with Mr. Schlatter that the question of who ultimately decided, I mean, that doesn't seem to fall within attorney-client conversations. So if you all could please confer briefly off record, and we'll all go on mute.
It was
Dueling, I see you're back. Okay, go ahead.
Yes, sir. It was requested by legal staff that inspections be performed.
Do you have a particular person or just the omnipotent legal staff?
No, Tristan Kimbrell.
Did you conduct any of these inspections yourself?
No, not physically. I was not physically on the lease.
Who did?
We'd have to go through every one of them. There was different staff on different leases. Ryan Hermrick, Brad Boyer, Levi Burnett were the district field staff that did the inspections on the leases.
None of those. I don't recall any of those folks submitting pre-filed or rebuttal testimonies. Is that right?
No, it's not correct.
They did not.
No, you're not correct. There was one staff that filed pre-file.
Okay. What were those names? Ryan, Levi, and who was the third one?
Brad Boyer.
Brad. Okay. Thank you. And you inspected every single one of operators' leases for those staff
Again, I
members
stated
did?
I was not physically.
Let me
I'm sorry?
rephrase. I shouldn't have said you. Am I correct that staff inspected every single one of operators' leases?
I believe so, yes.
All and inspected all 400 plus whatever number of wells operator operates?
That is correct.
But do you know why this sort of mind sweep was conducted?
And again, that would be the attorney-client privilege. So I object to the question.
I don't think it's relevant to the issue, the compliance issue in the case. And it also likely is privileged. If indeed, Mr. Schlatter, you are asking what those conversations were.
I was just wondering what prompted an investigation of every single one of Ace Energy's wells. If that was, it seems to me that the only logical inference from that could be that it was for purposes of this evidentiary hearing, which would be the only basis for privilege. Then I think we have the answer we need.
And again, I would say that falls under privilege. Thank you.
Has district staff ever conducted this type of investigation with any other operator?
Yes.
Well, who are those operators?
I'm going to ask Chair, is that a question I can answer?
To the extent you're able, and it's public record, I don't have a problem with it, but would certainly understand if you need to offer a more general answer. I don't know how much this is prying into your recollection.
I can say for public record that we have done these type of inspections on Haas Petroleum and Quito Inc. I can say that we did those two for sure without going back. And if that's good enough, Mr. Slatter, or if you need me to.
Just curious. It seems extraordinary, and that's why I'm asking. Do you recall when Haas Petroleum's leases, every single lease was inspected?
No, not without going back and looking. I mean, I took oath not to lie, and I don't want to, give you a date that's not correct. I mean, all that is documented and public information, so we could go back and check. But
I just generally, has it been months, years, decades?
It's been prior to these.
Okay. During when you were put on direct, we got into some foundational issues on the business records attached to your testimony as RD2 through RD8. And you testified that these records are kept in the regular course. Am I remembering that right?
That was definitely put in different words than I might have said. So I guess could you rephrase what you're asking there?
Is this well, you testified that these types of records, the ones attached as RD2 to RD8 are kept in the ordinary course of staff's operations. Am I remembering that correct?
If I understand your question, yes. I mean, these exhibits are exhibits of how we track violations that we found during our lease inspections.
How many, just in ballpark, how many operators are in District 3? Operating wells in District 3?
Operating wells or operators?
Yeah, how many operators operate wells in District 3?
Oh, that's probably something I should look up so I have a true answer to that, but hundreds of operators in District 3. I don't
Hundreds
know
of
an exact number. Yeah.
And how many of those particular operators have you created records similar to those attached as RD2 to RD8 for?
I believe at least 3 others.
So 3 out of several hundred?
Yes. For sure, 3.
So these exhibits, and let me step back, were all of those exhibits or records, as you call them, used in commission proceedings for purposes of finding violations?
Not all of them, no. I use similar tracking for compliance agreements also of operators that's come forward to try to get a compliance agreement, and after field investigation, I use this same type of database to track that. So no, to answer your question is no.
Isn't a compliance agreement approved by the commission?
An approved one, yes, it's got to be approved by the commission.
At this point, I would like to lodge an objection to the admission of these exhibits as not falling within the Business Records Commission, Business Records exception to hearsay. These records are not kept in the ordinary course of business. They are completely ad hoc and apparently only done when a commission proceeding is involved.
These are clearly commission records. The commission can take administrative notice. The commission has already ruled on these exhibits being able to come in. They are admissible.
I'll overrule the objection on the same basis that we already overruled the motion to strike. But your objection is noted for the record, Mr. Schlatter.
Thank you. I had to do it. Okay, let's get into these inspections a little bit here. Let's start with RD2. Well, first of all, I have a kind of a curious question that I want to make sure I ask. So district staff was able to conduct an inspection of 400 plus of operators' wells over a 13-day time span. Is that correct?
I believe so. I didn't actually count the exact dates if it came out the 13th, but if it fell, them field reports fell within them the January 12th and January 25th, yes.
Yeah, I might be doing something no one lawyer should ever do, and that's math on the fly. But January 12th to 25th, that's either 13 or 14 days, I think. Does that sound right?
That sounds right.
Okay. Well, I just want to know, why does it only take staff 13 or 14 days to inspect every single well in operator's inventory, but it can't get a TA application approved in less than 24 days?
Objection, argumentative.
It's testified to 24 days being reasonable.
I'm going to sustain that objection.
RD2, you've identified, exhibit RD2 to your testimony, you've identified 303 wells that were out of compliance with 82.3.111, which are the TA violation or TA regulations, temporary abandonment regulations. Isn't it correct that those regulations require a TA application to be filed for any well inactive for more than 90 days?
Inactive more than 90 days? That's correct.
Then it's probably not possible that staff was able to observe these wells being out of compliance for 90 days over the course of a 13 or 14-day inspection, is it?
Well, first of all, these are violations. The well was inactive at that time. These violations were never sent in for penalty recommendations. These are wells that were listed as not that being inactive and not having a CP 111 filed.
But a CP 111 doesn't need to be filed until it's inactive for 90 days, and staff couldn't have possibly observed a well being inactive for 90 days over the course of 13 days. That would violate the constructs of time, wouldn't it?
Not on all of them, but if you go and read the field reports, there's several leases that were not equipped at all with electric to the lease. The electric company had pulled the meters, and those dates are reflected in that field report, which was well more than 90 days. So I can't say all 4 or however many wells you said was listed here on their CP 111, but there were several wells that for sure had been inactive for more than 90 days.
Not all of them, for sure.
Okay, not for sure, no.
All right, how about RD3, exhibit RD3? This is a claim that 18 wells weren't properly plugged. Were all of these wells approved for plugging?
Could I ask where you're at again, sir? I'm sorry, I don't have
Your
this
exhibit
tab.
RD3.
Does that one start? Which violation report does that start with, sir?
114.
Okay, 82-3-114 violations.
Yeah, it looks like page 10, line 17 through page 11, line 4 of your pre-filed testimony direct.
Okay. And what was the question again? I'm sorry, I've got them here.
I asked if all of these wells were approved for plugging.
Approved for plugging, I would I would have to go look. I do not know if they have CP1s filed. I'm sure they do, because some of them definitely have CP4 and CP23s completed. So I'm assuming they were approved for plugging.
Okay, and would staff have witnessed the plugging of these wells?
Without going and looking up each individual, I cannot tell you which ones were witnessed and which ones were not witnessed.
Would there be a well plugging record on file for all of the wells?
Possibly, if they were plugged.
Is that what the CP23 was that you referenced was? Is that the well plugging record?
Yeah, that is correct. CP4 and CP23 completed. That is the operator and KCC plugin report. So yes, those wells, it says that was CP4 and CP23. They obviously have plugging CP23 plugin reports filed.
Okay, and prior to this docket, had operator been notified that staff had issues with the way that it completed the plugging job?
Rephrase that again. I'm sorry, or not rephrase, but repeat that one. I'm sorry.
Prior to the initiation of this particular docket, had staff communicated to operator that it had concerns with the manner in which these wells were plugged, or the plugging operation was completed?
Not that I'm aware of.
Has the landowner complained about the manner in which the casing was cut off on these plugged wells?
I think the problem is that there's none of the wells are been cut off after plugging. The casing's still above ground. That's the reason we found them.
But the landowner didn't complain?
I do not know if the landowner complained or not. I don't have an open complaint that I know of that says that.
Okay. Moving on to your exhibit RD4, which is lines 11-8 through 12 of your pre-filed direct testimony. You say that staff found a well that was plugged without a plugging application. And that's referenced in your exhibit RD4. What did staff do to try and find this well?
I don't have these exhibits. It's just one big continuous exhibit. So where's RD4 start at? Is it the 82.3.117 or is it something else?
Yeah, it's 82.3.117.
Okay. I have that exhibit from it. And what was the question?
Well, you've alleged that operator plugged a well without obtaining permission, but you couldn't find the well, I believe is what the testimony is. I'm asking what staff did to find the well.
It appears here that the staff went out and visually inspected the leases and could not locate this well. And this well, it states here, has no CP4, CP23, which means the well was either plugged and cut off because a CP1 was filed and scheduled to plug on November 19th of 2019. So when we did our inspections, the well is no longer at the location that it says this well is at. The operator never reported, called in and scheduled the plugging or filed a CP4. So either the well got plugged and they actually cut it off below surface, or it's disappeared because it's not in the location of where it says it's located per operator inventory.
Did staff excavate the site to confirm the well had been plugged?
No.
So staff doesn't actually know one way or the other if this well is plugged.
Staff does not know if this well was is plugged or not. We know it's not above ground at the location stated on the inventory.
Well, if staff doesn't know it's not plugged, how can that be a violation of plugging well without permission?
In my testimony, can you take me to that?
I'll just
This is exhibit.
withdraw that question. It's not. I think the point's been made. I do find it odd that staff was found or alleges to have found 303 TI violations, but thinks that operator would plug a well and not tell it. Do you think that's strange too?
Objection, argumentative.
I'll withdraw the question. Moving on to your pre-filed testimony, page 11, lines 17 through 20. This is exhibit RD5. Just let me know when you're there, Mr. Dueling.
Page 11, line what? I'm sorry.
17 through 20. These are the 120 violations.
Okay.
I believe in the exhibit itself, there's a reference to that says that operator is the working operator of the Beechner #1 well. That's a term I'm unfamiliar with. What does it mean to be the working operator?
Back in there's an RBDMS, which is a database the KCC has. There's an operator and working operator. The ACE Energy was listed as the working operator back in 2017. I don't know the exact date. When they did the transfers of this lease, this well was left off the transfer. And there's a note in RBDMS that they were listed as a working operator back. I don't have that date in front of me, but they would need to supply a T1 to get that out of the working operator into actually on the operator's inventory.
I apologize. I didn't follow that. What does it mean to be a working operator?
It means that they were working the well and not being on their actual inventory.
That's what. I didn't mean to cut you off. Go ahead.
No, what?
You said that they were working the well, meaning they were using the well, but it wasn't on their well inventory.
Correct.
What was done to establish that operator was using the well?
I would have to go field report. It shows it was producing when we was there. So,
When was
from
that?
this exhibit, we would have to go to field report 8232 on the Beechner. But tell me what date, that we did the field report.
Is this something that occurred while during this January 12 to 25 inspection, or something unrelated to that?
As far as being producing,
Whenever it was
I believe
identified that operator was the working operator.
that was identified back in 2017 that he was a
Oh.
working operator.
Okay. And this testimony says that it's a water supply well, which means that, I mean, it's used to produce water to provide support for enhanced oil recovery operations, correct?
That's what a water supply well is. That is correct.
And you've indicated that this Beechner number 1 well is API number 15037 22201. Correct.
Correct.
I'm going to show you the KGS report for this particular well. So I've got here in front of you the KGS record for this Beechner well. And we zoom in. Okay, can you see that okay?
Yes, sir.
This is saying that it's an EOR well, correct? And I'm sorry, this is exhibit AX7.
Well, what that says is when the intent was filed, it was filed to be drilled as an EOR well. Just because it says it's EOR well on that does not mean that it's an EOR well. Where it says well type, is that what you're talking about? Where it says EOR?
Yes.
Yeah, whenever you file an intent to drill well, that well type is, you have to mark what type of well you're going to be drilling, whether you're going to be drilling an oil well, a gas well, saltwater disposal well, EOR well. That well type there means that was intended as an EOR well.
You're telling me if this well had been intended as an oil well originally and it had been converted into an EOR well, it would still show as an oil well?
No, because they changed the extension from 0000 to 0001.
And why do they do that?
How do they do that? That's probably
Why?
more of a better question to ask either Dwayne Sims or Todd Bryant. But when you drill an oil well and you want to convert it to an EOR well, you have to do the proper paperwork and file for a permit. And then the API number the last 4 extensions, which is not showed on this exhibit, will change from 00 to 01.
But according to you, when it's converted from an EOR well, which is a well that accepts water for injection and has numerous reporting requirements, when it's converted to a water source well, the records aren't updated to reflect that?
Well, what I'm saying is this well was never an EOR well because it does not have a permit. So even though it might have been classified and drilled as an EOR well, it was never authorized and permitted that I see anywhere.
Where are you coming up with that?
Well, where am I coming up with it? Because
Yeah, I don't mean, what are you seeing that would lead you to believe that?
there should be a place on this form for KCC permit number at the bottom. I believe that's the number. If it was an EOR well, there would be a docket number. Either if it's an E, it would start with an E.
And the Beechner 1 lease is not an enhanced oil recovery lease?
I didn't say it was I didn't say there wasn't no wells on there that it makes it enhanced recovery. I'm saying the Beechner number 1 is not an EOR well.
Okay, but the Beechner lease is an EOR lease.
I would assume that has EOR wells on it. I
Okay.
do not know without going and looking at the field report and looking to see what wells were found, but I thought your question was, is this number 1 an EOR well?
The difference between an EOR well and a water source well is quite apparent from the surface, is it not?
Is what?
It's
I'm
quite
sorry?
obvious from the surface that an EOR well and a water source well are not the same thing, right?
That's correct. Should be if it's equipped. If it's not equipped, it'd be hard to tell. If it's just a casing sticking above the ground, then you might not be able to tell. But if it's totally equipped either way, you should know whether it's EOR or water supply.
Well, this well was equipped because you in the exhibit it says it was producing water.
Which would make it a WSW well, water supply
Right.
well, correct? Mm-hmm.
Well, I guess what I'm wondering is if staff didn't look at the wrong well, because according to KGS records, it's an EOR well, and according to your records, it's a water source well.
Well, what I'm saying, this exhibit here that you classify number 1 as an EOR well, I would like for it's not an EOR well because there is not a permit authorizing that as an enhanced recovery well. So it's not an EOR well. I mean, I can tell that it was filed as an intent to be drilled as an EOR well, but to be an enhanced oil recovery well, it should have a permit. And if not, then it's not authorized to be used as an EOR well.
Right, and we've already established.
If that makes sense.
It makes sense, but we've already established that
Okay.
this is an EOR lease.
Well, you just said lease and not well. I didn't say that there wasn't EOR wells on the lease. You was asking about number 1, correct?
I'm ready to move on from this, Mr. Dueling.
Oh, okay.
The page 12, lines 6 through 10, deal with KR 83-400. You've got a list of wells on here that are again hooked up for injection. Did you personally observe these wells actually injecting water into the ground?
Me personally, no.
In your testimony at page 12, lines 18 through page 13, lines 2, you talk about a couple of spills that are described on RD7, exhibit RD7, in violation of KR 823603. I'd like to direct you to that testimony.
Okay. I'm getting there. What, let's see. Page 11, or I'm sorry, page 11, 18, line 18, is that correct?
Starts on 1218 of your direct testimony.
I apologize. I'm on 12. Sorry.
Okay. These are wells that were supposedly had spills that were cleaned up but never reported. How much fluid was spilled here, according to your records?
We would have to go back and investigate the field reports. Obviously, I would be able to tell you if they would have been reported because we document spill reports, especially in case EPA or anybody's contacted. So, I mean, I do not know if I have exact documentation of fluids because there was never a spill reported. And so I do not have answers to that question.
You don't know how much fluid was spilled, allegedly?
We could go back and review the field report to when we found the spills.
That's attached to your testimony, isn't it?
I'm sorry, what's attached to my testimony?
Isn't the field report what exhibit
Yeah.
RD7 is?
The field report is attached to my testimony, yes.
Okay, can you look at it and tell me how much fluid was spilled?
Well, I don't know if it's documented in there.
Are all spills reportable regardless of volume?
It gets further than 6 feet away from the wellhead, they're supposed to be reported, no matter what the fluid or the amount of fluid is.
Does that
6
report say, oh, sorry. Go ahead. I didn't mean to cut you off.
If it's more than 6 foot from the wellhead, yes, it's supposed to be a reportable spill.
Does that say that on RD7 that the spill was 6 feet from the well?
On exhibit RD7?
Right.
No, but I'm pretty sure the picture in the field report would show that it's well further than 6 foot.
There is no picture attached to the field report.
Yeah, Mr. Schlatter and Mr. Dueling, just for my clarification, it looks like RD7 is just a listing. It doesn't include any field reports, correct? Are the field reports all included in RD1?
Yes,
Okay,
I believe so.
okay, thank you.
Just a couple last questions here, Mr. Dueling. How do you know there was a spill if it was already cleaned up?
Whenever staff did a lease inspection, and if you could you pull up that exhibit 603 for me real quick so I can take a look at it?
Sure. Give me a second here. Scrolling down to, what did we say it was, RD7?
I believe that's what you said. Yeah, it was 603 violation, I believe. Okay, the Allen Hauser #2. If you see that field report number over to the right, it says 8230.
Mm-hmm.
If you would pull that field report up on 8230 and look at the photos attached to the Allen Hauser #2, I believe you would answer that would answer that question that you had.
I don't have that field report. I don't think it's an evidence.
It's part of my pre-filed testimony.
Okay.
I do not know what page because I just have the field report in front of me or in my documentation here.
Well, I think the commission can take notice of that if it's been offered and accepted into evidence, so we don't need to get into that. I'm just wondering if it's been cleaned up, how do you know how much water was spilled and what type of fluids were spilled, if it was even oil or gas, or not gas,
Well,
salt water.
if you could bring up that photo in that field report.
I can't because I don't know where it is, and I don't.
It would be helpful to me, and I presume the other commissioners, to know which field report to reference while we're having this discussion. Could we give maybe Mr. Dueling and council a moment to find the field report? Because I'd like to look at it as we're.
Looks like there's.
Chair French, John Myers here. I have the report. Would you like me to pull it up?
Yeah, if maybe could John take over the screen share and just pull it up so we can see it? And I apologize for cutting in.
Give me one moment. All right. This, I believe, was the exhibit RD1 part 1, the very first page of it. It's from right here is where I'm grabbing it. Here it is. It says 8230 here. I think this is what you guys are looking for.
That's correct, John. And I don't know what I do not know what page it is. I apologize. But if you would scroll down to the photo templates, it would say Allen Hauser #2 under the subject.
It's on page 9.
That's it right there. there is a spill that was not reported by Ace Energy that you had to question whether it went more than 6 feet away from the wellhead or what type of spill it is.
You're saying that this spill is cleaned up?
I'm sorry, do what?
Your testimony is that this spill was cleaned up when the inspection took place. How could that be true if this is indeed the spill?
I think you misinterpreted on page 12 on 19 it said yes, staff found that 2 operator wells were in violation of 823603. Staff found 2 spills at 2 of operators' wells. Operator cleaned up the spills but never notified staff of the spills. That statement says that we contacted the operator when we found these spills. They went out and cleaned up the spills, but after I've told Mr. Frieden numerous times they have to be reported, they never reported them. So these spills were here, and they did clean them up after we finally got a hold of the operator to finally have somebody from their team come out and clean these up.
Okay, so these aren't.
But they never were reported. I'm sorry.
Well, you said they were out of compliance, and apparently that's not the case. Let's move on to page 13, line 3 through 7. This is 22 wells not on inventory within the area of review. This one caught my attention a little bit. Were the operators' wells here, injection wells, were they lawfully permitted by the commission?
There was, I'm guessing your question, would you repeat that so I make sure I get it correct?
Well, you say there's 22 wells within the area of review of operators' injection wells. And
that's correct.
Okay, but that these aren't operators not responsible for these wells, correct?
That is correct. Not at the, I mean, what we located was 22 wells within the AOR of operators' injection wells. Operator is not responsible for the 22 wells that we found. However, we could do wells that the injection wells that fall within a quarter mile of the 22 wells that are not on their operator's license until those 22 wells are brought into compliance. Does that make sense? Did I answer your question?
These 22 wells are not violations committed by operator then, correct?
Yeah, they're not the operator's wells.
Okay.
No.
How many other operators have been subject to that kind of review?
Could you I mean, I don't understand the question.
Well, you're saying, never mind, I'll withdraw that question. I don't think I have any more questions for Mr. Dueling.
Thank you, sir.
Thank you.
It looks like we may have lost a few folks off of our Zoom just now. I saw a bunch of names drop off. Let's take a brief recess to see if folks can rejoin. I know we've lost at least one commissioner. John, have you gotten any communications from anybody?
No, they really did all just drop. I think
Okay.
Mr. Dueling's screen froze briefly a moment before then too. So it might be related to that.
Let's just recess briefly and see who all rejoins. It looks like we've lost our IT staff as well, so that will be important. Let's. Oh, go ahead.
I hate to ask, but can I request? You said a brief. Could we request at least 10 minutes so I might be able to use the restroom facilities again?
Certainly. Let's stand in recess until noon, and then we will hopefully have everybody back by then.
Parties, please.
We're off the record.
Right. Parties, please keep in mind, we're still live streaming. It would take me a moment to figure out how to stop that. So just keep that in mind. Mr. Keith, we lost a lot of people there for a moment. So we went into recess and now we're gathering everyone again.
Okay, well, I'll just hang out here then.
All right.
Annie, we're in recess until noon, just so you know. We went ahead and gave everybody a quick break.
Then I'll stand up and stretch my legs.
Mr. Kimbrough, when we went into recess, we went to recess. There we go. The note says down there, we're off the record in recess till noon.
Okay. All right. Thank you.
Chair French, I believe in the last few minutes, everyone has rejoined.
And I was about to ask, I see two commissioners other than myself on here, which is good. And yeah, if either party believes they're still missing anybody, definitely flag that for me. But it does look like we've got a full contingent again. We've still got one more minute until noon, so everybody at ease for another minute. All right, before we go back on the record, my intention, I know we're at noon, but my intention, since we've gotten to the past cross-examination, I think we'll see about commissioner questions and then hopefully get through any redirect and any necessary recross, and hopefully still get everybody to lunch in a timely fashion. And then we'll start with the next witness after lunch. So with that, let us move. I believe we're ready for commissioner questions. And I will begin with Commissioner Keene, if you have any questions for Mr. Dueling. Oh, and I apologize. We are back on the record, and I will begin with Commissioner Keene for commissioner questions.
Okay. Good to go. Thank you. Almost afternoon, so we'll call it afternoon. Good afternoon, Mr. Dueling.
Afternoon, Commissioner King.
Let's review a couple of things just for purposes of overview from maybe 30, 60,000 feet. Isn't it correct? I mean, operators have to have their licenses once they obtain them, they have to be renewed annually, do they not?
That is correct.
That doesn't matter how many wells the operator has or where the operator is located within the state. The same requirement applies to all operators, regardless of size. Isn't that correct?
Yes, that is correct.
And part of the process of that license renewal process annually is an update of the well inventory for the operator who is renewing his license, is it not?
Yes, that is correct.
And so that was that. Tell me about that well inventory a little bit. If it's done correctly, it's going to demonstrate all of the wells that the operator owns. It's going to demonstrate the character of the well, whether it's a producing oil, a producer, whether it's inactive, whether it's an injector. Isn't that correct?
Yes, sir. That's correct.
There's quite a bit of detail there too. There's the GPS location of the well and a whole lot of other pertinent information for each of the wells on the inventory is shown on that inventory sheet, is it not?
I believe so. Yes, I believe that is correct.
And most importantly, as a predicate, basically, to the operator renewal licensing process, the operator has to certify that that well inventory is correct. And they have to affirm that under penalty of law, basically, that inventory is absolutely correct. Is that not correct?
No, yes, that is correct.
Okay. With that in mind, let me kind of pick your thoughts here. I guess what I'm trying to do is have you help me reconcile the operator's well count that appears on either the operator's inventory or the operator's contentions in the testimony that's been filed here today, or in the testimony that will be given here today. And I want to kind of juxtapose that maybe a little bit to staff field inspection results, if you will. Let me ask this question as a preface to going down that road. Under Kansas statutes and the regulations that govern conservation matters for the Conservation Division of the Corporation Commission, doesn't the commission staff have broad authority to enter upon any and all oil and gas leases at any time to conduct compliance examinations?
Yes, they do. That is correct.
And they can do that on their own motion, can they not? Doesn't have to be a complaint from the public. Doesn't have to be a complaint from a landowner. If they believe that there could be compliance issues, they're entitled to go into any lease, basically, for any operator and conduct an examination as thoroughly or as succinctly as they believe necessary. Is that not correct?
No, that is correct.
So help me out here. Let's go back to this well count situation. Do you recall how many leases does the operator have? Do you know?
Exact number, no, but probably 20 leases.
Okay. I'll develop that with other witnesses. What's the total well count for the operator, Ryan?
Oh, I have that in here somewhere. It's over 400 wells. I apologize. I don't know where it's at, but that number's in here somewhere.
I saw the number somewhere in your testimony.
I'm trying to get to that testimony, but
okay. There's no shortage of paper
here. Let's see.
Can I ask a quick question about the well inventory? What exhibit are we referring to? Keene.
I don't, John, I don't have an exhibit number. I don't have one.
Okay.
Is there a well inventory exhibit contained within these documents, Ryan? Do you know?
I do not know the answer right off the top, Commissioner Keene.
Okay.
Well,
sure. For purposes of clarity, Ryan, Mr. Dueling, page 10 of your direct testimony, you testify that operators well inventory lists 427 wells. That's at line 14. Is that what you were looking for?
Yes, it is. Where was that at again? Chair Keene,
it's page 10 of your direct testimony, line 14.
Yes. I knew that there was a number installed in my testimony, but I could not remember where. I apologize. But yes, Commissioner Keene, 427 is what the operator lists.
Okay. I thank the chair for his assistance as well.
Me too. Thank you.
And so it is your contention, going back to page 10 of your direct testimony here, that of that 427, there are 303 that are out of compliance with KAR 82-3-111. Is that right?
That's correct.
Okay. And by that, and by reference to that particular reg, what you're suggesting is that, or what are you suggesting? Are you suggesting that there are 303 inactive wells?
That is correct. Our field documentation documents 303 wells that are inactive and out of compliance with 82-3-111.
Okay. I have a question that's somewhat related to the question that Mr. Schleider asked of you. And if you've asked and answered it, I'm not trying to harass you by re-asking the question. My question, which I think you've answered in part anyway, but I'll give you a chance to re-answer if you wish, is what prompted the timing and scope of the field compliance review that's encompassed within what is your exhibit RD1, which is all of this field report.
Okay, I caught half of that, and I want to make sure I answer your question completely right. So would you rephrase would you not rephrase it? I'm sorry, repeat that question again one more time, please.
I'm asking you what prompted the timing and the scope of the field compliance reviews that you performed in January of 2023.
The time frame, or what prompted the inspections?
What prompted the timing of your doing that in January, and what prompted the scope to be as expansive as it was?
Legal staff had contacted us wanting us to do lease inspections on the operators due to a license renewal.
Okay. Fair enough. Incidental to the license renewal.
Do what?
Incidental to the license renewal application.
Yeah, I believe so. I mean, the reason we did these field investigations is legal staff had contacted us, asking us to do lease inspections for Ace Energy.
Okay. Chair French, I would ask you to consider one thing now. I'm not sure. We've been provided within the last couple of days with a number of staff exhibits that have not yet been entered into the record, and I wanted to ask Mr. Dueling some questions of one of those exhibits. Is there any way that we could at least have that offered and see if there is any objection to the introduction of that evidence?
I'm certainly not going to stand in the way of you asking questions about a document, and if it leads us into establishing a foundation, we can have it admitted. If the parties want to object, they can. But no, I think go ahead. That's certainly fine by me.
Okay. What I'm looking at, Mr. Dueling, if you can find it, it's staff exhibit number 5.
Our exhibit number 5.
It's entitled staff exhibit number 5. It's been something that it's been proffered within the last 48 hours. The title of the document I'm looking at is its updated Ace Energy LLC penalty orders.
Commissioner Keen, I could put that on my shared screen if that would be helpful.
I appreciate that, Tristan, but I don't think it's necessary. Maybe we should do that because it'll put everybody on an equal footing. So let's do that. That would be a good idea.
Okay.
Okay. Scan up just a little bit and see if we can get the other direction. See if we can get one page on full page. Go back one page. You did it. Okay. Do you see this exhibit, Mr. Dueling?
Yeah, I do.
This is staff exhibit number 5. It's a 3-page exhibit. This is page number 1. And this page, as well as the next page, which is page 2, and you can see that not quite so quickly. Please go back just a little bit. I'm sorry. The date, the docket for the first violation that's shown here is 16/5/34, and that penalty order was issued on September 17th, 2015. And then you see there's a series of violations here on this particular page that go through docket number 19-3220, which was an order that was entered on January 10th, 2019. Turn to the next page. This list commences again at the top with a penalty order 19-3252, which was issued on January 31st, 2019. And it goes through an order 24-3081, which is dated 10/3/2023. It needs to be noted that we've got some footnoting here. The bottom 4 orders are instances where the operator has timely requested hearings in these dockets, but we have not had hearings as yet. I believe that's correct, is it not?
That's what it appears, yes.
And then the 4 orders just above that are the dockets that are before the commission in the present matter. Isn't that correct?
1729 87. Yes, I believe that is correct.
That'd be 23-3017, 3029, 3087, and 3135.
That is correct. Yes.
So if we go on to the next page, then the last page of this exhibit. This, in essence, I believe, is a listing of all dockets that have taken some kind of action on the operator's license, primarily suspensions. And it shows suspensions from, I'm going by date here of the suspension, from 2016 through 2023. Is that correct?
Yes, sir. That's what this appears. Yes.
Okay. So basically, this is a summary, as I see it, of the operator's compliance and fine and suspension record to date. We have numerous suspensions and numerous penalty orders.
Correct.
You've already been asked the question, I think, by Mr. Slatter, about how many operators were within the purview of District 3. Without regard to that number, is it over 1,000? Do you remember how many there are?
I did not remember, but I remember telling him there's hundreds. That way I was not lying on stand. I did not know the exact number of how many operators in District 3. So I said hundreds of operators.
And you've been the compliance officer for District 3 for how long?
Going on 2 years.
And before that, you were an ECRS for how long?
I believe it was 18 years. I believe I've been with the KCC roughly coming on 20 years.
Okay. And has that all been in the District 3 office?
With the KCC?
Yes.
Yes, that is correct. I've been with the all my service with the Kansas Corporation Commission has been with inside the District 3 office.
Okay. Given that experience and given your present position as the compliance officer for District 3, is this volume of license suspensions unusual?
Say yes. That it's a long list of suspensions for one operator.
Going back to the 2 prior pages and combining those and disregarding the cases that are before us now. Just the matters that get run from basically September of 2015 through May of 2022, those violations. Is that an unusually high number of violations? the average operator in District 3 going to witness this many violations?
No, sir, they would not. This is a large list of violations.
Do you have any idea how many, if we can take the screen share down now, thank you. I want to turn to the exhibit that's a part of your testimony now, RD1. I've gone through every page of this exhibit. I have to concur with Mr. Slider. There appear to be one heck of a lot of hours dedicated to this effort. Do you know how many different KCC field techs or ECRS personnel have dealt in some fashion with Ace Energy?
Oh, over just these dockets here today? Is that your question, or for sent? I'm sorry.
Yes.
Um, 2, 3. I'm going to say probably 7.
All right. Okay, I'm going to ask you as the compliance officer for some conclusions that you would reach from the review of all of what is encompassed within RD1, the exhibit. From these KCC staff investigations, what, in your opinion, are the most prominent, serious, and repetitive types of violation? Generically, the types of violation.
Obviously, anytime a UIC penalty or recommendation is listed, that goes to the top of the list, Commissioner King. The inactive wells is a tremendous amount of list, but the UIC and not reporting spills is the 2 highest priority penalties that are listed out. Is that what your questioning is referring to?
Well, you're giving me the various types of violations. Yes, and you've given me 2. Are there more types that jump out at you as you read through this document, this RD1?
Well, obviously, I mean, I guess I'm a little confused on the questioning, and I apologize. I might not be comprehending what you're asking, but also, you know, there's I believe part of this is operating without on a suspended license, and to me that's a huge one also.
Well, let me ask you this. In your opinion, and I'm not trying to put words in your mouth here at all, in your opinion, is there a lack of temporary abandonment authorization for inactive wells?
Oh, obviously, yes. There's several wells, hundreds of wells that are inactive that lack CP111 applications.
Why is that a big deal? Is there an environmental concern associated with that? Why is that a big deal?
Sure there is. I mean, a lot of these wells, and obviously without going through each field report, I cannot give you the numbers. But a lot of the wells that are inactive are just casing sticking up above ground. There's no surface control. The well's not shut in. We do not know the fluid levels of where, you know, if that fluid is in the fresh and usable water zone as far as where the casing is. So that is a huge deal, because there's too many unknowns, without having an application for us to evaluate whether it should be approved or denied.
Okay. You had another concern you actually listed there in answering my last question that jumped out at me as I went through all of what's encompassed within RD1, and that's the lack of surface control. Why is that a big deal?
Surface control is a very large, big concern. I mean, the well, if it does not have surface control, is open to the atmosphere. Escape of gases or fluids, without being shut in. There's no way to contain the hydrocarbons or fluids in the casing.
Is it conducive to spills?
I'm sorry?
Is it conducive to spills?
Sure, can be very, very highly.
Has your investigation looked into the potential for any inactive wells on the operator's inventory that are shown on that inventory as active wells?
There's a lot of those that in this exhibits RD2 through, I believe it's 8. There's a lot of those wells that are listed on inventory as producing that are inactive. It's pretty easy for me to sit at the desk and run this database and be able to query out how many we have documented that the operator shows are active producing, and when staff did their field investigation were inactive without, with no, either no, not equipped for production or no electric to the lease. It's a great number, but I do not have the actual number for you. But there is a huge discrepancy in the well inventory that the operator certified compared to what field staff found during their investigations.
Could you make that determination and provide that to us?
Did I?
Could you?
I could.
Because there was another adjunct.
Do you want it today?
No, well, I not necessarily, no, but I think it should be a part of the record. That's all I'm concerned about, is that we have that kind of information that's a part of the record. The sooner the better would be great, because there was an adjunct, Brian, of the question I was going to ask you about the well count. Because if we really get down to cases here and we do some comparison with the well inventory that's submitted by the operator compared to the field examination that you conduct, or the staff of the commission has conducted, we have a lot of breakdowns here. We could try to determine of the total number of wells, how many injectors do we have? How many are inactive? You've got a fair number of those. I think you think are identified here, 303. So we do a little math, that'll leave 124, something like that. How many are producers? That's all kind of germane here, I think. Those are the, and of the inactive wells, pardon me, in fairness to the operator, how many of those have TA permits and how many don't? But no, I'm not expecting you to forego lunch or jump to that today necessarily, but I would like to see that as part of the record. If you could provide that information to all parties, provide it to the operator, provide it to the staff and to the commission. I'd appreciate that.
Okay.
Mr. Chairman, I believe that concludes all of my questions for Mr. Dueling.
With that, we will turn to Commissioner Keither. Do you have any questions for Mr. Dueling?
Sort of ish. With the last question from Commissioner Keene on some information about inactive wells, if I'm reading correctly, you have comments down below the photographs about TAs, and that the Kansas Geological Survey has reported on this, as well as Evergy, whether or not there's any power going to the well. Am I correct?
I believe that's correct. You're asking on every photo that we provide, is that information supplied to that photo?
Well,
I apologize. I'm not understanding 100% the question.
well, just to point out that as a matter of record, on several of your photographs, that information is provided.
That is correct.
Okay,
Yeah, I'm not going to say on every one of them, but majority of them
but
has.
you have many of them, that information is already provided.
Yes, ma'am.
And I following up, it's not really a question, but if there's anything to add, please do. Environmental concerns, the impact that inactive wells are having without, I immediately thought of groundwater, but had not thought about gases and fluids at the surface. But just to be clear for me, the operator is obligated to report the status of all the wells they control. Correct?
That is correct. Yes.
And so right now, out of 427, 303 are out of compliance. And that was not reported. You had to discover that.
That is correct.
Okay, that is correct. Okay. And so you discovered that because staff, legal staff gave you that information, and how did they get that?
No, I evaluated
that.
that. I evaluated and got those numbers from the field reports that were constructed by District 3 staff.
Gotcha.
They went out and inspected every lease, every well, documented that information, and then I helped them put that information in these field reports that are RD1 exhibits.
Gotcha.
And then I went back and went through every field report one by one and listed all the violations that were found at the time of those inspections. And that's where the 303 wells we found that were out of compliance.
I appreciate those answers, and Chairman French, that's all I have at this time. Thank you very much.
Thank you, ma'am.
Thank you, Commissioner Keither. I do not have any questions for you, Mr. Dueling. So at this time, let me turn to Mr. Kimbrell and ask if you have any redirect.
I do. Not that many questions, Chair French. Mr. Dueling, if we could start, I'm going to share my screen. Do you see the penalty order in 22-3410 that was discussed earlier?
Yes, sir.
Okay. And scrolling down to where it says the commission orders, what did the commission order the operator to do in this penalty order?
The commission ordered the operator to pay a $300 penalty and either plug, return the well to service, or obtain TA status for the wells, the 3 wells in this order.
Okay. And I think there were some questions about a deadline to do that. So turning down here to D, what does that last sentence say that's underlined? Oh, sorry, the sentence before that. I apologize. The sentence before that.
Okay. Yeah. This order states that they have 30 days from the date of this service to either request a hearing or the order becomes final.
And so if the order becomes final, is that providing a deadline?
It is. That's giving them when this order is put out, they have 30 days to either request a hearing. If there is no request a hearing, that next sentence, I believe it's on down in E. If that is correct, it didn't say if they waive the operator's right to a hearing, then the order shall become final. So that 30 days gives them the chance to either request a hearing or the order becomes final, as stated.
Thank you. Turning now to that DR Nelson B2 TA application that you testified on earlier. Is this the record that you saw earlier of the submission of that TA application for the DR Nelson number B2 well?
Yeah, that appears to be the same exhibit.
All right. And did this come from Kohler?
Yes.
Chair French, I would ask that the commission take administrative notice of a commission record.
Any objection? Hearing none, we will take notice of the Kohler record.
Thank you. And when did the TA application?
Kristen, is that marked as an exhibit?
Yes, I should have pointed that out. Yes, it is marked as staff's exhibit 1, page 1 of 15.
Okay, we take notice of staff's hearing exhibit number 1, and it will become part of the official record.
Thank you. So Mr. Dueling, when was this TA application submitted?
On June the 11th of 2022.
And who submitted it?
Excuse me. Jonathan Frieden.
And do you remember when that TA application was denied?
Yes, I denied that TA application on July the 6th of 2022. I'm pretty confident in that date.
Okay. How long does it typically take for district number 3 to approve or deny a TA application?
That there's a lot of factors that go into that. The District 3 deals with over 2,000 temporary abandonment applications a year. We have a district policy that we want all TAs, once they are received, to be either approved or denied within 30 days with a deadline of no more than 45 days from the submitted date. We strive very hard to get through all the applications within 30 days, and there is a few that will fall within up to those 45 days from submitted, but we strive very hard to get all the TA applications approved or denied once they are received within 30 days of the receival date.
And did you deny this TA application within that 30-day deadline?
Yeah.
Thank you. I'm going to turn to the 2017 penalty order really quickly. And under the findings of facts, it states that the commission suspended operator's license on June 21st. Is that correct?
Yes, sir.
All right. And under the findings of facts, does it say that operator didn't pay the $300 penalty until June 22nd?
Yes, that is correct.
So was that $300 penalty part of the order of that 22-3410 penalty order?
Yes, it was.
Okay, thank you. I'd like to turn really quickly to temporary abandonment wells. So this is the Allen Hauser number 1. Well, is this a picture of the Allen Hauser number 1 well?
I'm sorry. Did you ask a question there, Tristan? I cut
Yes.
out.
Oh, sorry. Is this an accurate representation of the Allen Hauser number 1 well?
Yes. I mean, that's a picture that staff took of the Allen Hauser number 1, and that is the photo that's attached to this documentation.
Okay. And did the notes underneath say that KGS found that there were no reported oil sales since 2020?
Yes, that is correct.
Okay. And I'm going to enlarge the picture a bit. Can you tell us what we're looking at here in this picture?
Yeah, it's a 2-inch well that's open to the surface. As you can see, the casing head is sticking up above the ground and open. It's not shut in with the swedge and valve.
So do I understand that this has no surface control?
That is correct. There is no surface control on this well.
Okay. And can you state with any knowledge whether this well was in compliance with commission regulations on November 28th of 2022 when operator submitted this license renewal?
Would you repeat that real quick? I'm sorry.
Sure. So would you be able to state with any knowledge whether this well was in compliance with KR 823111 on November 28th of 2022 when operator submitted his license?
No, this well was not in compliance. The well operator's well inventory showed this as a producing oil well, and there was no CP 111 filed for temporary abandonment.
Okay. And do you have any idea of roughly how many other of those 303 wells you identified as being out of compliance with 111?
Oh yeah, total wells 300. I believe it was 303.
All right. And do you know approximately how many of those were out of compliance on November 28th with 111?
How many of those were out of compliance on November 28th? Is that your question?
Yes, with KR 823111.
I'd like to make an objection on the grounds of foundation. He has no personal knowledge of any of this. He's already testified that he doesn't.
These are commission records that have already been admitted to the record.
To the extent the basis is in the documents, and that part of his job is to order these documents to be created and to review the documents and ensure compliance with commission regulations, then I'll allow him to answer.
All of them.
All right, thank you. Moving on.
Just following up on that objection, that answer is absolutely not supported by the document on file. I think that needs to be stricken.
I'm not sure what the basis of that objection is. Mr. Dueling is testifying to his understanding of the exhibit.
I guess my point is that Mr. French made a ruling, or Chairman French made a ruling, that to the extent it's reflected in those records, he can testify to it. All of those records do not reflect that the wells were out of compliance on November 28th. That the documents speak for themselves. That answer cannot be true.
I think I'm misunderstanding what you're saying. Are we talking about just the 823111s? So we're just talking about the TA violations.
Yeah, I'm going to overrule the objection. Mr. Dueling is interpreting the documents, and his interpretation is as reflected in his answer. The commission can evaluate the weight it wants to give to that.
Okay, Mr. Dueling, is this a picture of the DR Nelson number R2 well?
Excuse me, I'm sorry. Could you repeat that, Tristan?
Is this a picture of the DR Nelson number R2 well?
Yes, sir, that is.
And was this one of the wells that you had listed as being an unauthorized injection well?
That is correct. This well was listed as a fully equipped, authorized, active EOR well.
But did it have a permit?
No, it's unauthorized.
Okay.
It does not have a permit.
Okay. I'm going to make the picture a little bit larger here. So we had a question earlier about check valves. Can you explain what a check valve is?
Yeah, a check valve is designed to be installed in the line that will only allow fluid to flow one direction. The check valve that's installed on this well, and it's kind of hard. I wished I could just point and show. But if you see the wellhead coming up and the ball valve that is open, follow that up to a T, and then come back to the left. The first valve that you come to is the check valve. And if you notice on that check valve, the little round circle over to the left-hand side, that is where that check valve pivots. It is angled to show where the flow of fluid push the check valve up, only allowing fluid to go down into the wellhead. And then the check valve will close when there's no pressure behind that.
So is this a valve that you have to open each time you want to inject fluid?
It automatically opens.
All right, thank you. Are there any other valves that you can see visible in this picture?
Yes, there's two ball valves, one attached to the swedge above the casing. Actually, I guess there's three ball valves. There's one from the pressure gauge on top of the cross T to the right that is closed. That is just open-ended. It's if they need to release the pressure off the line and wellhead, they can do that with that valve. Then you go all the way to the left where the riser comes up above the ground. There's another ball valve installed there that's open from the elbow. And then I believe there's another twin screw valve in between the actual water meter and the check valve that is a pressure to allow how much fluid can travel.
Okay. And are the valves leading down into the injection well? Are they in the open or closed position?
Yeah, they're open.
So if water was going through this injection line, would there be anything to stop it from going down into the well?
No.
I'm gonna stop my screen share. We talked a little bit about exhibits RD2 through RD8. Can you explain again how those were created?
Yeah, after field staff gathered all the information and constructed the field reports that's in RD1, I went through each field report and documented each violation that field staff found throughout the lease and put it in this database so I could query out the different violations from the reports, which are the exhibits RD2 through 8.
Okay, so you compiled those RD2 through RD8 yourself?
Yes.
And as compliance officers, do you ever compile lists of violations for other operators?
Yeah.
All right. We talked a little bit about, testified a bit about other previous license reviews. And I believe you said Haas and Keto, district number 3 had done reviews of all of their leases. Is that correct? Is that what you testified to?
Yes, sir. That's correct.
And why did district staff perform inspection of all of their leases?
I know one of them was actually a request from the commission. They were both but I believe both of them were for license renewal applications. But I know one of them for sure, if not both of them, was request to do lease inspections to evaluate and see if there was any violations the operator was in violation of any regulations.
And did I understand you say that both in Haas and Keto, it was license renewal
Yes.
questions?
Yes, it was.
I'm going to share my screen again. And I know we've already seen this. Is this still a picture of the Allen Hauser number 2 well?
Yes, sir.
And it's showing a spill.
Yes, sir.
And I believe there's some question on whether Ace Energy was still in violation regarding that spill. Is Ace Energy still in violation of a commission regulation for some reason on this well site?
I mean, yeah, all spills are supposed to be reported. There was never a spill reported to the district office from the operator. Luckily, staff, when they did investigations, came across this and reached out to Ace Energy, and they did come out and stop the leak and clean the spill up. But you know, all the violations that was notated in these field reports there has not been penalty recommendations sent for all of those. But yes, they never did file any spill reports.
Why is it important for an operator to file a spill report?
It's actually, I said spill report, but actually call in the spill, report the spill. That way, not only staff knows about the spill, but we can work with the operator to make sure that the spill is cleaned up properly, and that we have, eliminated as much chance of contamination or anything. So that's why it needs to be reported to the district office. And there's also, I'm sorry.
No, please go ahead.
And I'm just assuming, since it wasn't reported to the district office, that the landowner was not notified, which is also mandatory on a spill, CASONA form.
Okay. As compliance officer, do you enforce settlement agreements with operators?
Do I enforce settlement agreements?
Do you keep track of an operator's movement towards completing a settlement agreement?
Yes, I track. Yes, I do.
How does it typically do? A settlement agreement typically have a certain number of wells need to be brought into compliance per quarter. Is that how a settlement agreement usually works?
Yes, that is correct.
And for a typical operator in District Number 3, how many wells are supposed to be brought into compliance per quarter?
Each settlement agreement will be different, and it'll be evaluated on the amount of wells, the style of wells. But I would say majority of the compliance agreements that we deal with is anywhere from 3 to 5 or 6 wells per quarter.
And I'm bringing up the email from staff's counsel regarding a settlement offer. And looking down here, the settlement suggests that Ace Energy would bring 50 wells per quarter into compliance. Do you consider 50 wells per quarter to be something that any operator in District 3 could manage?
No, sir.
Okay. I have no further questions at this time.
I'm still intending to get completely through this witness, but I think maybe we plowed a little new ground in commissioner questions. So I want to ask Mr. Schlatter, do you have any recross, or if you do, is it substantial?
I got about 3 questions, which maybe end up being 15, but I promise you I'll try and keep it at 3.
Why don't you go ahead?
Okay. I'm going to republish what was marked as staff exhibit number 5. Let's see. God, I'm terrible at this Zoom. Can we see that?
I can see it. Can you make it full screen on your screen?
So every time I publish it, it puts this bar over all of the things that control the PDF. So I can't change the PDF, and it's such a mess, and I don't know how to fix it. Yeah. Okay. Sorry about that. This is staff exhibit 5, Mr. Dueling. Mr. Keene asked you some questions about this earlier. Pages 1 and 2 detail each and every penalty order of Ace Energy dating back to September 17th of 2015. And going down until May 10 of 2022, which is docket number 223410. That's the last docket before we get to the dockets that are at issue today. Are you following which dockets I'm talking about, Mr. Dueling?
Yeah, I believe so. Yes.
And since visually we can't make a record, but I will just go ahead and do that to assist. Starting here and going to here. Those are all the dockets that were on this report that predate the dockets that are the subject of this hearing today. Isn't it correct that every well subject to these penalty orders was brought into compliance prior to this docket being commenced?
I am going to say that I assume that is correct because operator's license would probably be suspended if they had not brought those into compliance.
And all of these fines would have been paid as well for the same reason, correct?
I'm going to assume yes. I do not know that. I never deal with the collection of any penalties that are assessed by the commission.
And these dockets here that were before the commission, I believe the testimony in the record is that they are all the wells subject to those penalty orders are compliant.
Repeat that.
These wells with asterisks next to them are the ones that are the subject of this particular docket. Every well that is the subject of those penalty orders has also been brought into compliance, correct?
I don't believe so, no.
Well, that's the testimony in the record, well, or to be in the record.
Well, that's, I don't know how you bring unauthorized injection wells into compliance without getting permits. So I guess I'm not following your question. I apologize.
Well, those were all unhooked according to staff's discovery responses, and that's all that was asked of operator. I can call up that report if you'd like. This is exhibit AX 11. It's dated August 23rd, 2022. It's an email to you, in fact, from Mr. Boyer that says all 5 of the wells subject to that particular docket have been unhooked.
Okay.
Is that satisfied that those were in compliance?
Well, they weren't being used for injection. So assuming that they are shut in and have TA applications approved on them, then they would be brought into compliance. I would have to look to see if the operator filed CP 111s on them.
What about compliance under this docket, which was for unauthorized injection?
Well, those wells, I can't say that those wells you asked if all those wells are in compliance. Those wells did not change. That's the same well number. So I would have to pull to see if the operator filed a CP 111.
It's not in dispute, Mr. Dueling. Every well, each one of these penalties ordered have been brought into compliance at the time when this docket was initiated. Each one of the wells under docket 233017, all 3 of those DR Nelsons, we already went through this, were compliant. The MITs on those 2 wells, the EC Larson wells, those wells were plugged. That's already in the record. The 5 wells we just talked about were unhooked per your direction. That's all that was asked for in that penalty order. That's compliance. And then this one is after the date that this docket was commenced, 12/1. So each of these 3 here, all those wells were in compliance as of the time this docket was commenced, November 30, 2022.
Objection, Mr. Schleyder's testifying and it's argumentative.
Yeah, I'm going to sustain the objection. I think, Mr. Schleyder, you've indicated that you believe that there are no facts in dispute here. So I think we can probably move forward.
That's fine. It'd be a lot easier if the questions would just get answered. And we've already gone through this. Instead of having to argue my questions, it's very frustrating. I apologize, but it would move this thing along a lot quicker if the witness could answer questions that are asked.
Objection again, Mr. Schlatter. It's not appropriate to be testifying like this.
I'm not testifying. I'm not under oath. I'm just expressing my frustration with how this is going. Facts are not in dispute. I shouldn't have to continually ask questions about it. That's all I'm saying. I'm moving on. So as of November 30th, 2022, the date staff filed its motion, every well on this list subject to the penalty order was compliant. Moving down here, this is a list of license suspended. Scrolling to the bottom. On 11/30/2022, the date staff filed its motion to deny operator's license. Every single license had been reinstated, correct, Mr. Dueling, according to this report?
According to this report, yes, the license was not suspended.
And that indicates that those dockets were then brought into compliance, correct?
That's what I assume, yes.
Okay. You testified that each of the 303 wells you allege are subject to TA violations, immediate threats to pollution. Is that a fair statement?
Yes.
You inspected all 303 of those wells, and how many spills did you find?
I didn't inspect any of them. I evaluated all these off of the field reports from staff that did the field investigations.
Okay, how many did staff find? How many spills?
I know of at least, I believe at least 2.
Thank you.
That
That's all the
was
questions
not
I have.
reported.
That's
Oh,
all the
sorry.
questions. That's all the questions I have.
Thank you, sir.
At this time, are there any commissioner follow-up questions to any of the redirect or recross? I see a shaking of a head from Commissioner Keither. Commissioner Keen, any follow-up?
With your indulgence, Mr. Chairman, just very briefly, I would let's go back. Let's put up the prior exhibit that was just on the screen. If you can do another screen share on that again. This is staff exhibit number 5.
I can put it up.
Okay, please. Thank you, Tristan. Yes. And once again, that's page 3 of 3, and it shows a list of all the suspensions. And I think, Ryan, my question to you is this. I think Mr. Schneider was indicating that for each of these suspensions, except for the last 2 on the page, there was remedial action taken such that the license was reinstated as of the date on the far right-hand column on the page. Is that correct?
That's correct.
But all that evidence is that as of that date, there was compliance. It doesn't indicate that there would be compliance in perpetuity thereafter necessarily, does it?
Correct.
Ryan? Did
Yes.
you respond? Okay. And then if we go back to the 2 prior pages, either one of them is fine. That's fine. The next page is similar in effect. This indicates the types of violations and the penalty orders that were issued by the commission incidental to these violations. And I think, did I understand you correctly that your conclusion was that in all probability, each one of the failures here that's noted in these violations had been remedied, or else there would have probably been a license suspension attendant, the non-compliant response to the order. Is that correct?
That is correct.
So once each one of these was corrected, much as this would be the case in the license suspensions, that only says as of that one point in time that there is compliance. That doesn't say prospectively in perpetuity that there's going to be compliance, because there's ongoing activity on each of these wells, each of these leases, each of these.
Potential.
I don't know. My screen
Frozen on
froze.
my
Can you hear me?
screen.
Okay, you're
You're
back. now.
back.
Yeah, Commissioner Keither, she was frozen for a moment. I can see you, Chair French. Brian, did you answer my question or did you hear it?
You froze up about a third of the way through it. I apologize. I really don't know what the question is.
Well, I'm sorry for that, because I'm going to give you the abbreviated version. Just
Okay.
as was the case with the license suspensions, is it not true that with respect to the penalty orders, that the probability is that the violations here were remedied, or there probably would have been a subsequent order by the commission incidental to the failure to remedy these problems? Is that not correct?
That is correct.
And that even though those problems were remedied at that point in time, that doesn't provide any assurance that prospectively those kinds of violations will never occur again. Is that correct?
That is also correct. Yes.
I have no further questions. Thank you.
Thank you.
All right. If there are no further commissioner questions, this is staff's witness, so I want to give Mr. Kimbrell one final opportunity. Do you have any final redirect?
No, I have no more questions. Thank you.
Okay. All right. At this time, we will conclude the testimony of Mr. Ryan Dueling. Ryan, you may virtually step down.
Thank you.
And thank you. And we are going to take a break for lunch. I'm sorry it took us till 1 o'clock to get there, but we are now off the record and in recess until 1:35 for lunch. We will be back at 1:35. Welcome back, everyone. Looks like we have all the parties. Please speak up. I see we have Jackson Ely. Is Mr. Schlatter still here with us, or do we expect Mr. Schlatter to be absent this afternoon? Jackson, do you know? And Mr. Ely, you are on mute if you're trying to respond.
All right. Give us a second here, Chair French. We're getting back on.
As much time as you need. Thank you.
Okay, sorry, I'm a few minutes late.
That's okay. That's okay. We may have dropped you off. All right. It looks like we have everyone. I'm not seeing. We've got both commissioners. We've got staff. John Myers, you think we're good to go?
I do, yes.
Okay, very good. The last thing I want to do is start in cyberspace without everybody here. So we are now back on the record in this hearing, and staff, you may call your next witness.
Thank you. Staff calls Nancy Borst.
Good afternoon, Ms. Borst.
Good afternoon.
Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Tristan, the witness is yours.
Thank you. Ms. Borst, could you please state your full name for the record?
Nancy D. Borst,
By whom are you employed?
Kansas Corporation Commission,
What is your work address?
266 North Main, Suite 220 in Wichita,
What is your work title?
Administrative Specialist.
Are you the same Nancy Borst who caused to be filed in this docket direct testimony consisting of 6 pages and 4 exhibits, as well as rebuttal testimony consisting of 4 pages?
Yes, I am.
Was this testimony created by you or at your direction?
Yes, it was.
Are the exhibits NB1, NB2, and NB4 attached to your direct testimony commission records?
Yes, they are.
Was exhibit NB3 taken from the Kansas Secretary of State's website?
Yes, it was.
Are you familiar with KSA 55-155 and the associated commission regulations?
I am.
As part of your job duties, do you regularly apply KSA 55-155 and the associated commission regulations to oil and gas operators in Kansas?
I do.
Now that you are under oath, do you have any corrections to make to your testimony?
I do not.
If I asked you today the same questions contained in your testimony, would your answers be the same?
Yes.
Do you swear the answers contained in your pre-filed direct and rebuttal testimonies were and are true to the best of your knowledge?
Yes.
Thank you. At this time, I move for the admission of Nancy Borst's pre-filed direct and rebuttal testimonies to the formal record.
Any objections?
Subject to the prior objections, no objections, and your audio is doing the same thing it was doing earlier. Chair French.
Or am I? Yeah, it's still lagging. Okay, we have noted your objections as in the written motion to strike. Again, those are overruled, but they are noted for the record. And so we will admit the testimonies of Ms. Borst. With that, we will turn to cross-examination.
Thank you, Chair French. Good afternoon, Ms. Borst.
Good afternoon.
Again, I'm going to just dive right into it because we've got daylight hours burning here. So if you're ready to go, I'm ready to go.
Do it.
Okay. So I want to look at one of the exhibits to your testimony, Ms. Borst. I'm trying to call that up right now. So if you could bear with me a second. This is your pre-filed direct testimony. Getting better at this. Okay, this is your pre-filed direct testimony, Ms. Borst, that was just offered and accepted by the commission in this docket. I want to scroll straight on down to your exhibit NB4. This demonstrates that you accepted Ace Energy's license renewal application on November 28th, 2022, correct?
I put it on hold on that date.
Oh, thank you for clarifying that. It was submitted and you reviewed it and put it on hold that day.
Correct.
Okay, and at whose direction did you put it on hold?
Initially, I put it on hold at my own because it was incomplete.
Okay, what was incomplete?
He's asking for 2 rig tags, and he has failed to provide me any proof that he owns these rigs.
Okay. Has that been corrected to this date?
No, it has not.
At the bottom here, or on the second page of this, it says that Ace Energy submitted total cash obligation of $3,750. Was that accepted by the commission?
The payments all go through CanPay. That is out of our purview at the commission. That's another entity that handles that.
Those funds don't belong to the commission, are accounted for by the commission?
Well, they do, but the payment is made through CanPay, and I can't tell you how those funds then come back to us. I'm not privy to that.
If these funds, I mean, Mr. Frieden or Ace Energy's application has not been approved, have these funds been returned?
No, they have not.
Okay. I want to use your testimony because you have the statute cited in it. And so I'm going to go to page 2, line 22 of your testimony. Oh, that's not right. Oh, I'm sorry. So the premise of docket 233143, and I am at page 2, line 20 of your testimony, is whether operator's license renewal application complies with the requirements of 55C4, correct?
Correct.
And here is the statute I was referencing here earlier, which I believe is KSA 155C4. That starts at line 3, or at page 3, line 5. And what you've done, I believe you've essentially copied that provision from the statutes.
Yes.
And so these are the requirements of 155C4 to obtain or to have a license application renewed. And I think what's at issue in your testimony is what I'm going to refer to as the combination parties, which are these listed at item number 4 here, which are any spouse, parent, brother, sister, child, parent-in-law, brother-in-law, or sister-in-law of the foregoing is a member, partner, officer, director of a operator who is not in compliance with commission regulations. Is that
a question?
Well, am I understanding that correctly, that's the crux of one of your concerns, is that some other operator, in this case SX54's non-compliant, should be imputed to ACE pursuant to this statute, specifically the item number 4 there?
No, it would be item number 1.
Item number 1, the applicant is not compliant with commission regulations. So how does SX54 fit into this then?
Well, Mr. Frieden is listed on that license as a contract operator, and I think that is the origination of the concern that legal staff expressed to me when they asked me to hold this license.
I'm going back to where are you seeing that in the application? And I'm sorry you can't drive, so just tell me to scroll up or down.
You need to go down to the SX 54.
That's
Agreement
it,
application.
54. Okay. All right, that is exhibit NB4. Okay. Now show me what you're talking about.
So if you'll scroll down just a bit more under representatives,
Mm-hmm.
you see emergency contact, owner of Ace Energy, LLC, parentheses, contract op, parentheses, Jonathan Frieden.
Okay. And I guess back to the statute here, which one of these categories here is contract operator?
Well, I think the inference is some sense of ownership.
Can you explain that?
If someone has some level of ownership, either a member, director, partner, officer in a company, that's what 55-155 is addressing. If they have any level of ownership, then if that license is in conflict with another license, that's where the problem lies.
But you said that you believe Ace Energy has entered into a contract with SX54.
No, that's not what I'm saying. It appears he has listed himself as the contract operator for SX54's wells.
And that to you means that he's an owner, member, director, or partner?
I think that's the conclusion I would draw, yes.
Okay, and how do you draw that conclusion? I guess I'm not following this at all.
Well, contract operator would seem to infer some sense of ownership, some sense of decision-making within the company.
Well, to me, it infers the opposite. Why would somebody who owns something enter into a contract with themselves?
It's just a term that sometimes gets used in the business. I can't speak to it more than on its face.
And you've not seen a contract that reflects actual ownership in SX54 by Ace Energy?
I have not seen a contract document. Is that your question?
Yes, you've not seen a contract between Ace Energy and SX54 that would indicate ownership, director, partner, member of SX54.
No, I don't see contracts.
Excuse me. I think I'm kind of following along here. And just to be clear, it's not, and I'm just going back to your exhibit NB4. It's not the fact that Ace Energy is listed as emergency contact that would make him fall under any of these combination rules.
Correct.
Other and bear with me, I did not understand that to be your testimony when I read it. So I'm kind of trying to make sure I'm covering my bases here. Okay, so is that the extent and scope of what you believe, how you believe SX54 non-compliance could be imputed to Ace Energy is the parens that say contract operator?
And Mr. Frieden. Yes.
Mr. Frieden himself.
Yes.
But he did not list himself as the contract operator. Ace Energy did.
Well, but he lists his name there.
Correct, because he is the owner of Ace Energy.
Correct.
Okay, what about the allegation that because Mr. Frieden's wife Rebecca Dragon Frieden is a resident agent. Where does resident agent fit into these criteria set forth at 1, 2, 3, and 4? There's KSA 55, 155 C4.
That statute doesn't address resident agents.
So are you no longer alleging that she could be an owner, manager, director of SX 54 because she's resident agent?
No, I'm just saying that 55, 155 does not address resident agents.
Okay, so why would Ace Energy's license not be allowed to be renewed because Mr. Frieden's wife is the resident agent of another company?
Are you asking about the renewal that I'm currently holding?
Yes. I am also referring to some testimony later that you submitted.
Well, the renewal that's currently on hold, as I mentioned, is incomplete. I also had a concern because he answered one of the questions incorrectly about whether his license had ever been suspended, and he said no, and I knew that not to be true. So that was a concern as well. And before any of that could get rectified, I was told to hold the license by legal.
Okay, and Mr. Frieden personally has never had a license suspended, correct?
Mr. Frieden is Ace Energy, so I would dispute that statement.
You would dispute that Mr. Frieden personally has ever had his license? Has Mr. Frieden personally ever had a license as far as you know?
In his name as an individual,
Correct.
not to my knowledge.
So absent any evidence, and I'm looking at your testimony on page 5, lines 3 through 11 here. You state that Mr. Frieden is also a member of SX 54. Then his license should not be renewed. There's nothing in the record that indicates that Mr. Frieden is a member of SX 54, correct?
I can't speak to that conclusively, no.
So you are aware of something that would demonstrate that Mr. Frieden is a member?
Well, the contract operator to me is a bit telling, but I don't know what it indicates beyond what it sounds like.
Beyond being listed as a contract operator, are you aware? Is there any evidence that you've seen?
I am not aware.
Okay, the second item here, I think it begins with page 4. I'm sorry, my notes are just not getting me to where I need to be here. This is all about SX 54. Okay, I think this is what I was looking for. line 516, I'm sorry, page 5, line 16 through 20. You state that operator's license cannot be renewed if the operator's license is suspended. At the time you accepted or put on hold Ace Energy's license renewal application, his license wasn't suspended, was it?
No, it was not.
And so the two reasons offered for putting his license on hold were non-compliant, or SX54's non-compliance and Ace Energy's non-compliance with commission regulations. Ace Energy was compliant at the time the application was submitted, and the only evidence of his relationship with SX54 is that he's the owner of the company that's the contract operator.
That's not correct. The reason his renewal was not done initially is because it was incomplete.
Other than that reason, did I properly state the rationale?
For me, it was because it was incomplete. When legal staff asked me to hold it, that's when I held it.
Did legal staff explain why it should be held?
They had concerns about renewing in light of his compliance record.
I'd like to turn to some of the rebuttal testimony that you submitted. Let's scroll down to page 3, lines 1 through 8. This is in reference to a phone call Mr. Frieden made to you. And I'll just proffer that at those particular lines, the phone call that he's referencing occurred in July of 2022. And the question is asked, do you recall this conversation? And your response is, the last call I received was in October 28th, 2022. What does that have to do with a July 6th phone call?
I never got a phone call from him on July 6th. I keep very detailed phone records of the phone calls I receive, and I did not receive a phone call. In fact, I haven't really spoken directly with Mr. Frieden ever.
You didn't receive a phone call from him in June of 2022 either?
No, sir, I did not.
You said you maintain meticulous call records.
I do.
I believe those were requested in discovery, but were not furnished. Do you know why?
Objection. Those were furnished to you in discovery, Mr. Schlatter.
Can you, identify? I don't recall seeing that.
I'd have to go through all of the discovery, but they were furnished to you.
We'll hold that question for now because I don't remember seeing any call records. Is that a practice of staff to keep phone records, or is that just your practice?
I think anyone in legal and as in the district offices as well keep pretty meticulous records for this very reason.
Okay. Well, the reason I ask is we also request Mr. Pierenboom's phone records, and we're told that none exist.
Objection.
That
This
was
is
the subject
irrelevant.
of a motion to compel that we had filed. So you never spoke with Mr. Frieden about the TA application for the D.R. Nelson V2 well?
No, I have nothing to do with TA applications.
What about the, let me see, I'm going to go to 316. This is a question that referencing Mr. Frieden made numerous calls to you regarding the EC Larson number 2 and EC Larson number 6 wells. I think that would have occurred in around July of 2022. Is it your testimony that you never you say you have no record, but you also actually did not talk to him on the phone. Is that your testimony?
I did not talk to him on the phone on those dates regarding those matters, no.
I have just a minute. I think I'm through all my questions with Ms. Borst. Other than we might need to hold back that issue on our discovery request. We'll review that and report back. But if I can hold her as a witness just for that limited purpose, I would appreciate that. But I think I've got through everything.
Can you hear me now? What we'll do then is we'll move to commissioner questions and any redirect. And Mr. Schlatter, if you're able to look in the next few minutes to see if you can find that discovery, I'm also inclined, if you can't find it, to maybe give you and Mr. Kimbrell just a few moments to confer to see if that was provided. I'd rather not have to bring a witness back. I'd rather release her if we can. So let us move at this point to commissioner questions. Either Commissioner Keen or Commissioner Keither, do either of you have questions for Miss Borst? And I'll start with Commissioner Keen.
Could we remove the screen share, please?
Yes, and I apologize. I've done that for hours today, and please just shout at me if I do that again.
That's okay.
Apologize for that.
Good afternoon, Ms. Borst.
Good afternoon.
I had no intention of asking you any questions, but the cross-examination by Mr. Schlatter compels me to ask you two. I'm looking at page 3, and we could maybe screen share this. That would be fine. It's page 3 of Ms. Borst's rebuttal testimony.
John, can you pull that up? John Myers, sorry. Thank you.
Okay. Let's look first at, that is it, in fact. Let's look at lines 9 through 12. And I'll read the question and your answer, Ms. Borst, if I could. This was from your rebuttal testimony on July 7th, 2023. The question is, you suspend and reinstate operator licenses as part of your job duties. Your answer was, no, I do not. My primary job duties include processing and reviewing license applications, processing open records requests, and processing legal filings. I do not suspend or reinstate operator licenses as part of my duties. And that was your testimony on July 7th. Is that your testimony today?
It is.
Scan down the page just a little bit more for me, John, if you would. That's fine. My second and last question references lines 17 through 23. And once again, I'll read the question and the answer for the record. The question you were asked is, has your recommendation regarding the docket changed based upon Mr. Frieden's testimony? Your answer beginning on line 19 is, no, it is not. I stated in my pre-filed testimony under KSA 55-155C4 and KAR 82-3-120G2, an operator's license cannot be renewed if the operator's license is suspended for being out of compliance with a commission order. Currently, operator's license is suspended in 2 dockets. The commission should deny the operator's license renewal application because operator's license is suspended. 2 questions there, Ms. Borst. Did I accurately read the question and your answer from your pre-filed testimony?
Yes, you did.
These were your opinions on July 7th, 2023. Do they remain your opinions today?
They're not opinions, they're facts.
Pardon me. I stand corrected. Okay. Very well. No further questions. Thank you. Thank you, Ms. Borst.
Thank you.
And Commissioner Keither, do you have any questions? I see a shaking head. And I do not have any questions, so let me turn at this time to Mr. Kimbrell. Do you have any redirect for this witness?
Yes, briefly. Ms. Borst, do payments when an operator is renewing a license, do they typically go through CanPay?
Yes, if they're in Kohler, they must pay through CanPay because it's the payment that sends their renewal application to me.
Okay. And if you are holding a license, does CanPay refund that payment amount while you're holding the license?
No.
If we could go to, I'm going to share my screen real fast. Do you see exhibit NB4, page 1?
Yes.
And is this the license renewal application of SX54?
That is the most recent one we received, I believe. Yes.
And who submitted this license renewal application?
Jonathan Frieden.
All right. Is Ace Energy's license currently suspended?
It is.
And do you know the docket numbers?
Well, I'm looking at his record right now, and it appears he's actually suspended in 4 dockets currently. 23, 33, 26, 22, 31, 24, 22, 31, 50, and 22, 32, 15.
All right. And are some of those consolidated into one docket?
I don't know that. The 3124 was a standalone in our compilation list, so I don't know if it's been combined with something else or not.
Okay. And under KSA 55155C4, can an operator's license be renewed if they have a suspended license?
No, it cannot.
All right. Thank you. I have no further questions.
All right. I don't think we tread any new topics with the commissioner questions, but Mr. Schlatter, were you able to locate the phone records discovery that you referenced?
Yes. We did not receive any records. We received a sort of a recreated version of 2 phone calls.
But you did receive discovery in response to the request.
We received what appeared to be, I don't know what it was. It looked like something that was created for purposes of responding to discovery.
Okay. Do you have?
If I could,
Go ahead.
I believe Ms. Borst handwrites her notes, and so I typed in what she had written. I could copy off the actual notes and send them to Mr. Schlatter if you'd like to see those, but it's the same as what you got in the typed version.
Okay.
So I guess the only question I'd like to ask is Mrs. Borst has only ever spoken to Mr. Frieden twice on the phone. Is that correct?
I did speak to him last October when he was trying to get some wells plugged and wondered about one of his old licenses, but I did not ever speak to him. The November voicemail, I don't believe I ever spoke with him. I had sent him an email in regard to that one.
Okay. I think that's all we got for this particular witness. Chair French, thank you.
All right. Thank you, Mr. Schlatter. I don't believe we need any additional commissioner questions or redirect after that. So, Ms. Borst, you may virtually step down. I appreciate your testimony.
Thank you.
All right. Staff, you may call your next witness.
Thank you. Staff calls Brad Bohr.
And Chair French, can I interject just briefly here? The next couple of witnesses are going to be handled by my associate. If we could have like 2 minutes to adjust, I would appreciate that.
Absolutely. Would you like to, if you want to go ahead and do that now, we'll just stand in recess for a minute or two and just let us know when you're ready.
Thank you.
Sounds like we're getting some feedback at your office there. I don't know if you've got maybe two microphones on. Oh, looks like you're just getting out of the way.
Mr. Schlatter out of my office, so hopefully that resolves the issue.
I think you've got it fixed.
All
All
right.
right. Are you ready to proceed, Mr. Ely?
I am.
All right. Well, then I'll turn back to Mr. Kimbrell. Mr. Kimbrell, would you please, I don't know, remember where we left off, but we are now back on the record and I'll have you call your witness, Mr. Kimbrell.
Thank you. Staff calls Brad Bohr. And Mr. Myers, if you could change the name below from Ryan Dueling to Brad Bohr, he's using his laptop.
All right. Good afternoon, Mr. Bohr. If I could have you raise your right hand. Do you swear the testimony you will give today is the truth? Swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. And back to you, Mr. Kimbrell.
Thanks. Mr. Bohr, please state your full name for the record.
Brad Boyer,
By whom are you employed?
the Kansas Corporation Commission on the Conservation District number 3.
And what is your work address?
It'd be 137 East 21st Street, Chanute, Kansas 66720.
What is your work title?
Environmental Compliance Regulatory Specialist.
Are you a member of the technical staff?
Yes.
Are you the same Brad Bohr who caused to be filed in this docket direct testimony consisting of 5 pages?
Yes.
Was this testimony created by you or at your direction?
Yes.
Now that you're under oath, do you have any corrections to make to your testimony?
No.
If I asked you today the same questions contained in your testimony, would your answers be the same?
Yes.
Do you swear the answers contained in your pre-filed direct testimony were and are true to the best of your knowledge?
Yes.
At this time, I would move for the admission of Brad Bohr's pre-filed direct testimony to the formal record.
Are there any objections?
Subject to the same objections that we've raised before, none further.
Thank you, Mr. Ely. Those are overruled as we previously ruled, but they are noted for the record. And Mr. Boyer's direct testimony is admitted into the record. With that, Mr. Ely, you may proceed with cross-examination.
Thank you, Chair French. Mr. Bohr, am I pronouncing that correctly?
Lawyer.
Boyer, okay. Mr. Boyer, my name is Jackson Ely. I represent the operator in this proceeding. I'm just going to ask you a few additional questions about your previous testimony and a few other matters. I see that you have not testified before the commission before. Is this correct?
Correct.
Okay, well, this is my first time too, so let this be our first rodeo.
Okay.
All right. You testified that you conducted an inspection relating to docket 23-3017. Is that correct?
Correct.
Okay. You inspected the Peggy Kruger lease in respect to that. Is that right?
Correct.
And you conducted that inspection on July 8th, 2022.
Correct.
Who instructed you to undertake that inspection?
That was instructed from the District 3 Compliance Officer, Ryan Dueling.
Okay. And you inspected the Stanley Stitt lease related to docket 23-3017 as well, right?
Correct.
And that inspection also occurred on July 8th, 2022?
Correct.
Okay. And did Mr. Dueling instruct you to undertake that inspection as well?
Correct.
And after you conducted those inspections, you reported your findings to Mr. Dueling, is that right?
Correct.
And that's pretty standard procedure for you, right?
Yes.
Okay. Let's talk about docket 23-3087, I believe. You conducted some inspections for that as well, correct?
Correct.
You inspected the Gail Mullen lease on July 13th and July 14th, 2022. Is that right?
Correct.
Ryan Dueling instructed you to inspect those leases?
Yes.
And you also inspected the Underwood 6 lease on July 14th, 2022. Is that right?
Correct.
Ryan Dueling instructed you to do that too.
Correct.
Were you done with your inspections of those 2 leases after July 14th, 2022?
Could you bring up my field reports? I can't quite remember. I'd have to recall.
I
on that.
can. Give me
If
a
you
moment here. Let me see how I can figure out to share my screen here.
Mr. Ely, John Myers here. There should be a button down at the bottom that's in green that says share screen. And then when you click on it, it gives you some options. There you go.
I puzzle that out there. Okay. All right. I'm trying to show right now what's listed as the penalty order for docket 233087. Is that what you're able to see on your screen there?
Yes.
Okay. Making sure there's not a picture of my computer background. Scroll down here. And I believe this is the field report that you compiled. Is that correct?
Correct.
Are you able to tell from this first page of the field report what dates you conducted this inspection?
Yep. Looks like July 13th, and then I returned on July 14th.
Okay.
Looks like.
I'm gonna scroll down a little bit more. Did you return to those leases?
Yes, on July 26th.
Okay. So you weren't done on July 14th. You went back. Is that right?
Correct. I did go back. Yep.
Okay. Did Ryan Dueling instruct you to go back?
That's been a while. I cannot recollect on that.
Okay. Well, if you don't recall, that's fine.
I'm sorry, I don't recall.
Okay. Do you normally go back to re-inspect leases that you just inspected, though?
There are times if, I forgot to, document something. If I didn't happen to get a picture or something, there's times, yes, I will
Okay.
go back to make sure I get everything I need.
Okay. So you went back about 12 days later and re-inspected the Gale Mullen, and this report shows your findings. Is that correct?
Correct.
Okay. I'm gonna scroll down a little more. Is this the report for the Underwood 6 lease?
No, that is for the, oh, yes, that is, sorry. Yep, it is.
Okay. Did you go back to the Underwood 6 lease on the 26th of July, 2022 as well?
Does not appear to, I don't see it on there.
Okay. Well, let me scroll down a little bit more here.
$14th.
I don't see anything indicating that.
Yeah, I don't either.
Okay. Mr. Boer, let me kind of change gears here a little bit. Based off these inspections, you recommended that the penalty order in docket 233087 for 5 counts of unauthorized injection be entered. Is that correct?
Correct.
Okay. Mr. Boer, how do you believe a water flood works?
I'm sorry, I didn't hear you.
How do you believe a water flood works in the terms of an injection well?
They inject water to help open up more oil and to be able to bring more oil to the surface.
Okay. Where does the water come from?
Sometimes they have a water supply well.
Okay. Can the water come up from the ground with the oil? Is that the source?
Correct.
Okay.
Correct.
And if it's brought up in the ground with the oil and then it's separated, is that a part of that process?
Right. Yep.
And then the water that was separated from the oil will be re-injected back into the well. Is that correct?
Correct.
That's a pretty standard injection well, right?
Correct.
Okay. So the water that's being re-injected into the injection well, that comes up out of the ground, right?
Correct.
Okay. And when the water comes up out of the ground, it's hot because of the pressure underneath the earth. Is that right?
You're saying I'm sorry, could you ask that again, please?
Let me ask you this. When the water comes up out of the ground, is it hot because of the pressure underneath the earth?
I cannot attest to that. I don't believe so.
Okay. So you don't believe the water comes out hot?
No.
Okay. What temperature does the oil come out of the ground at?
I am not sure on that.
Do you kind of have a general sense? I mean, does it come out freezing cold? Does it come out boiling hot? Do you kind of have a guess?
I'm going to object. Mr. Boyer has indicated he does not know the answer to this.
Well, he's indicated they didn't know the answer about water. I'm asking about oil.
He just said that he doesn't know about oil either.
Yeah, I don't know that I got an answer on oil, but if the witness says he's not familiar, that's okay. But I don't know that we got an answer on that one.
Yeah.
Chair French, I would like to ask the question about the oil again. I mean, I don't feel like I got an answer on that.
Yeah, I'm allowing that.
Okay, Mr. Boer, when the oil comes out of the ground, does it come out generally warm or generally cool?
I cannot attest to that.
Okay, so you don't know what temperature water and oil comes out of the ground at?
Correct.
Okay. Let's talk about the water when it goes into the injection well. It goes down the injection well, right?
Correct.
Does anything come back up the injection well that the water is going down?
It can. Usually those are constructed with a check valve to prevent fluids from going back into the lead line.
Okay. But if water's actively going down the hole, generally there's not going to be anything that goes back up, right?
Correct.
Okay. You mentioned check valves. Can I talk about that for a second? How do you think a check valve works?
It allows fluids to go through. There's a little valve in there that will open when the fluids proceed through it. When there's no pressure, it will shut, and to prevent fluids from, backflowing into the back into the lead line.
So the water only goes one way through a check valve.
Correct.
And the valve is only open when water's actively flowing in that one direction. Is that correct?
Correct. Correct.
How do you believe a ball valve works?
A ball valve can be manually, or a gate valve, can be shut off with a lever, and it completely shuts off all fluids, and would only allow fluids to be able to be moved if somebody opened that ball valve back. Once it's shut, there's should be no fluids going through it.
So when we see a lever for a ball valve, we can generally tell whether it's open or not by looking at it, right?
Most of the time, yes, correct.
And when the handle is parallel to the valve, that allows fluid to go through it. And when it's perpendicular, it closes the valve. Is that right?
Yes.
Okay. Mr. Boer, are you aware of how the KCC regulations define the word injection?
I am not.
Okay. This came up earlier in Mr. Dueling's testimony. KR 82.3.101A4 defines injection as the meaning of meaning the injection of fluids or natural gas for enhanced recovery or disposal of brines or fluids into an injection well. Is that consistent with your understanding of the word injection?
Correct.
Okay. So fluids or natural gas or brines have to go into the injection well for there to be injection. Is that right?
Correct.
Okay. So if nothing's going into the injection well, there's no injection, is there?
I'm sorry. Could you state that again?
If there's nothing going into the injection well, is there injection?
I would have to refer that probably to our compliance officer. I'm not for sure on that, to be honest.
Mr. Bohr, you are the man on the ground. You're finding injection. It's your job to discover when it is. Is your testimony that you don't know when there's injection?
Objection. Mr. Bohr has already answered this. He's already stated that he is not the one who applies the regulations. I think that at this point it's just argumentative.
Okay, I'll rephrase. Mr. Bohr, can a well be hooked up for injection, but not actually injecting fluid?
Can a well be, you said hooked up, but
Hooked
not
up for injection, but not actually injecting fluid. Is that possible?
Yes, that is possible. Yes.
Okay. Let's look at your previous testimony in this matter. I'm going to stop my share for a second. Pull that up. Mr. Bohr, can you see image I pulled up on the screen here? It's supposed to say pre-file direct testimony of you.
Yes.
Okay. This is the testimony that you just entered into the record through Mr. Kimbrell. Is that correct?
Correct.
I'm going to go to page 4, line 18 of your pre-file testimony. You say you found the Gale-Mullen C43, the Gale-Mullen E43, the Gale-Mullen I43, and the Mullen I22A wells were all hooked up for injection purposes. You said that, right?
Correct. Correct.
You just testified that a well can be hooked up for injection, but not actually injecting fluid. You said that just a moment ago, right?
Correct.
Is it possible that these wells were hooked up for injection, but were not actually injecting fluid?
Objection. That's not what he's testifying to. He's talking about
I'm asking a question that's different. He's established it. I'm asking a new question.
And I would, could we pull up the field reports for those particular wells, please? I think.
Absolutely.
Mr. Ely, could you restate your question just for my benefit? I think I missed the beginning of it.
Yes. My question, and I'll try to see if I have the phrasing right here. The Gale-Mullen C43, the Gale-Mullen E43, the Gale-Mullen I43, and the Mullen I22A. He testified that they were all hooked up for injection purposes. My question is can they be hooked up for injection purposes, but not injecting fluid?
Correct. Yes, they can.
Okay.
But oh, never mind.
No, go ahead.
Oh, I was just going to say on my field reports, if we could look at some of them, there was several indications of showing that these wells did have fluids going through them. There was, I can't remember which one it is. Could you scroll down?
Well, I'll get to the field reports in a second.
Okay. Sorry.
I want to focus on your pre-file testimony first. Is that okay?
Okay. Yep.
At line 20 of your pre-file testimony, you said you have pictures showing the wells hooked up as injection wells. Is that right?
Correct.
Okay. At line 22, you say you saw the Underwood well hooked up as an injection well. Is that correct?
Correct.
We go down to page 5 in line 2. say that you have photos of the Underwood well hooked up as an injection well. Is that correct?
Correct.
Do you say that the wells were actually injecting fluid, or do you say that they were hooked up as an injection?
On this testimony, the direct testimony right here, it says
Yep.
just just says that they were showing that the wells were hooked up. Yeah.
Okay. At line 4 of page 5 of your testimony, you said that the wells were hooked up with check valves indicating the flow of the fluid toward the well heads of the subject wells.
Correct.
Okay. Mr. Borst, is it possible that a well can be hooked up with a check valve, but that check valve is closed because there's no actual injection of fluid? Is that possible?
Could you repeat that again?
Is it possible for a well to be hooked up with a check valve, but not actually injecting fluid?
I believe so. Yes.
And then at line 6, you state that the lines were cool to the touch, indicating that the fluids are traveling through the flow lines to the wellheads. Is that correct?
Correct.
Okay. Mr. Borst, didn't you just testify a moment ago that you have no idea what temperature water is when it comes out of the ground?
Correct. I do not.
So why do you say that it was cool to the touch, indicating fluid?
There was several indications of the well, or that the lines were dripping. I think on one of the field reports there was one where one was dripping.
Mr. Borst, I'm going to stop you for a second. I'm not asking about dripping fluids. I'm asking about the cool to the touch.
Oh, okay. Could you ask that again?
Yeah, let me try to rephrase. How do you know the lines being cool to the touch indicate fluid traveling through the lines when you testify that you don't know what temperature the water comes out of the ground at?
I'm going to object to this. There's no indication that the water coming directly out of the ground is what is going through these lines. That's a leap in logic. That's calling for speculation.
I'll rephrase. Mr. Borst, do you know what temperature water is when it is re-injected after it came out of the ground?
I do not.
Okay, so how do you know that these lines being cooled to the touch indicate that there was fluid traveling through them if you don't know what temperature the water is?
I would say that, it's obviously underground water would be cooler. I don't know, like I said, I don't know the exact temperature, but it would be cooler coming up from the ground than it would be.
Okay.
But I don't, as far as the exact temperature, I would not know that.
Mr. Borst, you conducted these inspections in July, correct?
Correct.
I imagine it was pretty hot outside in July.
Yes.
So if it was cool to the touch, that means that the water was probably, or whatever was in the lines, was cooler than the outside temperature, correct?
Correct.
And the outside temperature was probably pretty high when you conducted these inspections.
Yeah, I believe so. I don't know exactly, but
Okay.
it was warm.
Safe to assume because it's July, though, in Kansas, right?
Mm-hmm. Yeah.
Okay. All right, I'm going to switch gears a little bit here, and I'm going to go to your field reports. I know you wanted to talk about. Where in your findings paragraph do you state that the wells were actually injecting fluid?
I do not see where I said that they were. I don't see it.
Okay. I'll scroll down. We got a lot here. If you need me to scroll down, just let me know and I can do that.
And your question was where?
Where in this report do you indicate that the lines were actively injecting fluid? Not that they were merely hooked up to inject, but they were actively injecting fluid.
Could you go scroll down just a little bit? I don't see where that is in there.
Okay. I'm gonna go to the Underwood one. Where on this page does it say that the well was actively injecting fluid, not that it was just merely hooked up to inject?
Again, I do not see that on there.
Scroll down. Where on this page does it say it was actively injecting fluid?
I do not see where it says that it was actively injecting on there.
I'll try to go through these one at a time here. On the Gale Mullen I-43, you stated that there was a small drip causing a wet spot on the ground, and you took a photo of that, right?
Correct.
Is this the photos you took for the Gale Mullen I-43?
Correct.
I can't see a small drip in that photo, can you?
I can't see the small drip, but if I don't know if there is a way to enlarge that. I believe that you could see around the wellhead there was a couple, there was water standing there. It's kind of hard to see.
Mr.
Yeah,
Borst, maybe
there's
you're seeing
a wet
something I
spot.
don't. Can you point out or kind of state orally what portion of these images have a drip?
There's the pictures is not of the drip, but I have, the pictures of where it had been dripping. I couldn't get a picture of it dripping. It was a very slight, very slow drip, but you can see, especially on that picture to the right of the casing, you should be able to see the fluid there on the ground puddle around the wellhead.
Is it possible that fluid came from a different source, like rain?
No, I don't know. It had not rained at that particular time for
Is
quite
that
a
in your
while.
report?
It is not.
So you just know what the weather was a year and a half ago.
Objection, that's argumentative.
Let me rephrase the question. Mr. Board, do you recall specifically what the weather was a year and a half ago?
I don't specifically recall, no.
Okay.
But
Mr. Board, you testified in this first paragraph here that you attached 2 photos showing the leak with this report. Is that on there?
on the I-43, yes.
On the I-43, yeah, I'm still on the I-43.
Yep.
But you just testified a moment ago that you did not take photos of the drip.
That's not what he testified to. I object. He testified that you couldn't get a picture of the actual drip because it's so small. He testified that you could see the result of that drip.
Mr. Board, can you see the drip in the photo, yes or no?
No.
Okay. I see here there's a paragraph for additional information. Do you fill this out when you go and take photos? Is this something that you create simultaneously when you're at the well?
Not, or can you ask that again? Is it like?
I see a paragraph with the first 2 words saying additional information.
Mm-hmm.
Do you create the text in this report at that paragraph simultaneously when you take photos of the well?
Not simultaneously. Is that so? If I could elaborate, I get to the lease. Usually start off by taking a picture and then go through the word photo templates, add all the information, and so it's not simultaneously. If I'm understanding your question right, as taking the picture, no, it is after the fact, after taking the picture. that
Do you
I had
type
that
this
information
text out
down.
on I'm sorry, go ahead. I didn't mean to interrupt you.
Oh, I'm sorry. I just was just gonna say, no, it is not simultaneously as I'm taking the picture.
Okay, I'm just trying to get an understanding. Do you type this text the same day that you take this report and take these photos?
If possible, I try to, but it's not always possible. Due to other activities during the day, if I have if we have a spill or something else that needs to be addressed that day, but I try to do it
Okay.
as soon as I can.
You don't mention the drip in this additional paragraph section, do you?
I'm sorry, what's that?
In this additional information paragraph underneath the photographs of the Gale Mullen I-43, you don't mention the drip, do you?
Not in this Word photo template, no.
Okay. We got another set of documents for the I-43. What's the date on those? On that?
July 26th, looks like.
So this is when you came back, right?
Correct.
We got more detailed pictures this time.
This is of the check valve showing which way the fluids would be going is what that's shown.
Okay. Can you see a drip in this photo?
No.
It looks like there's a new sentence in your additional information paragraph this time around. Is that correct?
Could you go back up to the other one?
That was the one from
Right
July
there.
13th.
Okay.
And I'll go down. This is the one from July 26th.
Yeah. Yes. There's another sentence stating that. Yep. Yes.
A little more detail this time, right?
Yes.
Okay. Mr. Boer, I'm going to call your attention to the right-hand photo on this July 26th set of images at the Gale Mullen I-43. On the very far right-hand side, it appears to be a handle. Is that what you see?
Are you looking from the check valve to the right of the check valve? Is that?
Can you see my mouse by chance?
Yes, I can.
I'm looking at this right here. I know that that's not helpful for the record, but it is on the center far right-hand edge of the rightmost photo.
Okay, I see what you're saying. Yes, that's
that a handle?
Oh, I'm sorry.
Is that a handle?
That is not a handle.
Okay. What is that?
That is a clamp to clamp the hose onto the nipple there to tighten it down to keep the hose tightened on there.
Okay. Is there any way to tell if fluid is going through this check valve by this photo alone?
No, other than by the indications that I saw when I first got there. But no. Okay. Yeah, no.
I'm gonna go back up here a bit. I want to talk about the Gale Mullen E43. Okay. You said that the gate valves were open and one of the gate valves had a small drip on the right. Is that in there?
Let's see where it said that there was a drip in there.
And I'm sorry, it doesn't say the word right. It said that there was a small drip. Let me clarify.
Could you point me to kind of where? Oh, a valve had a small drip. Yep, right there. Okay.
Okay. Are these the photos of the Gale Mullen E43?
Yes.
When did you take these photos?
It says July 13th.
Do you mention the drip in the additional information paragraph?
No, I do not.
Okay. In the photos, can you identify an open gate valve?
I would have to.
The photo alone.
Just identify if the gate valve was open.
Based off the photos, can you identify an open gate valve?
Oh, I'm sorry. It'd be pretty tough too, so no.
Okay. Zooming in doesn't help, it does it?
I see, it's very hard to see on my end.
Okay. I think I zoomed in too far there. You see an open gate valve on the photo on the left?
Can you go up? I can only just see just barely. Very hard to see, but it looks like there could be the valve there on the ground, but it's very hard to see. It's not very clear.
You can't conclusively say based off this photo, can you?
Yeah, correct.
Okay. I want to talk about the Gale Mullen C43. And paragraph about that, you state that the valve was open and there was a spray of free fluid, don't you?
Notice a spray of free fluids next. Yes, correct.
Okay. Are these images of the Gale Mullen C43?
That one is yes, correct.
What is the date these photos were taken?
That was July 14th.
Do you mention the spray of free fluid in the additional information paragraph on July 14th?
Not on this one, no. I believe on the second set of pictures, it's stated below there.
You do state something more on the second set, correct?
Correct.
What is the date of the second set?
That's July 26th.
So when you went back out, you put more information in, right? Okay.
Correct.
I'll go to the first set of photos. Can you see a spray of free fluid in that photo?
On the first set,
On the first set.
It's pretty tough. I don't think so. It's
okay.
Pretty hard to see.
On the second set of photos, can you see a spray of free fluid?
I can see where it had sprayed on the right hand picture where the grass is stained. Where there's a ball valve right there to relieve the pressure.
Okay, I guess I'm having a hard time seeing it here. For the record, try to state it as detailed as you can. What portion of the photograph shows the spray of free fluid?
Okay, so where the pumping hose, it's kind of it looks like a pinkish, faded red color. It kind of wraps around, goes up towards that ball valve. I don't know if you can see that ball valve handle right there. Yep. And then if you look at the grass around in the background, it's relatively brown, and then that black spot where it had been, that valve had been open at some point in time, and it's stained grass.
This shape that I'm kind of running my mouse over on the center upper mid portion of the rightmost photograph.
Correct. Yep, right in there.
Is it possible that's a shadow?
No, it was not that day.
Okay. I want to talk about the the Mullen I-22A. Did you say that the ball valve was open?
Ball valve at the wellhead was open and the check valve was, yes.
Okay. Make sure I have the right thing here. Is this the images of the Mullen I-22A?
Correct.
what do you state in the last sentence of your additional information paragraph on that?
It says in these two pictures, you can see the oil seeping from the bushing and covering the swedge and valves.
Do you mention the ball valve being open?
In that sentence, no.
Okay. Is it fair to say on this left-hand photo, in the center portion of the image, where kind of a pinkish hose attaches, is that the ball valve right there?
No, I believe that's I can't quite see it. I believe I'd have to. Could you? No, that's the. Are you talking about right there where the hose connects?
Yeah, right where my cursor is.
Well, you're right there. That's the check valve. Looks like, yeah, that's the check valve.
Where's the ball valve?
The ball valve. If you go to the T, and of course it's kind of hard to see. There's a nipple, and the ball valve should be below that. Yeah, right in there. Looks like. And there's also another valve, or there's actually another gate valve up there on top too. It looks like I forgot that one too, with the blue handle.
Okay.
Yep, right
So
there.
the ball valves are here somewhere?
Yeah, there's one. If you might, could you go back over to that picture to the right? It might be a little bit better. Yeah, it's very hard to see. So in that picture, you have the T. Now I can't quite see it.
You can't identify where the ball
Yep.
valve is in this photo, can you?
On this one, I can, yes. You can barely see where that light spot is right there. That is where the handle would be. The handle was broken off on that one. Somebody has used it. You could use a crescent wrench or another tool to do it. It's kind of stained right there. That bushing is right above that ball valve, that particular
You
picture
stated
on the
that
right.
the handle for the ball valve was broken off. Is that correct?
That appears to be. But
that seems kind of odd, doesn't it? Would you not normally put in your report that a ball valve handle was broken?
Well, the handle comes off. You can still shut the valve. Oh, I'm sorry. I guess I've never I never have put that in a field report. No.
Okay.
But
so how can you tell if it's open or closed if the handle's not there?
It's hard to. So in that picture, you can't see very well where the handle connects to that. It is perpendicular, and you can move it up and down. If it's up and down, then it's open, just like if it had the handle on it, the handle will come on and off. But it can still be closed. Like I said, with
you just say the handle is perpendicular to the valve.
No, not on this picture. No.
Okay.
But
right.
if it was on there, it would be. But that's the ball valve right there.
Okay, I guess I'm just confused. How can you tell that the valve was open if the handle wasn't there?
So, and I don't know the correct terminology of it, but where the handle has a little slit where it slides into that. Like I said, you can see that kind of that shiny spot right there where the oil hadn't stained it. It slides over the top of it, and you turn it either up or down, perpendicular or not, like you would if the handle was on there, if that makes any sense at all. So, I mean, you can still tell that it can still be shut and then open with even with the handle not off on it, it can still be closed and open, and you can visually see it.
Okay. Is it fair to say that it's really hard to tell from this photo whether or not that valve is open or closed without that handle?
It is. Could you repeat that?
Is it fair to say that it's really difficult to tell from this photo whether or not the valve is open without the handle?
I would say yes, it is. It is hard.
Okay. I'm going to go back up to this one. Are you aware that the Gale Mullins C43 is an EOR well?
Am I aware of it?
Yes. Okay. Why would there be a spray coming off of an EOR well?
I would say somebody at some point in time, it indicates that somebody probably released that ball valve to release the pressure off of it. And could, just also indicate to see if they have fluids going through it too.
Okay. I'm going to switch gears again. I'm sorry to keep you guessing here, going in between wells. On the Mullen I-22A, you talk about oil seeping out. Is that correct?
Correct.
How could oil be seeping out if this well was actively injecting water?
Well, the oil in the water, there's also, the produced fluids. It could be, a malfunction there at the bushing or something, not tight, leaking as it's injecting into the wellhead.
Would you say that it's more likely that the oil was seeping out because there wasn't water being actively injected?
I'm sorry, what I say was, I'm sorry.
Would you say that it's more likely that oil was seeping out because water was not actively being injected?
No.
Okay. How could oil come up the well that water was actively going down?
Objection, that's not what Mr. Boyer testified to.
This is a new question, Mr. Cameron.
I'll overrule the objection.
I'm sorry, could you repeat
How could water be seeping out? I'm sorry, let me first. I've gone and forgot my question. I'm sorry if I'm going to reiterate things here. Would you say that it's more likely that, wait, no, I already asked. How could oil be seeping out if water was actively going down the tube? Actively going into the well? How could it be coming up?
how would it be coming up?
How could oil be coming up and seeping out if water was actively going down the well?
Well, I would say that that's a pretty tough question. The picture would be, if the water was coming to the T going down into the well, it would, it's seeping down, going at a downward from that bushing and over that ball valve down, and it looks like that's the swedge, and it's, going down from there.
Where's the oil coming from?
It could, with the fluids that they're, injecting back through the system for injection.
They're re-injecting oil into the injection well?
Well, it might have some. I'm not saying that they would be re-injecting oil in there, but it might have, some remnants of some oil going back through there.
Is it pretty usual to re-inject water with oil in it back into an injection well?
Is it
standard? Is it common in your
I
language?
don't, not to my knowledge, no.
Okay. I go down to the Underwood 6. This is the field report for the Underwood 6 lease, correct?
Underwood 6, yes, it is.
Okay. In your findings, you state that the valves for the flow lines are open and the injection line was connected to the wellhead. Is that correct?
Correct. Was connected to the wellhead, yes.
Okay. Mr. Boer, have you used KGS records before?
I have.
Okay. You're pretty familiar with how that works then?
Fairly familiar, yes.
Have you used KGS records to look up historical production for leases before?
For leases, yes.
Okay. Stop my share here for a second. I'm going to publish this document. Mr. Bohr, I'm showing you what's been marked as Operators Exhibit AX9. Does this look like KGS lease production records that you're familiar with?
Yes,
Okay. And the name at the top of the lease is the Mullen Gale J. Is that right?
that's what it says. Yes,
Okay. And then under the Kansas Department of Revenue lease name, it says Underwood 6. Is that right?
yes.
Would you say that this is a fair and accurate depiction of the KGS production records for the Underwood 6 lease?
For the entire lease, yeah,
Yes.
on the Underwood 6, yes.
And that's the lease that you inspected, correct?
That's one of them, yes.
Okay. I'm going to ask that Operators Exhibit AX9 be admitted into evidence.
Is there any objection?
No objection.
Hearing none, it will be admitted.
Thank you, Commissioner French. Mr. Bohr, I'm going to scroll all the way down to the end here. What does the KGS record show the last time there was record of production on the Underwood 6 lease? What was the year? What was the month?
2021.
What was the month?
If you could scroll, is that the month? I can't quite see.
So I'll scroll back up and I'll show you the title of
the month. Okay,
and I'll scroll back down.
Be March of 2021.
Okay. So is it fair to say that there were no production records after March of 2021 at this 6 lease?
After there was no records after 2021, or after, is that what you were saying?
Let me rephrase. Is the last record of production for the Underwood 6 lease in March of 2021?
Appears to be, yes.
Okay. That was about a year and a half before you conducted your inspection of the Underwood 6 lease, correct?
Correct.
Okay. So there's no KGS records of production at the time that you were conducting your inspection?
Not to my knowledge, no.
To operate a water flood, don't you need some production?
Correct.
So how was this water flood operating if there was no production?
Objection calls for speculation.
Let me rephrase. Where was the water coming from that was being injected into the well at the Underwood 6 lease if there was no production?
I do not have an answer for that.
Is it more likely that the Underwood 6 lease was not injected?
It appears it could be.
Yes. Hold on, I'm going to object to that. That's argumentative and it calls for speculation.
Mr. Ely?
Chair French, this is a very pointed question. Mr. Bohr testified that there was injection. He claimed that there was in his report, or that it was hooked up for injection at least. I think it's important to know whether or not the man who inspected the lease believes that there is injection based off these facts.
Okay, I'm going to overrule the objection. Go ahead and re-ask your question.
Mr. Bohr, do you believe, based off this information, that the Underwood 6 lease was injected?
Based off of this information?
Yes.
No.
Okay. Mr. Bohr, did you create a spill report for the Gale Mullins C-43?
I would have to see that. It's been a while.
That's fair. Here's what I'm going to do. I'm going to publish this. Can you see the document I have pulled up? It says your name here at the top.
Yes, it is. Yep, I can see it.
Does this look like a spill report?
Yes.
Does it look like you compiled the spill report?
Casey Seff, who investigated, yes, I was there.
This has been marked as Operators Exhibit AX10. And this is the spill report you created for the Gale Mullen C43 on August 2nd, 2022. Is that correct?
August 2nd, yeah, yes.
Okay. Is this a fair and accurate depiction of the spill report that you created?
Yes.
Okay. I'm going to ask that Operators Exhibit AX10 be admitted into evidence, please.
No objection.
AX10 is admitted.
Thank you. Mr. Boer, in this report, you state that you arrived on site at approximately 11:30 a.m. on August 2nd, 2022, correct?
Correct.
Okay. In that report, do you state the volume of fluid that was spilled?
It appears, looks like if I'm reading it right, approximately a half a barrel of fluids were released.
Half a barrel.
Yeah.
Okay. Under incident description, the first sentence says value broke. Is that a typo? Did you mean to say valve broke?
I would believe, yes, it would be a valve. Yes.
Okay. So just to be on the same page, this spill report was created as the result of a valve breaking at the Gale Mullen C43. Is that correct?
Correct.
Okay. If a valve broke at an active injection well, probably be a lot of water coming out, right?
Yeah, yes, it could be, yes.
Okay.
I mean, it just, yeah, depends. Yeah.
In your experience with spills, is half a barrel from an injection well a lot?
I have not had a lot of injection wells that have had leaks, but it would be hard to say. Like I said, this depends on how, if the valve just had a little bit of a crack, or, you know, or if there was a larger crack, or how much pressure was on it.
Well, in the incident description, do you state that operator staff disconnected the line from the wellhead?
Yes. Oh, yes. Okay. Yeah. This well, I'm sorry. Yes, I did. I arrived on location appears. Yeah, I did say that. Yes.
So help me with my understanding here. The valve broke, and then the operator disconnected the line from the wellhead. Is that correct?
I believe that appears to be what that appears to be what it says. Yes.
Okay. Would you expect more fluid than half a barrel to come out if a valve broke on an active injection well and then the line was disconnected?
I can't really say for sure what I would expect.
Okay. Is it possible that the half a barrel was just static fluid in the line and that the well was not injecting?
It could be.
Does it seem likely that that was the case, given that it's only half a barrel spilled?
I don't know. That would be hard for me to say for sure.
Okay. Mr. Boer, after your findings, I'm going to stop sharing my screen here for a second. After your findings from all these leases that you inspected, did you or someone else from staff request that operator unhook the various wells on the Gale Mullen lease and the Underwood lease?
Could you restate that again?
After all these leases that you conducted, did you or someone from staff request that operator unhook the wells at the Gale Mullen lease and the Underwood lease, the ones that we've been discussing?
I'm not sure if that would be in any. I believe it's been a while. since they were all unauthorized injection wells, I believe that they needed to be unhooked as the time that they were found.
Okay.
I believe I would probably prefer that to Ryan Dueling, the compliance officer. I'm assuming that would have probably came from him if that was the case.
That the request of the wells be unhooked would come from Ryan Dueling?
Right.
Okay. I'm going to share my screen here. Mr. Boer, do you see the email that I have on my screen?
Yes, I do.
Is this an email from you?
Yes.
Okay, I'm showing you what's been marked as Exhibit AX11. This email is dated August 23rd, 2022, correct?
August 23rd. Yes, it is correct.
Okay. And this email is about the wells we've been discussing being unhooked, correct?
Yes.
Is this a fair and accurate depiction of the email that you sent?
Yes.
I'm going to ask that operators Exhibit AX11 be admitted into the evidence, please.
No objection.
AX11 is admitted.
Thank you, Chair French. Mr. Boer, in the email, you state that an inspection was conducted on August 19, 2022. Is that correct?
Yes.
For the 5 wells we've discussed, right?
Correct.
What did that inspection find?
It says that all the unauthorized injection wells were unhooked.
So is it fair to say that staff asked operator to unhook the wells and operator did what it was asked to do?
Would it be fair? Yes.
Is that what happened?
Yes.
Okay. Mr. Boer, I'm going to share my screen again. And for sake of clarity, I've gone back to the record. This is the penalty order in 3087. Specifically, I'm going down to the field reports that we've discussed earlier in this testimony. Familiar with these still, right?
Yes.
Okay. This additional information paragraph that you did on or about July 13th, pretty generic, right?
I'm sorry, what's that again?
This additional information paragraph that you compiled on or about July 13th is pretty generic. Is that right?
Yeah. Yes.
When you went back about 2 weeks later, you added information. Is that right? For the same well.
Correct.
For the Gale Mullen E43, additional information paragraph on July 13th is pretty generic as well, right?
Correct.
For the C43, the additional information paragraph that you created on or about July 14th is pretty generic as well, correct?
Correct.
On the C43, when you went back 2 weeks later, you added more information. Is that correct?
Correct.
On the Mullen I-22A, we don't have anything from July 13th or 14th. We only have the one from July 26th. Is that correct?
Correct.
And you have some details in that paragraph, correct?
Correct.
For the Underwood 6 or 90, you did that one on July 14th, correct?
Correct.
And that one's pretty generic.
Correct.
Are you seeing a theme here, Mr. Boer?
I'm going to say it's
Okay,
argumentative.
I'll rephrase. Mr. Boer, all the information that you provided on July 13th and July 14th was pretty generic. You added more information when you went back on July 26th. Is that correct?
Correct.
Was Ryan Dueling aware that you conducted these inspections on the 13th and 14th of July, 2022?
Yes.
Did you speak with Ryan Dueling between July 14th and July 26th about the inspections that you conducted at the Gale Mullen and the Underwood 6?
I cannot recall on that. I'll be honest. I don't recall.
You normally go out to re-inspect leases where you already found that all the wells were hooked up for an authorized injection?
It has been known to happen. Yes.
But this time, you went back out and you added more information consistently on July 26th than you initially had on July 13th and July 14th. Is that correct?
Correct.
Did Ryan Dueling instruct you to go back out and re-inspect the leases on July 26th to find or fabricate evidence of unauthorized injection?
Objection. Objection. That's argumentative, badgering the witness, and he's already answered that he doesn't recall.
So, Mr. Ely, these are definitely asked and answered. I mean, I know we've heard these. I will let the witness answer the question, but you're pretty much at the end of it here. Mr. Boyer, you can answer the question.
Okay, could he please repeat that?
Did Ryan Dueling instruct you to go back out and re-inspect the leases on July 26th to find or fabricate evidence of unauthorized injection?
No.
Okay. Chair Keen, that is the end of my questions on that line, by the way. So,
can I ask, do you have substantial additional cross for this witness? I'd like to give everybody a mid-afternoon break.
I don't. I have maybe 2 or 3 more questions.
Let's go ahead and wrap up your cross, and then I'll give everybody a break before commissioner questions. So go ahead.
Thank you, Chair Keen. Mr. Boyer, you also conducted inspections of operators' leases in January of 2023. Is that correct?
Correct.
You conducted inspections of the Gale Mullen lease, correct?
Correct.
The Pearson lease?
Correct.
The Peggy Kruger lease?
Correct.
And the Underwood 6 lease?
Correct.
Those are not all the leases that were contained in the allegations arising out of the inspections conducted in January, were they? Let me rephrase. Other people conducted those inspections in January in addition to you, correct?
On other leases, yes. Yes, correct.
All those inspections were conducted after this docket was initiated, correct?
Correct.
Have any of those findings from your inspections in January been issued as penalty orders?
Objection. That's
I am
on Mr. Boyer's job description.
Okay. Mr. Boyer, to your knowledge, has operator been found non-compliant with those after a tribunal?
To my knowledge.
To your knowledge, has operator been found non-compliant with anything that you found in the inspections in January at this time?
I do not know.
Okay. I have no further questions.
All right. Thank you, Mr. Ely. As I mentioned, I want to give everybody a short break here mid-afternoon. So we are off the record. Return. It's going to be a 10-minute break until 3:30. When we return, we'll have commissioner questions. So everybody, please mute your speakers or mute your microphones, turn off your cameras. We'll be back at 3:30. right, this is Chair French. We are back on the record and we are ready for commissioner questions of Mr. Boyer. I will begin again with Commissioner Keen.
Thank you very much. Mr. Ely, in conjunction with my cross-examination of Mr. Boyer, I'm going to request your assistance with the screen share on many of the documents that you crossed him on. So if you'd help me with that, I'd be grateful. I'll tell you which ones I want when. Good afternoon, Mr. Boyer.
Good afternoon. Good afternoon, Commissioner.
Mr. Boyer, which counties are within your area of responsibility as an ECRS?
I am responsible for Crawford, Cherokee, Labette, and also where as needed.
Okay, that's fair enough. From among those counties that you're directly responsible for, which counties does Ace Energy operate in?
That would be Crawford.
Crawford. That'd be the only one of the four or so that you have, all right? Okay.
Yes.
Trying to decide where to start here, actually. I'm going to start with your experience. First of all, I think it's germane. I'm looking again at your direct pre-filed testimony on page 2. Tell me about your field experience that's relevant to oil and gas.
I had previously worked for a gas company as a pumper, coal bed methane, and that's about that's what I've done so far.
Is that post rock?
It was post rock at the time. Yes, it's River Rock now, I believe.
Yeah, and as a pumper, you're kind of intimately familiar with a lot of production issues, are you not? Isn't that what the function of a pumper is?
Correct. And
for the wells you were responsible for, did you visit those every day?
I got to them as almost every day. Yes, I had about 100 and I think it was 130 some wells. So it took up over a period of time.
Yeah. Okay. Well, I think that testimony is relevant because your experience is relevant because you know the intimate details of the production process and the enhanced recovery process. Do you not? You've had experience, field experience in those areas. Am I correct?
In the gas field, yes.
Yeah. And when you produce water with natural gas, so let's focus on that part of your experience. Is there any residue oil that comes up with them in some circumstances?
In some very, very, very rarely, but yes, it can happen.
Okay. And you still have to take the water that's produced through a separation system?
Correct. Yep. It goes through a separator.
Okay. And then from the separator, part of that's going to go into a water tank that's going to be used to provide water to an enhanced recovery well in some instances. Is that correct?
Correct.
And that water isn't pristine, is it?
No.
In fact, it can contain basic sediment. It can contain oil residents. It can contain any number of contaminants, could it not, including iron sulfide and a whole lot of things that will break out of the waters that are produced.
Correct.
Okay. More about that in a moment. Most of the cross-examination that was directed to you had to do with docket 23-3087, which is the docket dealing with unauthorized injection into 5 wells. You were asked a question about whether water comes up out of a well hot. Is that relevant?
I don't believe so.
I mean, what happens? It comes out of comes up out of the tubing that you're producing through, I presume, into a lead line. Where does the lead line go?
to the tanks.
To
Where
a
they will be
separator,
the
probably.
produced fluids. Right, I'm sorry, yes, yep.
Okay. And then eventually it will work. Some of the water is going to work its way into the water tank and then ultimately be injected into wells if that's the purpose for the water, right?
Correct.
You can tell hot from warm from cool, can't you?
Yes.
Regardless of whether you can tell what the exact temperature of anything is, you can tell that difference, can't you?
Yes.
What's the significance and we're talking about inspections here with respect to the Gale Mullen 143 and the Gale Mullen E43. This is an inspection you conducted in July, right?
Correct.
So if a lead line or a flow line to an injection well or a well connected for injection is cool in July, what does that say to you?
That would be a very good indication that there are fluids going through those lines.
And why is that?
Cool to the touch, it's hot, the condensation, and if there is fluids leaking too. But just very good indications, very good indicators that
if there was no fluid in the line and it was July and the line lays on top of the earth, is there going to be what's going to be what's that line going to feel like to the touch?
I would say it would be very warm.
Yeah. Or if the line were full of fluids that were not in motion, what would be the likely temperature of the fluids in that line as you feel them through the line?
I'm sorry, could you repeat that?
Yeah, if the line was filled with fluid, but it was not in motion, what would be the likely temperature of the fluids as you feel them through the line?
I think, it might be a little bit cool, but not as, would be not as evident if they were flowing, obviously.
And why would that be?
They're kind of stagnant, if they're not moving and, it's able to heat it up.
The sun's beating right down on it right there, right? Okay.
Correct.
You're pretty familiar with these wells and the way these wells are configured for the operator. It looks like they're using poly lines. Is that correct?
Correct.
The fittings at the wellhead, tell me about those. I see some brass fittings. Are they using plastic fittings at the wellhead?
I did not see any plastic fittings.
Okay. Were they all steel or bronze?
I believe they were mostly all steel, if I remember right.
Okay. After you did these inspections in July on these Mullen wells, I think we focused primarily in the cross-examination on the dates of July 14 and July 26. Have you been out to those leases? Have you seen these wells subsequent to July 26?
After that date, is that what you're saying?
Yes, sir. Mm-hmm.
Yes, I have.
What did you find?
They had been unhooked at the time.
Okay. Mr. Ely, if you would, let's go to the KGS document that you showed to Mr. Boyer. Yes, that's it. If you could scroll down just a little. Okay. Well, we have here, let's look at the captions there together for a minute, Mr. Boyer, at the top of each one of these columns. You see where it shows the year, the month, it shows the production, the wells, and and basically the first purchaser. You see that?
Correct, I did.
All right, let's scroll down again to the bottom, if you would, Mr. Ely. Thank you. Yes, and Mr. Ely was focusing in his cross-examination on the date of what he claimed was last production being March of 2021. Do you recall that question and your answer?
Yes, sir.
What was your answer? You remember?
that there was nothing, there was no, it was not showing any production after that date on March 2021.
That's
I believe.
right. Okay. Okay. Are you, because you see there, right? Let's just look, let's focus on that. March 21st of 2021. That's been quite a length of time there. Do you suppose this is still a commercial lease or producing a live lease, an active lease?
I'm sorry, what's that now?
I'm just wondering rhetorically if that is an active lease since they haven't had any production in over 2 years.
No, sorry.
The second column there is, of course, the month of sale. The third column, it was been represented to you as production. That's what it says at the top, doesn't it? It says production. Do you know how the State Geological Survey obtains the information they put in that column?
As far as the barrels or the production on it?
Yes.
I'm not fully aware. I assume they get it from the purchaser. But I am not familiar with that exactly.
They kind of get it from the purchaser through the Department of Revenue, because the Department of Revenue is very interested in obtaining all the tax revenues due to the state of Kansas from the sale of oil. Okay. From the sale of oil, not from the production of oil. What's the difference between production and sale, Mr. Boyer?
Production, you may be making production, but if you don't sell anything, then you won't have a sale.
That's correct. So how can we, if this number actually represents sale, which is what an incredibly low amount that is, but if that actually represents sale because it's information provided to the survey by the Department of Revenue, if that's the case, then how do we know what production is?
I'm sorry. Could you repeat?
Yes, if that third column represents sales, how do we know what the production is?
How do we know what the production is?
Yeah.
I mean, you don't, I guess.
You wouldn't. Exactly.
Yeah.
And if you don't know what the production is, because that's something that's made at the tanks, right? That's something at the tanks. So that's not something that went into the first purchaser's truck. That's what McClaskey uses. So basically, you responded that because of the fact that this represented to you as production was so far apart from the time of your field inspection over a year later, that meant therefore the well couldn't be used for injection. Do you want to rethink that? I mean, does that make any sense to you?
No, it does. It does.
Explain that.
I'm sorry. Could you kind of cut out for a minute? Could you repeat that again?
Yes. If the amount in column 3 represents sales, and from the information that the survey provides to you, it's virtually impossible to determine what production is. How is it possible to conclude, therefore, that there was no attempt to have production, therefore there couldn't have been injection into a well associated with this lease? How could you conclude that?
By doing a field inspection and indicators and going to the lease, and that would be the best way I could answer that. If I'm answering that right, I'm not sure if I'm.
Let's move on. Mr. Ely, if you would please, let's go back to the I think it started with pages 1 and 2 of the Exhibit A. That was the document that we spent quite a bit of time on. Yes,
Commissioner Keen, I'm assuming that you mean the field report that was attached to the penalty order.
You're headed in the right direction, Mr. Ely. Let's go up to page 2. Yes, if you could, no, you were there. You were there. There we go. Yeah, that's the page. Thank you. Mr. Boyer, on cross-examination, Mr. Ely was cross-referencing the narratives that you have here back with the photographic documentation that you had taken at the time that you inspected these wells, whether it be on the 14th or the 26th of July, 2022. Let's take a look together at these just one more time, very briefly. I'm looking at the Gail Mullen 143, the very first one. You say here that the line was cool to the touch, indicating the fluid is traveling through the flow lines. Is that your conclusion based upon your experience in the field?
Correct.
Let's go down to the Gail Mullen E43. Again, it says there the line was cool to the touch, indicating fluids were traveling through the flow line. Again, is that your conclusion based upon your field experience?
Correct.
Gail Mullen F41. Move on down to the Mullen C43. Okay, it says on this, along location, I noticed a spray of free fluids next to the well in the grass, which appears to have come from the bleeder valve. Am I reading correctly from what you wrote there?
Correct. Yes.
And that was based upon your field inspection on July 26th, was it not?
Correct.
And that stain in the grass there, that what I think you're contending is a stain, wasn't there on July 14th. Is that correct?
Correct.
And I think you've testified that that was not a shadow.
Correct.
And you're testifying under oath, are you not?
Yes.
Mr. Ely, if we can move down just a little bit more, thank you. Again, I'm reading here with respect to the Mullen number, I don't know what that is. I guess it's I-22A. On July 26th, I noticed a stain on the ball valve that appears to be coming from the bushing, seeping from the ball valve. Is that still your testimony today? That you intended to write that as a result of your inspection on July 26th?
Yes, sir.
Mr. Ely, if you could go to the photographs of those wells for me, please. Of that well, that last one. Yes, that's it. Thank you very much. So if I understand your testimony correctly, and I don't want to put words in your mouth, I just want you to, you're the one testifying here, that if we look at the T with the nipple that heads down into the bushing, and then the bushing connects into what appears to be the top of a ball valve. Am I right?
Correct.
And the question was, how in the world can you possibly tell whether a ball valve's open or shut if the stem's on there? Do you remember that question?
Correct.
Tell
Yes,
me how
sir.
you can't tell me how you can tell whether it's open or closed with the handle being missing.
And I don't know the correct terminology of it, but where the handle pops onto that open and close the ball valve, you can see if it's, perpendicular or if it's shut in, like if you would have with the ball, or if you had the handle on it, you can visually see it. And if the ball valve if the handle gets broke off, I know sometimes some of these leases, not this particular lease, you know, there's cattle that rub on them and break them off. And a lot, I know we used to, when I used to work, we would take some of them off to help prevent that, you know, and cause a leak or something. But you can still visually see with the angle of that, if the ball valve is open or not, and you can still take a crescent wrench or you know, another type of wrench and open and close that valve, even though the handle is not on there at that time.
Is that part that the valve connects to called the stem?
I believe so. I'm not 100%, but I believe so.
Let's take a wild guess. It may be that. So what you're saying, if I understand your testimony, is that below the T here, we have what looks like kind of oil on the nipple, and around where the nipple connects to the bushing, below the bushing where it connects to the ball valve, and then it kind of runs on down to the swedge. It's down below that connects onto the wellhead. Is that right?
Correct.
And so the question was, where did the oil come from? Where do you think the oil came from?
It would appear to me that it came from the lead line coming into that T and then going down, injecting into the wellhead.
It'd be a constituent of the fluid level that's primarily water that comes from the water tank, because the separation system in the water tank is less than perfect. Is that pretty close?
Yes.
Mr. Ely, if we could go up a couple of photographs for me. Yeah, just go back to that. Yes, right there. Thank you, sir. That one's fine. No, up, back. Yes, that one right there. That one right there. Down where I can read the narrative a little bit more, if I could. And then was there a subsequent photograph of this one taken on the 26th? On down one more, please. Is that the same well, Mr. Boyer?
Could you go back up, or is that you're talking about?
That's E43.
That's the I-43 there.
I-43. Okay. Well, you were asked. Go down to the one just below this. Thank you, Mr. Ely. Yeah, I think you were quizzed pretty extensively by Mr. Ely about whether or not your photographs captured drips, which would have evidenced maybe some water in those lead lines. You remember that?
Yes, I do.
And I think you had indicated that basically from the photographic evidence you had here, you really couldn't see that very well, if at all. Is that correct?
Correct.
Although I think, as I recall your testimony, you thought that there could be some residue of water on the ground that could evidence some leak, minor leak somewhere. You remember that?
Correct. Yep.
And you made all that testimony under oath, did you not?
Yes.
Okay. Mr. Ely, I appreciate your help. We can drop the screen share. Thank you. Okay, Mr. Boyer, let's talk for just a little bit about the inspections that you were a part of performing in January of this year, of 23. As I think you testified that you inspected, I think, 4 leases that were in Crawford County incidental to this rather large-scale inspection effort. Is that correct?
I believe so, yes.
Okay. Have you been back to this lease subsequent to January?
The Mullen lease?
Yeah, the leases that were, the leases, these 4 leases that you inspected in January of 23. Have you been back to those leases subsequent to the inspection you performed in January?
Some of them I have, some of them I have not.
And what did you find when you returned? Was it pretty much in the same condition as it was in January?
Yes.
And roughly when was that?
I don't have a recollection of that for sure, and I don't think I have any records of that exactly. I've been doing other day-to-day activities at times too, so.
Sorry about the rather disjointed nature of this, but there's a lot of disparate parts here. Going back to these two of these wells that were subject to this 3087 order here for unauthorized injection, in particular the Gail Mullen 143 and the Gail Mullen E43. Those are the two where you said you could feel the lines and they felt cool to the touch. Could you hear the check valve?
I could not at the time.
Yeah, some check valves are tougher to hear than others. If it's got a flapper in there, you can hear that sometimes. If different, and there's different valves, you can't. I was just curious about that. Well, Mr. Boyer, I appreciate your testimony. I think for now that concludes my cross-examination.
Thank you.
Thank you, Commissioner Keene. Commissioner Keith, are any questions for this witness?
Not at this time. I was curious about whether or not he had visited the wells after the 26th July date, and he answered that question, so I'm good to go. Thanks.
Thank you. Well, before we let you down, I just want to clarify one thing, Mr. Boyer. So it's on that last item you were talking to Commissioner Keene about on page 5 of your direct testimony. You talked about your observations of the 5 wells, I think 5 wells, injection wells, and you indicated that the wells were hooked up with check valves indicating the flow of fluids towards the well heads of the subject wells. And when you make that statement, you're talking about all 5 of the wells?
Correct.
All 4 of the Gail Mullen and the 1 Underwood, correct?
Correct.
But then you say only with respect to the Gail Mullen E43 and I43 did you make the observation that the lines were cool to the touch. Is that correct?
Just on those two, yes.
Did
believe if
Did you check the other ones, or is this just an indication that those were the only 2 you checked and they were the only 2 that were cool?
Those were the only 2 that I had checked at that time.
Okay. So we just don't know on the others because you didn't check.
Correct.
Okay. All right. I think that's the only clarification I wanted to make. With that, I believe we are ready for redirect, Mr. Kimbrell.
Thank you. Brad, who typically tells you which leases to go out and inspect?
Usually comes from one of the program managers.
Usually is Ryan. Is Ryan
typically?
Sorry,
yes, sir. That's okay.
I apologize. Ryan Dueling, is he one of the individuals who typically tells you to go out and inspect certain leases?
Yes.
Does he occasionally send you back out to reinspect a lease?
Yes.
Did he do anything out of the usual, out of the ordinary with respect to these Gail Mullen and Underwood leases?
No.
Okay. If you were to hook up a well for an injection, is there any other uses you could put that well to?
No.
So if a well is hooked up for injection, the only use that well could be put to is injecting fluids?
Correct.
So the way an injection well is constructed, there's no windows, right? You can't actually see the water flowing into the well. Is that correct?
Correct.
So in order to determine if there is water flowing through that, would you have to look at additional information other than visual?
Yes.
So just to clarify a bit, for that Gail Mullen I-43 well, you testified that you weren't able to take a picture of the drip. Were you able to observe the drip visually when you were on the lease?
Yes.
And I believe you testified that there was a puddle next to the well.
Yes.
And when you were inspecting this well, do you recall any rain that had recently occurred?
I do not.
When you are filling out a field report, do you typically add all the information that you learned about a well into that additional information box?
I'm sorry, could you repeat that?
Yeah, let me pull up. Okay, so as we've discussed at great length, you have information regarding the wells here. Is that correct?
Correct.
And then you have pictures of the wells, and then below that you have a box that says additional information. When you are
Yes.
filling out a typical lease, a typical field report, do you typically put all of the information you learned about the well into that additional information box?
No.
Is that just additional information that you put into that box?
Correct.
Okay. Let's see, I'll stop the screen share. The Gail Mullen C43 well, you testified that you couldn't take a picture showing the spray of free fluids. Did you visually observe a spray of free fluids at that well?
Yes.
And I'm going to share my screen again. And I believe Commissioner Keene delved into this a bit, but I just wanted to clarify. So these are the KGS records that we've discussed before. Do these show sales or production on the lease?
Production.
So as Commissioner Keene indicated, is this information that is reported to the Kansas Department of Revenue?
Yes.
And do you know who reports that to the Kansas Department of Revenue?
I'm not for sure.
Okay. And do they report that when there's a sale or when oil has been produced? Do you know?
Believe just when there's been a sale.
Okay. So is it possible that after 2021, oil had been produced on this lease, but it just wasn't reported as a sale to the Kansas Department of Revenue?
Yes.
So is it possible that there's been oil produced on this lease after 2021?
Yes.
I'm going to move over to this spill report that you talked a bit about. It indicates on the spill report that a valve broke. Do you remember what the valve was that broke?
I do not.
Okay. When a valve breaks, does it lead to a large release of water or does it lead to a small trickle of water typically?
It just depends on sometimes the crack, if it's not very big, or but it can vary.
All right. So is it possible that this well was an active injection well, but the valve breaking only released a small amount of salt water?
Correct.
Okay. So the valve broke and salt water was released, and I believe you testified that it's possible that that could have come from static fluid in the injection line. Do you recall that as your testimony?
I do.
Why would there be static fluid in an injection line if the well wasn't being used as an injection well?
Yeah, there would be no no reason for, as I know.
So just to clarify, if there's static fluid in the injection line, then the well most likely was being used as an injection well.
Most likely, yes.
Okay. Stop my screen share. So you went to the wells, the leases on July 13th and 14th. Why did you add additional information when you went back on July 26th?
There was some more details and more information that I saw and that I wanted to record and add to my field report that I had not, previously seen on the first inspection.
Okay. And did Ryan Dueling tell you you need to add more information on July 26th?
No, he did not.
Okay. When you inspected these wells on July 13th and 14th, were they in violation of commission regulations by being unauthorized injection wells?
Yes.
And did that change when you went back on July 26th?
No.
So all you did was add additional information on July 26th, is that correct?
Correct.
Okay. I believe that's the end of my questions at this point. Thank you.
All right, thank you, Mr. Kimbrell. We had a good amount of commissioner questions, so let me ask, Mr. Ely, do you need to do any recross?
I would like to, please.
Okay, go ahead.
First thing, though, Mr. Schlatter reminded me, Chair French, Commissioner Keen, I was mixing up your names, so I do apologize earlier.
No worries, it happens.
Mr. Bohr, you testified when Commissioner Keen was asking you questions that there could potentially be condensation on lines if water was going through them. Did you see any condensation on these lines?
I think I don't recall. I don't know that it's in my field report, but I really honestly can't recall at this point in time. I don't want to say that it did and didn't. I don't recall.
We've talked a bit about these KGS records and production versus sales. I'm going to pull that up again if you entertain me for a moment here. Mr. Bohr, can you see the KGS sales production record that I pulled up?
Yes, I can.
And if I go up to the top here, it says production. That's this third column, is that right?
Correct.
What's the last number for March of 2021?
2.28, I believe, is what that says.
Is that 2.28 barrels?
I believe so. You might have to. I believe that's it. Scroll back up and see. It just says production, so I would assume that it would be barrels, but I don't know that for sure.
Is this acronym at the top here, this BBLS, does that stand for barrels?
I believe so, yes.
Okay. So is it fair to say that that was 2.28 barrels
I would say so.
for the entire lease?
I believe that's how, yeah, they go off by the entire lease. I don't believe that they go off individual. Yeah.
In your experience, is 2.28 barrels in a month for an entire lease a lot?
No.
Looks like there wasn't a lot of production even when they were reporting.
Right, correct.
Is it feasible that production ceased, coinciding when reported sales ceased?
It's a possibility, I would say.
This last column here, what's the title of this last column?
I believe it says reporter or purchaser / reporting customer, looks like.
Is that the party who reports this information?
No, that's who purchased the oil. Or
But the
purchased.
purchaser of the oil would report this information, correct?
I'm sorry, what's that?
The party listed in this column who purchased the oil would be the one reporting this information, correct?
I'm not 100. I would assume so. I'm not 100% sure, but I would.
It says reporting or purchaser / reporting customer.
I would. Yes. Yes, it does.
Is it fair to assume that they would be the party reporting this information?
Yeah, I would say so.
So operator has no ability to withhold that reporting on behalf of McClaskey, does it?
Not to my knowledge.
Objection. That's outside of Mr. Borst's expertise.
I'll withdraw the question. Mr. Boer, are you aware of any evidence of continued production after March 2021?
I am not of any continued. Is that what you said?
Are you aware of any production?
No.
Any production at all on this Underwood 6 lease?
I am not.
For there to be production, the wells have to be pumping. Is that correct?
Well, yes, yes, correct.
I'm sorry, I interrupted you. Go ahead, finish your statement.
I'm not for sure actually where I was. I don't know if I had anything to say. I think I might have been trying to repeat the answer or repeat the question. I kind of had a little bit of a glitch there, I think.
Okay, yeah, you froze on my screen. Let me rephrase the question here. You have been out to the Underwood 6 lease multiple times, correct?
Correct.
At least in July 2022 and at least in January 2023, right?
Yes.
Have you ever seen wells pumping when you've gone out to this lease?
On the Underwood 6, to my recollection, I do not believe I've saw a well pumping at the time.
Mr. Boer, I'm going to show you your field reports again. This is the main page of the report, correct?
It looks like, yes.
This is the second page of the report. This is where you put the bulk of the information that you find. Is that correct?
Correct.
And then we've kind of discussed the photos in the additional information paragraph. When do you compile all this information on these first 2 pages? At what stage of the inspection process do you do that?
That's a very good question. It just depends. Like it takes a while. I don't know that it would take a day, you can get it all done in one day. It takes a little time to get everything.
I'm sorry, I didn't mean to interrupt you again. Keep going.
Oh, no, go ahead.
Okay. Is it fair to say that this is the last thing that you do?
As far as putting the additional findings in and this report or what we're looking at right here is the last thing I do.
Preparing page 1 and page 2 of this, is that the last thing you do when you conduct an inspection?
Usually when I start my report, I usually start, everybody does a little bit differently. I usually start with those first, and then, then we have to do the word photo templates, separately too. And, it's just a lot of information and different processes to get everything all put together.
I see here in this report that you reference certain dates. You reference July 26, 2022 in this first paragraph about the Gail Mullen I-43. Is that correct?
Mm-hmm.
So you couldn't have prepared that paragraph before July 26, could you?
You're talking about where it says on July 26th. Is that if I'm understanding the question right?
You couldn't have prepared that before July 26, could you?
No.
Oh. Is it fair to say that significant portions of this page here were prepared on or after July 26th, 2022?
On that they were prepared on
or after?
Yes, on or after, yes.
No, we can't tell just by looking at this report what you put in there before July 26, can we?
Not to my knowledge, no.
When Mr. Kimbrell was asking you questions, you stated that you went back out to the Gail Mullen leases and the Underwood 6 leases because, and if I'm misquoting you, please let me know. You went back out because you saw more that you wanted to put in your report. Am I summarizing your testimony accurately?
I don't quite recall. I just, as far as the additional findings, why there was more information, I saw more findings, and that's why there was more information on the second date than there was on the first.
When did you decide or discover that you saw more? When did that occur?
When I was there on the 26th, I saw that especially, I don't remember what well it was. If we could, the one with the free fluids, I saw that wasn't there, the original time I was there on the first time.
Okay, I guess I'm confused here. You saw more on the 26th when you went back out, but then why did you go back out on the 26th?
Could you say that again?
Well, you said you testified that you saw more when you went back out on the 26th, and you wanted to put that in your report.
Mm-hmm.
But you couldn't have seen more on the 26th until you went out there. Is that correct?
Right. Yeah, I would not have seen anything more until I arrived.
So why did you go back out there?
I honestly, at this time, I cannot remember why I did. I'll be completely honest. I don't remember why I did.
Okay. Mr. Boer, in your experience, have you witnessed people removing fluid from lines before?
As removing fluids from lines?
In situations of injection wells like these that have fluid in the lines, when they're not operating, have you witnessed people remove the fluid from the lines?
Move the fluid from the lines?
Well, how does the fluid get out
itself
of the lines then? Let me rephrase the question. How does the fluid get out of the lines when you just turn it off, when you stop injecting?
Well, you would have to, open a valve to release the pressure.
So if you don't open a valve, there's still fluid in a line, even though it's not injected.
Yeah, I mean, there could be, yes.
Okay. I have no further questions.
All right, thank you. Well, I think we're gonna give one more opportunity if there's any follow-ups from commissioners here. Commissioner Keen.
Thank you, Mr. Chair. With your indulgence, and I'll try to be quick again. Mr. Ely, if you would help me with the screen share, let's go back to the KGS. We're going to beat that one to death just one more time. And I promise I'll be brief. Okay, here we go. Here we go. The far right-hand column, Mr. Boyer says Kelly L. McClaskey Oil. Are you familiar with who that is? Do you know who that is?
I've heard the name. Yes, Trimble McClaskey.
And what does that company do?
They have oil leases themselves. They produce oil as well as buy oil.
They primarily buy oil, don't they? Aren't they an oil purchaser? Pretty good sized oil purchaser in eastern Kansas.
Pretty good as far as what I know.
Okay. Were they not? They were the first purchaser for Ace Energy, were they not? From, it looks like, what was it? February of 2020 through what this chart shows would be March of 2021. They were the first purchaser, right?
Correct.
Okay. Do you think they care what the daily production is? You think the the oil purchaser, are they going to care what the daily production is?
To my knowledge, no.
Why not?
They're just there to get the oil. I mean, it's not their responsibility. I mean,
not their job, right?
Yeah.
Okay. So, and here, it's incredible. I mean, you look at this number and you're thinking, my gosh, did they actually bring a semi or even a bobtail? Did they actually bring a truck out there to pick up 2.28 barrels in March? That's a great question. Now you're a gas guy from your past experience. I get that. On the oil side, are you familiar with the term split load? Does that mean anything to you? Split load.
I have heard the term. Yes.
What does it mean? Do you know?
I'll be honest with you. I'm not sure.
It means the circumstances when they first purchaser will purchase less than a full load that the truck he brings out there can contain. That's what it means. What a patient first purchaser Kelly McClaskey is to go out to this lease, take the time and effort it took to go out there and pick up 2.38 barrels, because McClaskey will do split loads. They will pick up from individual leases less than a full load. There are other first purchasers who won't do that. Coffeyville Resources will not do split loads in some parts of the state. They just simply won't do. They can't afford to. Okay, enough of that. Move on. Let's go back to, if you would, Mr. Ely, let's go back to that page 2 of 11 again on Exhibit A. I'll be very brief. Okay, tell us, Mr. Boyer, when you prepare to prepare this kind of a document with these findings on here, and when you're out in the field, do you make any kind of handwritten or notes on your computer to yourself so you can subsequently go back and compile this sort of a presentation?
Yes.
And why do you do that?
It's, a lot of information. Just want to be sure to get all the accurate information, get everything that, that I saw, and have a backup just in case of, computer failure, just to have it as a backup, basically.
So you can kind of remember pertinent information. Is that close? And then later compile it when you have the time to reflect upon putting all your notes together, and that's how you come up with this document. Is that a close guess?
Yeah, correct. Yes, I'd say so.
No further questions. Thank you.
All right. Thank you, Commissioner Keene. Commissioner Keith, are any questions?
Just one, if I'm recalling correctly, Mr. Boyer, I thought you said in your testimony that you went out to revisit these wells on the 26th at the request of Ryan Dueling. Is that correct?
I'll be honest, I'm not sure if I said that or not. I can't remember.
Okay. Well, I do believe you did, because
okay.
Different answer towards the end of your testimony. I thought I heard you say that. We'll have a record to look at. Thank you.
Thank you.
I do not have any additional questions. Mr. Kimbrell, do you need to do any final recross? If you do, I'd ask you to be brief.
Yeah, just very, very briefly. So Mr. Boyer, we were talking about the KGS records, and it said 2.28 barrels in March 2021. Were the injection wells, the unauthorized injection wells that you found, were they hooked up as EOR wells?
Yes.
And what is an EOR?
Is an enhanced oil recovery well.
And what does an EOR do?
It helps to get more production out of the oil then.
Okay. And before you went out to the Underwood lease, did you happen to look at Ace Energy's well inventory regarding that lease?
I don't remember if I did or not. I don't remember. I'd have to look it up on the field report if it was on the field report or not. I don't remember.
Do you remember if Ace Energy had listed any of their wells on that lease as producing wells?
I don't. I don't remember if they. I think they did, but I'm not 100% sure off the top of my head.
But thank you. I have no further questions.
All right, thank you, Mr. Kimbrell. At this time, I'm going to release the witness. Mr. Boyer, you may step down virtually. We've got 35 minutes left before my very hard stop at 5 o'clock. At this point, I think what I'd like to do is ask the parties for some guidance. We've got Dwayne Sims up next. I don't know if that's Mr. Ely or Mr. Schlatter that's taking the lead with Mr. Sims, but I think my question to you is, if it's a hard stop at 5, like I'm going to cut you off mid-question, is it worth getting started with Mr. Sims? Could we make material headway in your examination, or would it be unproductive to start this witness right now?
Chair French, I will be the one conducting the cross-examination of Mr. Sims. I don't have a ton of questions for him. I'm optimistic that we can get done by 5, but I will be honest, I think it might be cutting it close.
Well, I think with that representation, if we can make good headway, I will ask you to do that because we've got an awful lot of witnesses left to go. Otherwise, I'm going to be putting pressure on everybody tomorrow, and I don't want to do that. Let's get as far as we can. Staff, why don't you call your next witness?
Staff calls Dwayne Sims.
I am not seeing Mr. Sims on my Zoom.
I'm
Do you
afraid
know?
with YouTube, there's a bit of delay, so they might not realize that he's been called in. I'll go outside and check.
Okay, we will stand in recess briefly. Okay, I see Todd Bryant has popped up here. Oh, here we go. Could we get, I don't know who has permission to change the name on the Zoom, but could we get it changed? There we go. We've got Dwayne. Do we have everybody back here? Okay, I see Mr. Ely, see Mr. Kimbrell, and I've got 2 other commissioners, that's all I need. All right.
Thank you.
Mr. Sims, can you please raise your right hand for me? Do you swear or affirm that the testimony you give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Mr. Kimbrell?
Thank you. Mr. Sims, could you please state your full name for the record?
Dwayne Allen Sims.
By whom are you employed?
The Conservation Division of the Kansas Corporation Commission out of Chanute, Kansas.
And what is your work address?
137 East 21st Street, Chanute, Kansas.
What is your work title?
District 3 UIC Coordinator / Environmental Compliance Regulatory Specialist.
Are you a member of technical staff?
Yes.
Are you the same Dwayne Sims who caused to be filed in this docket rebuttal testimony consisting of 6 pages and 1 exhibit?
Yes.
Was this testimony created by you or at your direction?
Yes.
Now that you are under oath, do you have any corrections to make to your testimony?
No.
If I asked you today the same questions contained in your testimony, would your answers be the same?
Yes.
Do you swear the answers contained in your pre-filed rebuttal testimony were and are true to the best of your knowledge?
Yes.
Thank you. At this time, I move for the admission of Dwayne Sims' pre-filed rebuttal testimony to the formal record.
Any objection?
No objection.
Hearing none, the reference testimony will be admitted.
I'm sorry, Chair French, subject to the same objections that we previously lodged. I apologize.
All right. Yeah, I couldn't remember if you had, did you had objections to, or was Mr. Sims' testimony referenced in the motion to strike?
I don't believe it was, but I can't recall with 100% accuracy. So,
well, we will just note your continuing objection for anything within the motion to strike, but Mr. Sims' testimony will be admitted. Mr. Kimbrell, you have tendered the witness for cross?
Yes, I have. Thank you.
Okay, thank you. The witness is yours, Mr. Ely.
thank you, Chair French. Mr. Sims, my name is Jackson Ely. I represent the operator in this proceeding. I'm going to ask you a few questions about your previous testimony and some other matters, okay?
Okay.
Have you had many interactions with Jonathan Frieden?
As far as what?
Have you had many interactions with him? Generally.
I've had one phone conversation with him about this matter. I've had some since this matter. And I've had some email communications with him, yes.
Fair to say that you've interacted with him to some degree of frequency?
Not frequency.
But you have interacted?
Yes.
Mr. Sims, I am going to pull up your pre-filed testimony. Can you see that on the screen?
Yes, and I have it in front of me too.
Excellent, excellent. Good. We'll work through this together here. I'm going to go down here to page 3, lines 17 through 22 generally.
Okay.
You were asked if you harbor hostile animus toward Mr. Frieden. Do you recall that question?
I do recall that question, or that statement anyway.
Okay.
Yes, and the question.
And you testified that starting at line 20, unfortunately, Mr. Frieden has a tendency to get irritated, which occasionally leads to rather tense interactions. Did you say that?
He always contradicts. If you tell him something, he's always got an answer that conflicts what you are trying to tell him is going on the lease. The longer you talk to him about it, the more irritated he gets, and before long he's mad at you, and then that's when that's why we, after our phone conversation, we always followed up with an email.
Okay. You enjoy your interactions with Mr. Frieden?
Oh, it's part of my job.
Is that answer no, then, that you don't enjoy your interactions with Mr. Frieden?
They're not my favorite interactions. You're right.
Is it fair to say that you do not like Mr. Frieden?
No, I have no preference of whether I like him or dislike him.
I'm going to go to page 4 of your testimony. The answer is kind of long, and for the sake of the commission's time here, I'm going to just try to shorten it up. There was some discrepancy as to when certain phone calls between you and Mr. Frieden occurred. Is that correct?
That is correct.
And you testified that you found in your phone records that you called him on August 17, 2022 at 9:04 a.m. and you did not reach him. Is that correct?
That is correct.
And then he returned your phone call at 9:06 the same day.
That is correct.
2 minutes later.
Yes, sir.
Okay. And your phone call lasted for 10 minutes.
Yes, sir.
Okay. You also stated, let's see here. For the sake of time, I'm not going to search for it. I'm going to ask to see if you recall making this statement generally. Did you state at some point that you looked through your phone records and you don't have record of speaking with Mr. Frieden on July 16th, 2022? Oh, it's right there at the top.
Yes, I did.
Okay.
Line 5.
You keep pretty accurate phone records, don't you?
All cell phones come with accurate phone records. All you have to do is look back and see when the phone records were made or the phone calls were made.
So these records are coming from your personal cell phone?
Nope, my work phone.
Okay.
We don't call people on our personal phones.
So you have a work phone that has a log of your phone calls to Mr. Frieden?
Yes, sir.
Okay. Are you aware that prior to this hearing, operator requested that all staff's phone records with operator be produced?
I'm not aware of that, no, but I'm not surprised by it.
Are you aware that your phone records, which you just testified to, were not produced to operator?
I'm not aware of that.
Did anyone ask you for these phone records?
I don't think they asked me for them, no.
And you have no knowledge of turning these phone records over to operator or to another member of staff for the purposes of them turning it over to operator, do you?
I know I've looked through them several times, who I have given to. I mean, this was over a year ago. Who I've given to and not given to, I do not recall that, no.
So what evidence do we have other than your testimony here that corroborates these phone records?
Well, for one thing, I'm under oath and I do not lie.
But is it fair to say that operator has never been given this phone records?
I'm not arguing that. No, I agree. If you don't have them, I guess they were never given to you.
Okay. This phone call that you had with Mr. Frieden, during that phone call, did you instruct Mr. Frieden that he had to MIT certain wells?
No, I did not. I mean, directly instruct or in order to obtain a authorization to objection. That's a leading question. So I guess, could you restate that?
In a phone call with Mr. Frieden, did you ever convey to him that he had to MIT wells?
To obtain authorization, I may have. I mean, I did not write word for word down on this conversation. I may have told him in order to obtain an authorization for these 5 wells that he had to do a MIT before the authorization be written. Yes. That's
You
not
said
an
you may have told him that. Did you or did you not tell him that?
I told you I did not know and did not remember that.
Okay. Do you recall Mr. Frieden ever asking you on one of your phone calls why the KCC didn't MIT any of their orphan injection wells?
No, I don't remember that at all.
You have no recollection of Mr. Frieden making that statement?
In this phone call or which one? Because this is
In
the
any
only
phone
one.
call.
This is the only phone call I had with him that I can recall until after these proceedings.
Unfortunately, I don't feel like my question is answered, so I'm going to have to ask it again. Did Mr. Frieden make that statement to you in any phone call?
I do not recall.
Do you recall if Mr. Frieden ever stated to you during any of your phone calls that he could report the KCC's failure to MIT its orphan injection wells to the EPA, and that the KCC would lose EPA primacy if the EPA found out the KCC was violating the law? Was that statement ever made to you by Mr. Frieden in any of your phone calls?
No, it was not.
Do you believe your actions have been retaliating against Mr. Frieden because of any statements he's made during any phone calls that you've had with him?
Objection, argumentative.
Chair French, this goes directly to operators' defense theory of retaliation and arbitrary conduct. I think it's fair to ask if he if Mr. Sims believes that he's been retaliating or not. It's a simple question.
The only reason I'm waffling is I'm wondering what probative value it has to Mr. Sims' opinion of whether he's retaliating. I guess I will let you ask it, and he can give you whatever answer he wants.
Mr. Sims, do you believe your conduct has been retaliating against Mr. Frieden because of any statements he's made to you during any phone calls you've had with him?
No, I do not.
Have you ever encouraged other members of staff to retaliate against Mr. Frieden because of any statements he made to you during his phone calls?
No, I have not.
You are the UIC program manager for the KCC, is that correct?
UIC coordinator, yes.
And you've testified in your pre-file testimony kind of the extent of your job duties, is that correct?
Yes, sir.
And that involves overseeing the KCC's wells, right?
The UIC wells, yes.
Do you believe that your job would be impacted if the KCC lost its EPA primacy?
No, I do not.
Has that ever been a concern for you, losing EPA primacy?
Never even thought about it until you just brought it up.
I'm going to go to page 5 of your pre-filed testimony.
Okay.
On lines 9 through 13, you were asked, Mr. Frieden claimed that you and Ryan Dueling told representatives of operator that ACE needs to get out of the business. Things to that effect. Do you have any recollection to those statements?
That's never been out of my mouth, or I've never heard it come out of Ryan's.
Okay. That answers my question. I have no further questions for Mr. Sims.
All right, thank you. At this time, we'll go to commissioner questions, and Commissioner Keen, I'll let you go first.
All right, thank you very much. Good afternoon, Mr. Sims.
Good afternoon, Mr. Keen.
I just have one question for you, Dwayne. I'm looking at page 4 of your rebuttal testimony. We need not bring it up. I'll quote it into the record. Here's what your rebuttal testimony is as it appears on lines 18 through 20. This is with reference to a phone conversation I believe that you had with Mr. Frieden, the one to which you've made reference. And the quote from your testimony, beginning on 18 through line 20, is, Mr. Frieden also kept trying to tell me that the Mullen number I-22A, and then you give the API number there, was an authorized injection well because it was listed as an enhanced recovery EOR well on his well inventory. Do you remember that conversation with Mr. Frieden?
Yes, I do. And it's also documented in my email with him.
For the benefit of the commission, can you elaborate on what you understood to be his rationale for having that conclusion?
Mr. Frieden kept trying to tell me that just because he intended that well as an EOR well, and that he drilled that well as an EOR well, that he could use it as an EOR well. And I kept trying to tell him that no, just because you intend it as an EOR well does not mean that you can use it as an EOR well. That you have to file an application for the well, you have to obtain an application for the well, and in order to do that, you have to do a case during MIT. And I'm sure that's where that question from Mr. Ely come from.
Okay, so I kind of see this as a kind of a two-tiered thought process here. And that would be, and I don't mean to paraphrase you incorrectly. So, and I know you're not going to be shy about correcting me if I'm wrong. essentially the contention was, as you understood it from Mr. Frieden, and I'll ask him too, was that if you put down on the drill intent that you intend to use the well for EOR purposes, and then subsequently show it for the same purpose on the well inventory, that means that it's therefore an EOR well? Was that your understanding of his contention?
That was my understanding, what he was trying to tell me, yes.
All right, thank you. I have no further questions. Thank you.
Commissioner Keither, any questions for Mr. Sims?
Not at this time.
I guess I just have a follow-on to Commissioner Keen's questioning, because I'm trying to look at this testimony while we're talking here, but it's not clear to me. You say here that for 4 of the injection wells, Mr. Frieden said that they were not set up for injection, and he was not injecting. But for that last well, the Mullen I-22A, you said that he was contending that he was authorized for injection. Was he simply saying he was authorized for injection, or was he also saying he was injecting and that injection was authorized?
I took it as he was injecting and that he was authorized, is what he believed, just because it was listed as an EOR well on his inventory.
Okay, and we can follow up with him as well. I just wanted to make sure I was understanding clearly, what you believed your conversation was with him. So I believe that's the only clarifying question I had. Mr. Kimbrell, any redirect?
Yeah, briefly. On the phone records, Dwayne, can you describe what exactly that was, the phone record?
You mean as far as like my Verizon bill?
Yeah, so it was a Verizon bill.
It was our bill that we pay our bills. There are phone record, the KCC pays our phone records off of.
And did it list the phone numbers?
Yes, sir.
Did it list the individual who was calling?
No, it did not.
All right. When you were speaking with Mr. Frieden, was it on his cell phone?
I do believe that's his cell phone number. He has so many numbers that we can't get a hold of him. Half the time, he changes numbers a lot. So
Mr. Frieden would have those exact same records in his possession.
Yes.
Regarding the call times. And on these phone records, you didn't take any notes regarding any calls, did you?
As far as no, I did not take notes.
Okay, it was just the list of the numbers. I just wanted to clarify.
Yes.
Okay.
Yes, just a list of the numbers.
All right. I have no further questions.
Well, we've got 12 minutes left. Mr. Ely, anything in particular that you need to recross about? We didn't cover a lot of new ground there.
I have 2 very, very small issues.
Right.
If
you're quick, go ahead.
Okay. Mr. Sims, I brought your testimony back up. Can you see that?
Yes, sir.
I'm going to go down to near the bottom of page 4. This is when we were talking about Mr. Frieden telling you about the Mullen I-22A. You testified that Mr. Frieden kept telling you that it was an authorized injection well. Is that correct?
That's what I believe he was telling me, yes.
And then just a moment ago, you testified that you assumed that meant he was injecting. Is that right?
Yeah. Yes. From his attitude about it, he was using it as an EOR well, yes, injecting.
From his attitude, how are you able to determine that there was actually fluid being injected in the well?
Because he told me he was using it because it was an EOR well. It was authorized.
Well, hold on, Mr. Sims. Did he tell you he was using it, or did he tell you that he was authorized as an injection well?
Probably it was authorized. We can look at the emails and see what it says. It's followed up in there. Right there.
What does he say it is?
After reviewing my well inventory, the well I-22, which he left the A off, API number 15037222385 is, in capital letters, unauthorized EOR. Thanks in advance for reviewing your notes and confirming with me the accurate status of this well.
Did Mr. Frieden tell you that he was injecting into the well?
No, he did not.
He just told you it was authorized, correct?
Yes, but when we elaborate on that or stop there?
No.
Thank you.
Mr. Sims, on these work phones, this is the first time I've heard about KCC work phones.
Well,
Are you aware of who generally gets these?
what do you mean who generally gets them? Everybody works at KCC.
To your knowledge, do all KCC employees get work phones?
All field staff get cell phones. All office staff has a hard line, yes.
All office staff gets work phones as well.
Office lines, yes. I don't know about phone records to office lines, but I do know that cell phones have.
Okay. I had no further questions.
All right, thank you. Commissioners, any very quick follow-ups? I'm seeing shaking heads. Mr. Kimbrell, any very quick redirect?
No, I'm good. Thank you.
All right, we've finished a little early. I appreciate everybody's cooperation. Mr. Schlatter, I see you've got, well, let me dismiss the witness real quick. Mr. Sims, you may step down virtually. Thank you for your testimony. Mr. Schlatter, I see you have gone off of mute. Do you have something to address with us?
I do, and I can't believe you perceived that because I wouldn't have. Maybe it was me going like this. I don't know. I have a matter that I would like to call before the commission and a proffer of evidence, just on a kind of a real brief, discrete matter. This may not be fair to Ms. Borst because she's no longer on the line, but during her testimony, she, and I noticed that I was caught a little off guard by some of her testimony because for the first time she testified that the reason that she held Ace Energy's license was because Ace Energy did not submit rig tags with its application, and that because Ace Energy was listed as a contract operator on SX54's application. That obviously caught me off guard because it's the first I'd ever heard of it, both through pre-filed and direct testimony. But I followed up with Mr. Frieden on that because I'd never heard of it. He furnished me with correspondence showing that Ms. Borst was furnished with the information she requested on the next day. And she testified that she never received it and still hasn't to this date. So I would like to proffer that email into the record since she's now gone. This could not have been discovered ahead of this hearing.
And I've objected that. I think we need to call Ms. Borst back in to testify if we're going to be talking about some email.
Mr. Schlatter, is this an email between Mr. Frieden and Ms. Borst?
Yes, it is.
Would you be willing to introduce it during Mr. Frieden's testimony tomorrow?
If I may.
We'll allow it.
Okay, thank you. The only other thing is we've come across some what appears to be withholding of relevant discovery. I'd maybe suggest we take that up as a post-hearing matter since it can't be cured on the fly.
And there was no withholding of discovery. We can take it up, but there certainly was no withholding of discovery.
I mean, you didn't furnish any of the records that your witnesses relied upon, and we asked for those phone records.
You didn't ask for that. You asked for phone logs. These are a list of phone numbers, and Mr. Frieden would have those as well.
Why would Mr. Frieden have staff's phone records?
He would have the times that the calls were made, which is only what Mr. Sims has.
I mean, this is an exercise in semantics. I'd just like to take up the issue. We can argue it.
The parties are certainly free to raise that issue in their brief, and we'll take it under advisement. So I just view your statement as a heads up. So that's certainly fine. All right, with that, we're still ending early. We will begin again tomorrow at, I think, John, are we set for 9 o'clock?
Yes.
All right. We are in recess and off the record right now, and we will begin tomorrow at 9 o'clock a.m. We'll see you all then.